One.
Good morning. Recognizing a quorum of commissioners, I call the July 27th, 2023 meeting of the Cannabis Control Commission to order. This meeting is being held remotely pursuant to Chapter 22 of the Acts of 2022 and is being recorded. Commissioners Camargo, Concepcion, Roy, Stebbins, and myself are participating in today's meeting. All votes taken today will be by roll call. We have a full agenda today, and I'll generally summarize. We'll start with opening comments from commissioners, then move into discussions on draft regulations regarding host community agreements, municipal equity, and marijuana establishment agent suitability. I anticipate this will be a live drafting session, and edits will be incorporated following the discussions in order to be voted on. I'll ask commissioners wishing to comment or ask questions during any part of the meeting to raise their hands to be recognized. With those initial comments, I'll turn things over to commissioners for any comments or updates. We'll go in alphabetical order, and we'll begin with Commissioner Camargo.
Good morning. Good morning. Thank you so much, fellow commissioners. It's good to see you all. I know it's muggy outside, so it's like a little uncomfortable, but I just want to say thank you to the commissioners who've worked on the drafts that we're going to see today. I mean, I'll make some more comments later, but I just want to say thank you. I know that this stuff is not easy. We put it out and it looks easy, but it's not. There's a whole, I call it an army and a team of staff and folks who make this stuff happen. So I just want to say thank you. I'm excited about today. And I hope that we also have patience with each other because I know there's a lot going on. So thank you.
Thank you, Commissioner Camargo. Commissioner Concepcion, who is joining us remotely.
I am. Good morning, everyone. Good morning to my fellow colleagues, to any members of the public who may join us. I am really excited for today. I think that, you know, we have a packed agenda, as you stated, Madam Chairwoman. And I'm really looking forward to the opportunity to really explain and go through our proposed regulations and the thought process behind them. I'm particularly looking forward to the conversation around suitability, and I'm happy that there's a good amount of attention being paid, but I also think that it's really timely. I know we were supposed to originally speak about this on Monday, last Monday, but it's good that there's been this opportunity for everyone to digest the information, and we can take advantage of this moment to really educate and promote some additional awareness. Thank you.
Thank you. Next, Commissioner Roy.
Thank you, Madam Chair, and good morning to all my colleagues. And Commissioner Concepcion, I hope you're feeling a little bit better. It's so nice to see you, even virtually. Again, as I've said in previous months, I just want to take this opportunity to thank. I had the honor to be on the regulatory lead along with Commissioner Concepcion on the host community agreements. And I just want to thank our team for all their hard work. And now we pivot to this next phase where we will go over a lot of questions today that have come up since we've released that first iteration, and happy to dive into all of those and look forward to voting on this policy and then opening it up to public comment and public hearing. So having said that, I'm ready to go. Thank you.
Thank you, Commissioner. Commissioner Stebbins.
Thank you, Chair. Just a couple updates from me. First of all, I had the opportunity to stop at our new dispensary, New Dia on Lansdowne Street on Saturday. Just kind of poked my head in, albeit wearing a Red Sox t-shirt and shorts, but as I went across the street to see the game afterwards. But great space. Really like the wall size, kind of Super Mario gaming wall, and a great array of products from licensees across the state. Commissioner Camargo and I hosted our virtual listening session and our second in-person listening session at Mass Bay last week. Great turnout for both. Want to thank members of our working group and team who showed up to help folks register, take notes throughout the meetings. We also had some members of our team, our collective team, who showed up sometimes just to be there and listen. So greatly appreciated. Our social consumption survey deadline was this past Monday, and we're working to pull that survey data results together and review them as a team. Finally, I'm speaking on a panel this Friday night in Cambridge at an event sponsored by Let's Talk Weed on the topic of social consumption. That's what I'm going to be doing on my Friday night. So looking forward to that, and also just extend my thanks to my colleagues in their working groups on the great work that they've been doing. And as everybody knows, with the open meeting law, this is kind of the first chance that we have to talk about the great work that they've done, but I'm excited to dig into this. This regulatory work for me really kind of translates into an overall competitiveness issue for this industry and how it's going to succeed in the near future. So I'm excited to talk through the results of my colleagues' work, and as Commissioner Concepcion said, kind of get to the meat of, how some of the decision making happens. So thank you.
Okay, thank you, Commissioner Stebbins. I also just join my fellow commissioners, thanking Commissioner Concepcion for being at the heart of the group, getting our particular work done on the regulatory rewrite. But particular thanks to Mike Baker, who is out on parental leave, who spent the entire 4th of July weekend making sure that a lot of these details got done, and especially also thanking Mercedes and Andrew, who are here, who are going to walk us through for leading us through a very difficult process. So we really thank you very much for that. I have no idea what I'm doing today, and so I look forward to your guidance, helping us walk through this. What we're hoping we do is have an opportunity to walk through. We won't go line by line, but we will sort of walk through this. If there are no questions, we'll move on. This is a fairly tedious process, but again, we're taking a tedious process and we're finishing it in a hopefully slightly less tedious way. But Andrew and Mercedes, if you can sort of help me kind of walk through this, so we're managing the conversation, so folks can either say yay or nay. And again, I don't think that there's a lot of disagreement right now. The only thing that I have that may actually change some things is I actually got some information back from the legislature about a particular line item that we were concerned that we had failed to address, and we'll get to that later. But I don't have too many comments and questions right now. So maybe we can just, if you can help me kind of walk through the first section that we're going to deal with, and you can turn us in that direction so we can walk through. There's so many pages here. So the first one is.
Sure, Madam Chair. And may I suggest the first section we will deal with is 0.002, which is definitions. And then as it relates to procedure for the board, you could review each of the red lines, and if there is consensus with the language, you can move on to the next topic. If there is not consensus, you may wish to take a vote. And if there is consensus, we could vote at the end as a single piece.
All right, thanks.
I just have a question.
Go ahead, please.
So Andrew, the questions that we got, Mercedes, and they're anonymized. Do we tackle these? How do we tackle these first?
I might suggest you tackle them when it comes up in the regulation, if it corresponds to a regulation, or is it a broader policy point?
There's both in here.
Why
So
don't you just raise an issue, and then we can, depending on how complicated you're making things, we can.
there's a lot of questions, so I don't want to miss if we are.
I wonder if, sorry, I know I'm speaking out of turn. I'll wait.
Oh, no.
Commissioner Concepcion.
Okay, so.
Thank you very much being here today. So
Just
yell.
miss being here too, especially now.
I know.
So what I'm wondering is, I know that it was, the identity of who asked the questions needed to be anonymous because we weren't in open meeting. But I wonder if now, as we're going through it, if there's a section that we come to and whoever raised the question can just bring it up as we're getting to the section, because I think it might get a little bit complicated otherwise.
Yeah. Okay. So let me just clarify. Do you want to go through those questions first?
Well, I can unanonymize myself because I was the last round of questions. Those were all me. There were 7 of them.
Well, I was thinking the opposite, and I was thinking in line with what Andrew was saying, kind of going through the full packet, going in order, and then
the
when
red lines.
Yeah,
Okay.
Yeah, because we'll get to that subsequent
Okay.
part. Again, my apologies to everybody. This is a little confusing.
it's new for all of us, Madam Chair.
Thank you.
It is.
And if I can point out, Commissioner Concepcion, you're totally missing the Barbie-licious look today. You looked at it going on with the hot pink and even the nails, so you are missing a treat today.
Barbie, into the commission.
Big Barbie.
I love it.
That's right.
Yeah.
I'm Cannabis Commissioner Barbie. All jokes aside, also, I'm sure I can speak for myself, but I have more questions than what I turned in. Obviously, I
Yes.
turned those in on Monday. We did more work
Right.
Tuesday and Wednesday, so obviously there's more
Yeah.
than what's on the paper.
Okay. Are you okay?
Yes, and I'm just going to respectfully ask Director Potvin to join us and Enforcement Counsel Rebecca Lopez, if you could join us on this section. Just keep your cameras on with us and hang with us, because I'm sure we're going to be deferring to you on a lot of this too. Thank you.
So if you can sort of help guide me and we can conduct this going forward. Thank you, Andrew and Ms. Davis.
Yes, Madam Chair. So the first edit would be under 002, gross annual sales.
So this is gross annual sales means the total revenue generated by the marijuana establishment or MTC under an individual license pertaining to the sale of marijuana, marijuana products, marijuana accessories, and marijuana establishment or MTC branded goods for the provision of services used by the commission to calculate limits under Mass General Law, Chapter 94D, Section 3, Sub D2, Romanet 1, regarding this community impact fee amount properly due and payable to the community. I assume that there are no questions or comments on that language?
There was a question.
Okay, go ahead.
The question was around branded goods. So I queried branded goods in our existing regs and it comes up 17 times, but there's no definition of branded goods in our glossary. So is that something we want to, that was a question that came up. So do we need to incorporate a definition of branded goods? And the question was, some people have branded goods with the name of their facility or but sometimes they have branded goods that are another brand. So, right, that was a question. So I guess my question would be to Kyle or Rebecca, do we need to define branded goods as
Can
a
I-
definition?
Can I add to that, Commissioner Roy? Because I think I asked that question.
Yeah,
And the reason I ask it is because we'll go down a little bit later in terms of community impact fees and gross sales. And when we talk about including everything into your bottom line, does branded goods, does it mean your branded goods? Or
Right.
does it mean I'm selling,
Barbie branded goods.
I'm selling a sneaker t-shirt, yeah, whatever.
Yeah.
Okay. Branded goods is, okay.
Oh, because I didn't see
Yes,
it last night.
it's under marijuana establishment branded goods.
Oh, I just put branded goods.
So then Commissioner Roy, then the second part of that question is basically when we get further down is do operators include sort of non-branded goods in their bottom line as gross sales? That's,
And I believe that was the intent and I'll.
but I mean, when we get there, we can cross that bridge when we get there because I think it's further down as well.
Okay.
Yeah.
Okay.
So if there are no comments and questions, so I'm assuming we don't have to take a roll call vote on this if there's consensus, or do you suggest we take a roll call vote?
Madam Chair, I think that a single vote would be
At the end.
appropriate. Yes, I think if the body could arrive at consensus, then I think that would be the easiest
Thanks
approach.
for clarifying that. Okay, thank you. All right, so we're good on that. So the next one is host community agreement, if so we're getting to, if you could just say the section, because that is.
Yes, Madam Chair, it's
definition.
500.002,
Mhm, okay.
and it is host community agreement HCA.
Okay, host community agreement, HCA, means an agreement entered into and executed between a host community and a licensed applicant, or between a host community and a marijuana establishment or MTC pursuant to MGL, Chapter 94G, Section 3D. Host community agreement, HCA waiver, means a written statement executed by a host community and a licensed applicant, or a host community and a marijuana establishment, or a MTC, which expresses the party's mutual intent to waive the regulatory requirement to have a host community agreement. Again, any questions or comments on that definition? Hearing none, moving forward. And then we will move down to license applicant, that definition. License applicant means.
Madam Chair.
Sorry, I beg your pardon. I'm sorry.
No, you're doing great. would we like to contemplate the HCA waiver definition as
I
well?
was gonna say that, I was,
Oh, I'm sorry.
Um,
So I,
And this should be a collaborative process. I recognize it's a public
Yeah.
meeting, so it's a little, so there will be a little give and take.
no, I.
so that
will-
was a
Okay,
question.
I'm sorry.
Yes, and I think the question was,
Don't apologize.
Oh, yeah, I
This is
think,
the first time we all.
Yeah, I know.
It's all good.
so I believe the question was if the waiver was in statute. And so in section 10 of 180, a host community may waive the host community agreement requirement, provided however, that the host community shall submit to the commission a written waiver executed by the host community in the marijuana establishment or medical marijuana treatment center. So the verbiage, they can waive it, is in statute. And I think that was the question, whether or not it was in statute. Obviously, there's no waiver in statute. We have to, if we want to create a template, that's for us to do as a body.
Okay. So is there anything that we need to find you? You're good?
I'm good.
Okay. All right.
I'm just answering questions.
Okay.
Okay.
Thank you. All right, okay. Now, moving on to license applicant. Means a person or entity pursuing a license to operate a marijuana establishment or MTC who has submitted or intends to submit a license application to the commission. A license applicant may also be considered a prospective marijuana establishment. Any questions or comments? Hearing none, we will move on to the definition of local approval process. Okay, local approval process means the steps involving a host community's cannabis licensing, including but not limited to zoning, all associated fees, deadlines, and meeting schedules for local bodies involved in such processes. This, I think, came from my group. Are there any questions or comments on that? Seeing none, I will move on. And the only next definitional change is under marijuana establishment. And again, it's just the acronym ME added there. So I think we can all agree on that. And then moving forward to model host community agreement. Model host community agreement means a template published by the commission to illustrate a compliant host community agreement. Any questions, comments, Mr. Stebbins?
Yeah, just a question. I know we have offered these in the past. They're available on our website in some cases, you know, for benefit of a licensee. I don't think this is a requirement of the statute, but is it just our decision to want to offer this up, create one for municipalities and licensees to follow?
Wait a minute. What's,
I mean, we're including a definition, but I didn't see I didn't see a requirement for this in the statute.
There is,
Oh, there
yeah,
is.
there is.
All right.
okay, go ahead.
I mean, I would defer to Counselor Lopez, but I would note that section 14 does speak to the development of a host, of a model host community agreement.
Yep.
But I will relate to Stafford, Counselor Lopez.
Commissioner Lopez, Councilor Lopez, Attorney Lopez.
Good morning, commissioners. Thank you. Thank you, Attorney Carter. I would just clarify that the statute gives us the power to develop a model host community agreement, but it does not obligate us to create a model host community agreement.
So are we, I think that I raised this question. Are we going, we have not developed it yet, but in the process of sending this to the Secretary of State's office and then getting public response at that point in time, is that when we anticipate drafting that? Yes, if we,
Yeah, I think the thought was we would save it till we know
right.
what the.
Because you know, I'm just saying.
Yeah.
because- Yeah.
Yeah, so we had talked about this and when we should put this in the pipeline of the HCA. And we agreed as a group that it should go at the end because we can't draft best practices if we don't know what the best practices are. So we kind of needed that first. And then in statute, it says develop a model host community agreement, minimum acceptable standards and best practices for municipalities and prospective licensees during negotiations of host community agreements with social equity businesses.
Okay,
That's what's
okay. I just want to clarify for the public because we'll get different folks saying, where is it? So I just want them to know. It's coming,
Yeah.
but it's part of the process. And again, we had talked previously about scope. Doing that would not be outside the scope. It's a continuation of that and it stays
Yeah.
within the scope of that regulation. Okay, so even that horse dead.
Yeah.
Go ahead, Commissioner.
Now that I found the language, I appreciate that. It does give us the authority to create those model host community agreements with social equity businesses. So are we limiting it to just a model HCA with social equity businesses, or should we make it clear that it would be social equity license? I think we have the authority to do this, but we want to expand it. And again, obviously looking on the end of the regulatory process to also include any licensee who wants to enter into the HCA.
Wait a
Are
minute.
you
I'm-
asking or telling
Could
us?
you, could you restate that? Because I'm.
Yeah, so the statute language says, develop a model host community agreement, minimal acceptable standards, best practices for municipalities and prospective licensees during negotiations of host community agreements with social equity businesses only. Obviously, this probably doesn't have to be a decision we make today, but we want to at some point make a model HCA that would address not only HCAs with social equity businesses, but HCAs also with a general licensing.
Isn't that what it anticipates?
I would defer to someone on the HCA group if they've thought about this one, but I would say, Commissioner Stebbins, that does sound like a policy consideration for the board, which
Yeah.
is, do we interpret the statute with just the singular identified term, or do we contemplate expanding it? I think that's a policy question for your consideration.
Can I ask a clarifying question?
Please.
So, Commissioner Stebbins, let me just try to figure out what you're saying. Very straightforward. So,
My daughters do this.
in the statute, it says that we're going to create the model host community for equity companies. But the policy question you're saying is, why don't we just do it for everyone? And create a model host community for
That's compliant.
Everyone.
Everybody would be
so that
compliant.
apples to apples.
I honestly thought we were.
I did too, honestly. Like, you didn't say, never use the word assume, but that was the assumption, I believe, and let Kyle, Rebecca, let's correct me if I'm wrong. I thought we were gonna just create it and it would be,
For everyone?
use it, you're
It
compliant.
feels like it's sort of, you can negotiate, but if you choose to, I thought it was for all. I didn't.
I did too,
Okay.
in all honesty.
I mean, the statute says one thing, but I think as policymakers,
Statute says one
we can
thing, but I'm
do.
looking
yeah.
at the definition, which I
Yep.
think the definition, just so we're all clear, gives us a
Yeah.
little bit wider berth that if we wanted to do that as a commission, we wanted to do that.
Yeah. Is there,
We're meeting the statute, but
yeah.
we're also,
yeah, what's the impact if we did, is there a impact if we did it for everyone? Is it helpful? Sean, please.
Please.
I would say the impact is actually from an internal standpoint or an agency standpoint, the value of a model HCA from a process standpoint is hugely valuable. In other words, if the commission adopts or upon completing a model HCA, it can then be used versatilely by any applicant. If they were to submit that model HCA to us, our ability to deem it compliant would be expeditious. Whereas if they chose to, between the community and or the applicant, to pursue a separate and distinct, unique HCA, our review for compliance would be a little bit more in depth. So in other words, if from a license processing standpoint, efficiency standpoint from a licensing staff, once adopted by the commission, a model HCA is then utilized by both parties. Again, we could essentially deem it compliant upon submission. So it would bring a lot of efficiencies to our process.
Thank you.
Madam Chair, can I ask another?
Yes, please. Thanks.
So the next, I guess, Commissioner Stebbins, is we have a policy question on the table for us to consider
that's
either
something.
now or when it comes back from public comment, right? So the question is sort of like, do we decide to create one for all?
Could we gain a consensus here? I mean, I.
Yeah,
think it
that's
should
a good,
apply.
that's
I
a good
think,
point. Yeah.
Commissioner Concepcion, just sort of want to get your take on this so we can, again, when we're doing this work and getting response, we're not drafting the model yet, but I think that here, I'm hearing from the folks here that they think it should apply to all, and I think that it makes a lot of sense and frankly would avoid a lot of headaches if we have it apply to all, even if the legislature didn't, restrict us just to social equity.
I agree. I'm of the same mind frame, and that is the thought that I had in mind as well. I'm similar to Commissioner Roy.
Thank you. Okay, so we don't need to take a vote. We're just saying we've got consensus and we're good.
Yes, and I think that definition as written accomplishes the policy objectives identified.
Okay, thank you. Right?
Can I ask a question?
Please, that was your question.
Attorney Carter. Mr. Carter.
Mr. Cobb.
So does that mean that policy sort of decision would be added to the definition, or is it implied in here, or is it a internal process? Like, how would people know in the outside world later on?
Sure. I mean, the working group who wrote the definition may want to opine on this, but the way that I'm reading it is it's a quite broad
Okay,
definition, meaning I think it would encapture the
Okay.
entirety of licenses.
thank you.
All right, moving on to reasonably related definition means a demonstrable nexus between the actual operations of a marijuana establishment or MTC and an enhanced need for a host community's goods or services in order to offset the impact of operations. Fees customarily imposed on other non-marijuana businesses operating in a host community shall not be considered reasonably related. Anybody have any questions or comments on that? Kim, please go ahead.
I just want to say that we spent a lot of time on reasonably related. This has been the $1 million question since the beginning of HCA's, and it's in statute, section 10, 2I, subsection A, that the community impact fee shall be reasonably related to the cost imposed upon the municipality by the operation of the marijuana establishment or medical marijuana treatment center as documented pursuant to subparagraph III. So what we did was and I want to thank Olivia Koval from our team because she got that definition off the ground. And then we kind of finessed it from there, but we did spend a lot of time, and hopefully this gives both host communities and licensees and prospective licensees some clarity around reasonably related.
Okay.
I appreciated that because that was my question as to how you answered the $64,000 question.
It's $1 million.
And the second part was what was a little confusing to me. Fees customarily imposed on other non-marijuana businesses operating in host community shall not be considered reasonably related.
You want me to?
If you can help.
Yeah, so let's just say trash pickup, right, is in the city of Worcester. Here we sit in the city of Worcester, and there's a fee for trash pickup, right? And that's a customarily imposed fee for everyone. So why would a marijuana establishment or MTC be treated any differently or held to a different standard for trash pickup? And it would be in their HCA or the community impact fee when other businesses are paying this customarily imposed fee. So why would they be held to a separate, different standard that would be in a contract like this?
So it's maybe this in the right way. It's kind of trying to avoid the double dipping, like I'm paying my trash fee.
Yes.
The community then can't come back and charge me again for that.
That's correct. That's correct. It's to make sure that they're not paying double costs for things that are already required and included as any other business.
Okay, and that might extend to like permit costs, inspectional costs, everything. It's trying to level the playing field.
Right. So the community impact fees are fees associated with the unique operation of an ME or MTC.
Okay.
So things that are because there's this type of operation, there are additional fees imposed by those host communities or costs imposed.
Okay, thank you.
Okay. All right, any additional questions, comments? Right, moving on to social I don't need to, this is red line through about the pilot program, but we've deleted it, so I don't need to, never mind, I never said it. Okay, so social equity business means a marijuana establishment comprised of at least 51% majority ownership of individuals who are social equity program participants or who have been certified as meeting the commission's criteria for designation as an economic empowerment priority applicant or both. Any questions or comments on that? I see none. We move on.
I actually have a question on this, and this is interesting. Now that I'm reading this, I know that under the law, social equity business is for those who would be eligible. And I'm reading through this language again and it doesn't seem to match the statutory change. And maybe I'll ask, because this is an equity working group question. I don't know if Tim's here, but maybe Andrew or someone from the legal team can kind of jump in on this.
But can you clarify the question? Because I'm not sure,
It's about how we're defining the social equity business. I want to make sure that it aligns with the statutory definition. So the definition of social equity business under Chapter 180 is, and hold on one second.
No, but this is what we went back and forth on. It's one, either you have checked that box and you have been deemed eligible and in theory have participated in the program, or you would meet the requirements. And this is what we have to more fully flesh out, which is having our staff work with communities to do that. Is that?
I think it might be helpful if I say, I'm quoting now the law.
Yeah.
So social equity business is a marijuana establishment with not less than 51% majority ownership of individuals who are eligible for the social equity program under Section 22, or whose ownership qualifies it as an economic empowerment priority applicant as defined by the Commission's regulations. And so my question is, because that the law includes eligibility language about individuals who are eligible for the social equity program, but our definition is saying that who are social equity program participants. So that I wanted to gain some clarification and just make sure that what we have in place is actually aligned with the statute.
Go ahead.
Commissioner Concepcion, I'm wondering if adding as defined by the commission would be helpful as well? Because I know what you're saying.
But see, I think what I'm seeing here is it around the word certified? Commissioner Concepcion, is that because what we had talked about is just like what they do for, courier and delivery. We had anticipated creating an opportunity for persons who would qualify, even if there isn't a cohort available, that we would certify them as we do with the drivers, the delivery businesses. That's what I thought we had anticipated, and that we would work with the communities to tell them whether or not, yes, that person would be eligible for these programs.
Right, but this language here does not, it doesn't, it's not in line with what your interpretation and mine is. So we have contemplated in our regs, there's two things. There's a pre-verification process where the commission would verify whether or not a business qualifies as a social equity business. And there's also a pre-certification process, but that pre-certification process is only available to EEAs and people who've actually been accepted and gone through the social equity program here at the CCC. What I'm saying is that this language limits social equity businesses to social equity participants as opposed to those who may be eligible.
But if we create the certification process, they will be certified.
They will not be participants, no. You're only a participant if you've been accepted to our social equity program.
But this is what I'm saying, is I thought we said, even if they didn't participate, we would create a process whereby, to meet what you're saying, where we would say to a community, check, they would be qualified, and they would have that, in essence, gold star, where they're certified, where they can go to a different community, or maybe it helps them, raise funds.
And I think
we're saying the same thing. I think we're saying the same thing, but this language doesn't say. Sorry.
If
I might
if I
cough
could,
every now and again. Go ahead.
Commissioner Concepcion, it sounds to me like this really hinges on the word eligible. Would you say that's correct?
It's that the word eligible, and then here in our definition, social equity program participants.
Yes, I mean, I think the word eligible in some ways is gives us direction from the legislature. But
Mhm.
ultimately, the policy interpretation will be done by the
Absolutely.
commission.
So what do we need to change anything here to? Sean, do you
I
have
mean, maybe this is a conversation for the entire commission, because what we would be doing in essence is a social equity business would only be for SCPs and EEAs as opposed to those who may be eligible. That's what I'm saying.
Right.
But that's an open question, and that's why,
Yeah.
I wanted to raise it, pose it, and sort of see what my fellow commissioners think.
So Sean, you got a?
Just a few thoughts, and I thank you, Commissioner Concepcion, for raising this. It could be, and I think one of the things the practical exercise we need to think about in the context, especially of social equity program, is essentially the seasonality of cohorts being open. In other words, if there's not a window for someone to apply and demonstrate their eligibility, they may miss out on perhaps funding from the Social Equity Trust Fund. Because we've had 4 cohorts or 3 cohorts, and we're planning the 4th. So there might be folks that are eligible and contemplating their business, but they're not that they're frozen out of the program, but we don't have that window open for them to apply and demonstrate their eligibility. So adding language here that someone could demonstrate their eligibility absent being actually accepted into the program may still allow them to access other state benefits, including the Social Equity Trust Fund. So, and we don't know
Exactly.
yet what their criteria for access to that fund is going to be. So it might be that they, and I please don't interpret this as being any inside knowledge of, it could be small grants or something of that nature where, because we don't know what that pool of money is going to be. So I guess you could modify this language, though, that social equity program participants, and then add into Andrew's point, to Attorney Carter's point, otherwise eligible. And I think that would speak back to the statutory language, which is, and we should also note that the economic empowerment priority process is a closed window. The statute has been met and satisfied, but does not grant us the authority to open that window again. So really getting more folks in as a social equity business would really hinge on the social equity program criteria, which again, the commission enjoys the ability to open or close those windows for applications. So I would say adding the word eligible would meet the statutory definition.
Does that?
We can incorporate that edit.
Okay, all right. Do we have consensus on that?
Thank you, Sean. Thank you, Mr. Executive Director. That was the reason why this was contemplated, is because we understood that it would have an impact on the access to opportunities, during that HCA process prior to, any cohort being open or access here. So I thank you, because you were able to really explain that in a way that was helpful. I hope it was helpful for my colleagues.
So we have consensus. We're going to add the word eligible. Or otherwise eligible. Okay, so we have consensus on that.
Okay.
And then moving on to verification of a social equity business, again related, verification of a social equity business means the process through which the commission qualifies applicants, as social equity businesses pursuant to an application and prior to certification. So we haven't done anything to that. That's consistent. Okay, anybody have any questions on that? Hearing and seeing none.
Madam Chair, I just want to ask, I'm just checking in on staff. Is Matt on as well? Matt Jinkola, is he available? I feel like some of the questions we were having now would have been helpful, but just in case he should be on.
Hi,
deck.
Commissioner.
Hey,
here.
Matt. Yeah, I would say just stay prepared on the bench.
Yeah, you bet.
Okay.
Okay, so where do we go next? We've gone through. All right. Yep, so 500.032, under revocation of a marijuana establishment agent registration card. And we go to section G.
I'm so sorry, because we went through verification of social equity business really quickly. And I stepped out, my mom called me, and I answer.
Oh, sorry.
I'm so sorry, but I just had a quick comment while I was reading this. The verification of social equity business is more of a process question, Sean, I think. Will there be, and I guess this is a larger question, there'll be guidance for most of this stuff afterwards. So like even for this verification of social equity business, I know we haven't developed the process yet. We have to do it internally. And Matt, that's why I think I was thinking about you now. And then will there be guidance on that process? Sorry, I know we jumped, but.
That's okay.
Madam Chair, may I?
Please, no.
So yes, thank you, Commissioner. That is something we contemplate through implementation. There's a few exercises we will go through. One is to assess our existing guidance documents and ensure that they are updated and accurately reflect the as to change or as to be updated regulations. But then also contemplate, are there other elements that would require new guidance? And this would certainly be one of them. But that's also something we assess as part of impact, which is an implementation is what are new processes that need to be developed and brought to the commission for your consideration, as well as what are new systems and or resources that might be necessary, including people around where does this land from a process standpoint? Is this with licensing, et cetera? And again, wanting to make sure that we're able to give you an accurate assessment as to what, I guess, the impact on people, as well as how much time might this take? What do we prioritize first? And I obviously want to get your feedback on that as far as, what we can't do all of these things at one time. So what is the most important thing to do? And then how do we adequately communicate and convey to the public, this is what to expect? For instance, if there's a new application necessary, what will it take to build that out? And when can folks expect to see something? So, but I would say, yes, absolutely. Things that are here that need to be interpreted a bit further would require guidance.
Thank you. Thank you. Thank you, Madam Chair.
Okay, so moving on, so it's under section G. And what this entails is the language is conviction, guilty plea, plea of nolo contendere, or admission to sufficient facts of, and we've deleted felony, drug offense involving distribution to a minor in the Commonwealth or a like violation of the laws of an other jurisdiction. So it's basically deleting the word felony. Anybody have any questions or comments on that action? Hearing none, moving on to section 8. We are adding language 935 CMR 500.801 Table A, marijuana establishment licensees, or 935 CMR 500.803 Table E, registration as a laboratory agent as applicable may otherwise affect the status of the suitability for registration of a marijuana establishment agent. I don't know any questions or comments on that. Hearing and seeing.
What?
Go ahead.
I didn't know, Commissioner Concepcion, did you want, is this the time that you were gonna?
Oh, no, I had no comment on this. It's included. We're going to have a thorough presentation and conversation around suitability in general.
okay,
But by all
okay,
means,
yeah.
if you have a question now, but I welcome it.
Yeah, no, I just didn't know. Okay, we're gonna do it later. Perfect. Okay, thank you.
Okay. All right, thank you. Moving on to section 2, in addition to the grounds in 935 CMR 501.032, section 1, a conviction of a felony drug offense in the Commonwealth or a like violation of the laws of an other jurisdiction shall be adequate grounds for the revocation of a marijuana establishment agent registration cards for individuals or entities subject to 935 CMR 500.801 Table A, marijuana establishment licensee, or 935 CMR 500.803 Table E, registration as a laboratory agent. I have never had to read this out loud. 500 dot, is it 500? How do I say it?
I think either works, Madam
Oh,
Chair.
all right, okay, I'm saying that right, okay, all right,
I'm going to wave my hand on the screen.
please, go ahead.
The one comment that I will make now, and we'll go into more detail, is that all agents and prospective licensees, current licensees, remain subject to suitability review in our standards. But we'll expand on that some more. I think there was a lot of misinformation kind of floating around there, but I thought this was a good point to make that point early on, and then we'll expand on it as we talk about suitability.
Okay, thank you. All right, no more comments or questions on that? Moving to section 6. Social consumption establishment. we've deleted the pilot program, and it now says social consumption establishments. Social consumption establishments may. And then we, may what?
Madam Chair, yes, this,
We're just deleting the whole thing.
this deletion is consistent with a vote that the commission took in May, I believe. So we
So all
just,
this is just deleting that, okay.
correct. So
fine.
this would
Deleting
be,
the pilot project.
yes, this would be an administrative change and effectuating a vote previously taken.
Okay, all right, so then. And then moving to, so, but in terms of the next section, under subsection B, social consumption establishment licenses shall be limited on an exclusive basis, so it goes through that. I'll read this. On an exclusive basis to businesses controlled by and with majority ownership comprised of economic empowerment priority applicants or social equity program participants, micro businesses and craft marijuana cooperatives for a period of 36 months from the date the first social consumption establishment receives a notice to commence operations, provided, however, that the commission may by vote decide to extend that period following a determination of the goal of the exclusivity period to promote and encourage full participation in the regulated marijuana industry by people from communities that have previously been disproportionately harmed by marijuana prohibition and enforcement of the law by farmers and by businesses of all sizes have been met. So again, that is just a clarification of that language and the ability to extend the exclusivity period. Any questions?
I have a question.
Go ahead, Commissioner Concepcion.
And I wonder, because it's helpful that we have this red line, because it looks like the language was stricken and then put back, and then there was some additional language that was by farmers and by businesses of all sizes that have not been met. I just wonder if Commissioner Stebbins or Commissioner Camargo can kind of provide some clarity about what we're reading.
Yeah, I'll take a stab at it. Like Attorney Carter to weigh in. Attorney Carter said, you know, our decision to do away with the pilot program, I think, is reflected in the red line strikes that you see. I think under B, which is social consumption establishment licensees, et cetera, only speaks to what is the current exclusivity period that's allowed. It's something that our working group is continuing to look at, but
I guess, am I missing the change? Am I missing, because I see it as the language being stricken and then put back. I feel like I'm missing something.
Commissioner, it would appear to me that that's exactly what happened, that the line was stricken and then reinserted because it appears consistent to me on the draft side.
Yeah, okay.
So there's no substantive change.
So there's no change.
No,
Okay, I just wanted to make sure I'm not missing anything. Okay, got it.
Okay,
I just have,
please go ahead.
I just want to make sure that, and maybe we're not there yet in the process, if it's aligned with statute. So we just talked about the definition of a social equity business. We expanded that beyond participants in the SEP or EEA designation. The statute call for, in other words, like I'm not in this working group, so I sincerely need a little edification around this. Are we excluding folks with this limited definition? This definition doesn't align with the SEB definition.
So we should add that same eligibility language.
You're asking?
Yeah.
I would say
Well,
that
that's-
could be. Commissioner.
I'm sorry, I can't see you because I'm not in the room. Sean, go ahead. I'll go after.
I would the question ultimately was, and Commissioner Rice, make sure I'm accurately reflecting this. Exclusivity at this point is limited to economic empowerment applicants, certified applicants, and accepted participants in the social equity program. Whereas the distinction for a social equity business now would include
Broader,
those that may not be in the program but would be eligible for the program.
right?
And so is there a decision or a choice to expand access to exclusivity to include those that may not be in
Because it opens
participants in
them
the
to other
program
state
but
benefits.
would otherwise be eligible?
Yeah.
Again, I would just, and I'm going to channel Attorney Carter a little bit. That's a decision for the board if you're inclined.
Yeah.
The one, I guess, restraint I would suggest is the social consumption working group could come up with that conclusion and prepare and propose it as part of their work. So it doesn't therefore have to be done today.
Yeah.
You would have that ability as
I
part of
wanted
the
to
process.
flag it at a minimum.
Thank you, thank you. We can come back to it. Yeah, that's a good point.
All right.
And I think we almost have to look at that as an umbrella now. Yeah, thank you.
Commissioner Concepcion?
Thank you. Just a few added comments. This would still be in line the same way that the delivery license types are exclusive to SEPs and EEAs. I mean, this wouldn't limit the ability for someone to seek an HCA and still come before us and apply for a social consumption license, so long as they are in fact SEP or EEA. I don't think that this is inconsistent with what we've done with social equity businesses. I think it's actually pretty much, you could qualify as a social equity business, apply for a host community agreement, and want to open up shop as a social consumption licensee, but you still have to go through our process to become licensed.
Okay. Yeah.
Okay. Anything else? We good? Okay. Moving on to 500.101 application requirements, going down to 8, which documentation in the form of the most current executed HCA or HCA waiver entered into between a licensed applicant and a host community that complies with 935 CMR 500.180. Assuming that we're all on board with that. Is that good? Moving down to 11, a plan by the marijuana establishment to positively impact areas of disproportionate impact as defined by the commission for purposes established in Mass General Law, Chapter 94G, Section 4A.5, Romanet 4. The marijuana establishment may satisfy this requirement in part by donating to the Cannabis Social Equity Trust Fund established pursuant to MGL Chapter 94G, Section 14A. And I'll just continue. The plan shall outline the goals, programs, and measurements of the marijuana establishment will pursue once licensed. Do we have any questions or comments on that? Please, go ahead.
Is the social equity fund established enough where they can even accept donations at this point?
Good question.
Good
Well,
question. But listen,
This
because
is
I
from
remember.
the statute. This is
Yeah,
directly from the law.
Right.
It's a requirement that we have to have in place under Chapter 180.
No, and I understand that. And this is just an aside, like,
It's an aside,
so
and
because
we have to, no, we need to set up a meeting with the Department of Revenue to determine, and this is one of the things that we went, back and forth on when we were talking about accountability for social equity at the municipal level, because basically we're not necessarily enforcing all of this. We're working in collaboration with the
Exactly.
Department of Revenue. So I am assuming that we can have a conversation and work some of these details out with the Department of Revenue when the effective date of November 9th. So that will be our goal that we have from Sean. I don't know if you have any comments that you want to make, but we need to set that up sooner rather than later to have those conversations with them.
Sure. Yeah, thank you, Madam Chair. I would agree with that as well. Another element is I know the statute in creating the Social Equity Trust Fund does authorize, I'll call them governmental disbursements and appropriations as well as private donations. So statutorily, legally speaking, the fund does have the ability and enjoy the ability to accept outside donations. I do know that the Executive Office of Economic Development, now EOED, as it's been changed, is working right now with both the Comptroller and Treasury and whoever else is necessary, ANF, et cetera, to establish that fund in a durable way, and would anticipate that legal.
But will this, where does it actually, is it going to, I mean, who's going to hold it? It's going to be Economic Affairs, but I guess I'm not clear on where it's going to go. Because again, this is not till November, but it's going to be, they are setting up a fund. They have a fund now. The funds have not been transferred or fully transferred by the comptroller.
Yep.
I think, Madam Chair, I think
Yeah.
that's a good point. Maybe we can follow up on it.
Yeah, No, we have to
Yeah, yeah.
follow up and I think that everybody's still a little bit in the dark about the roadmap.
Is that something Matt can do?
Right. Well, I think it's something that we're having a meeting with the Secretary of Economic Affairs to talk about.
Okay,
the
okay,
fund,
all right, so then we'll get there.
If I just may advocate, and I thank you for everyone that's been working collaboratively with those on the fund, that once they have mechanisms in place, if they issue guidance, if we share the guidance, because
Of course.
they can satisfy part of their positive impact plan. And like to Sean's point, executive director's point, that the infusion of cash may be at a certain time frame where this can start to create immediate infusion of cash. So I just want to put a pin in that. I know it's not under our purview or jurisdiction, but if we're a partner in this, to be able to convey to all of our licensees, and everybody would benefit. They satisfy
Yeah.
positive impact plan, the fund would get a quicker infusion of cash.
We're having that conversation.
I think everybody agrees, yeah.
In the
Yeah.
next, we're having that conversation in the next couple of weeks, I believe. Okay.
And I know I had nothing to do with
No. There's a lot of gaps. Okay, moving on to section 2, license pre-certification application process for economic empowerment, priority applicants, and social equity program participants. Section 8, license. Applicants controlled by and with majority ownership comprised of economic empowerment priority applicants or social equity program participants may file a pre-certification application. The pre-certification application for licensure shall be in a form and manner specified by the commission. After receiving pre-certification by the commission pursuant to this subsection, an application, an applicant may submit a provisional license application. After an applicant receives a provisional license, the applicant shall comply with the requirements of 935 CMR 500.103. So I don't know if there are any, this is a change. Yeah, Sean.
No, you stumbled on a typo, so thank you. I think it is an applicant may submit a provisional license application.
Yeah. Yeah, so do we agree that it's applicant, not application? We got consensus. Okay. Okay.
Sean, don't be upset.
So again, in this section B, pre-certification of application, these changes are merely typographic, types that it's putting in Romanettes 1, 2, and 3. And again, section 1, the licensed applicant may complete any section of the application in any order. Once all sections of the application have been completed, the application may be submitted. The commission may determine a licensed applicant to be pre-certified upon finding a license. How am I reading this?
The license applicant.
A licensed applicant has submitted responsive documentation demonstrating a propensity to successfully operate under a marijuana establishment license. Got it, sorry. We all okay with that? Then moving on, again, on approval. Go ahead, Commissioner Concepcion. Sorry, I'm trying to keep an eyeball on.
No, I'm sorry. I didn't want to interrupt as you were going through because I know you have a lot to read and cover. But that first, under subsection A, the same concern that I raised about social equity businesses applies here. So pre-certification, oh, I caught myself. I take it back. No comment.
Okay.
Sorry, guys. I'm thinking about pre-cert, pre-verification. This is correct and this is accurate. My apologies.
We've stumbled over those phrases many times in the last several months, so.
Yeah.
I hear you. Okay.
Sure.
Please, go ahead.
I want to make sure my assumption or my intention is aligned with the commission's intent in drafting this. And I'm also kind of speaking to our licensing staff a little bit too. The practical way for me, at least, to implement this is essentially creating one application for pre-certification and allowing the entity or the individual to identify which licenses they may want to pursue, as opposed to creating, so let's say we have 10 different license types, 10 different pre-certification applications. I think just from an ease of administration standpoint, a single pre-certification application, knowing that different licenses have different requirements, but allow the applicant to sign up, is sort of self-guide versus having to fill out. Let's say they want to be vertically integrated. One pre-certification application could therefore apply to 3 separate provisional license applications. that'll make our life a lot easier on the back end, but hopefully it allows licensees or applicants, excuse me, to sort of self-guide their way through the application process. I just want to make sure I'm understanding your intent and that I'm aligned and thinking through implementation.
Yes.
That's what this says in here. Yeah, right, yeah.
It does, but
It just says.
it's been a little bit of a heartburn on the back end of how do we implement this? And I just wanted to be sure that that plan squares with your expectations.
This has been a difficult languaging,
I know.
resourcing and impacting.
I know. I'm only saying it with a smile just because these things are so dense and so complicated.
Yes.
And no offense to folks who are writing this, but like folks have to be able to read this at a level that they understand it if they don't have a lawyer, right? So like everything you said, I'm like, yeah, this should be kind of watered down a little bit. But I think just being mindful when we're writing these regs, like not everybody has a lawyer or a consultant that can read these things. So, and I'm assuming when we have guidance and impact, and obviously asking the commission and emailing us will be helpful, but that's why I kind of smirk.
So,
I got another question.
please go ahead.
We talk about it, and again, I don't know what was still original language or what's been changed. Talk about a pre-certification application process for EE priority applicants, which we know the window is closed. Is that language that we should leave in just in case we ever have the opportunity to consider EE priority applicants in the future, or is there still a need for that language?
I think that was contemplated. But I guess I'm a little bit, Commissioner, do you mind expanding a little bit more on your question?
Please.
Sure. The section is titled License Pre-Certification Application Process for Economic Empowerment Priority Applicants and Social Equity Program Participants. Obviously, we know the latter will have future cohorts and eligibility opportunities for people to participate. I'm just asking if the language we're prescribing gives us the flexibility that if an economic empowerment priority application window was ever made available to us again, that we'd be covered by that? Or is it language that we no longer need?
As far as the eligibility for EEA status.
Right.
So the reason I would argue that it's still necessary is economic empowerment applicants there's some other requirements that I think they would probably describe it as a bit of a burden. Changes of ownership, for instance. We must assess their eligibility anew as if they were reapplying for that to determine whether or not they remain eligible for that, those benefits. And so having that eligibility prescribed in regulation is that legal authority that we evaluate against. And so I would say it is durable language that should remain.
Okay.
Yeah, I agree. Thank you, Sean.
Any other questions or comments? In the interest of time, the next several sections.
Madam Chair.
Oh, please, Commissioner.
I just wanted to add an additional comment to this section, just to benefit anyone who may be watching, who may not understand sort of what we're dissecting here, is that it's an expansion of our existing pre-certification. So I know that my fellow commissioners understand this very well. We have it in place already for our delivery license types, and it was originally already contemplated for social consumption as well. But what this does is it allows pre-certification for all EEAs and SEPs, so social equity participants and economic empowerment applicants as well. So it's an expansion of the existing pre-certification process. I just thought it was important because it sounds really complex the way that we're breaking it down and going through it word by word. But it might be helpful just to understand what we're looking at and what we're discussing. So that was it. It was just an added comment.
Yeah.
Thank you. Again, just a process that hopefully lowers barriers to social equity applicants to be able to more smoothly with reduced cost to be able to move forward in the HCA process. So again, the next several sections going through section 3, these are basically just, typographical A's and letters and things like that. So I will not bore you.
Madam Chair.
Go ahead.
And I actually just wanted to flag it, and this is something you and I have spoken about at length, is another change to Commissioner Concepcion's point is the ability for an entity or an individual to submit to a background check during this process, by which they would not learn suitability at the back end, but instead be able to prescribe it at the front. And I just wanted to acknowledge I know it's a priority of yours as far as finding out earlier in the process. And,
Right.
and just wanted to comment to bring some, identification of that change as well. I think it's substantive and important. So I just wanted to flag that for the commission's information. as well.
Thank you again. That was really what the working group was. Thanks for clarifying that. That's what the working group wanted to do, avoid people spending a lot of money and then finding out they may not be suitable. So,
Madam Chair.
go ahead.
So I'm just looking at the questions that were submitted, and somebody did submit the SEB. Is it in the definition
Can you
section?
write the question and maybe the person?
Well, this, yeah, it just says verification of SEP business definition section. What's the process for that? Do we commissioners decide on the policy, or does staff? Will there be guidance on this internally and externally? I don't know who submitted that question.
I did, Commissioner Roy. Yeah, thank you for bringing it up. I actually haven't brought it up because we've basically covered it and Sean discussed it a little bit. I kind of re-asked it earlier in a different way, which is sort of just process, guidance, you know, how to, because all this stuff needs to be operational afterwards. So that was my question. So thank you, Commissioner Roy.
Is this definition is SEB a definition?
Yeah, it's already,
Yeah.
it's what we
so
talked
in
about
there.
earlier.
Yeah, I
Yeah.
just wanted to
Thank you, thank you,
confirm.
thank you.
Okay. I don't want to miss any of these.
No, I appreciate it.
And again, this is an impact issue that, you know, we're working through with staff and we hopefully try to relay them, their
Mhm.
fears that this is going to be a flood.
Yeah.
I don't think it will be a flood, but anyway. Now getting to section 3, individuals and entities seeking pre-certification may submit to a commission-initiated background check upon request in form and manner determined by the commission. So that, again, that will be further fleshed out. Any other questions?
What section was that?
That is 3. It's hold on. It is.
Madam Chair, if you don't mind.
Please.
I'm not sure who wrote this language, but I do wonder if it could be simplified a little bit. Something to the effect of individuals and entities shall seek pre-certification and initiate a background check. in a
Go
form
back,
and
I'm
manner
sorry. Go back, I'm sorry.
By the commission.
Andrew, go back. Tell us what section you're in, because I got lost.
It's the same section I just read, but.
Okay, section
I
3.
assumed that-
3, and maybe it was written this way, so if the
Okay.
author could help me, that would be helpful, but we reference the commission twice in one sentence. So individuals and entities seeking pre-certification may submit to a commission-initiated background check upon request in a form and manner determined by the commission. So I think that individuals and entities seeking pre-certification may submit a background check in a form and manner determined by the commission. So just clean up the language a little bit.
Okay, I'm okay with that. Anybody, I mean,
Well, I'm confused. What are you striking in?
Sure, and maybe this is.
well, the only thing I was saying is that in a manner determined by the commission, because we haven't determined it yet.
Yeah, so that's for a future action. I just think a sentence that references the commission twice in one sentence is not particularly, I think it's a little
I think
circular.
I think commission means almost 2 different things here in the sentence.
Yes and no, Andrew, thank you for raising that. I hear you. The reason I didn't write this language, so I'm therefore, I don't want to be overly loyal to it at the same time. What I'm reading in that is that the commission initiated background check speaks to the background check required by the commission for licensure. Whereas if it were vague about just a background check, someone could theoretically attempt or argue, I've subjected myself to a query, I'm submitting that, can you please deem me suitable? So I think adding the distinction in there about it would be the commission's background check conducted, not an independent or external background check. But I would welcome feedback on how to articulate the intent.
Please, Andrew, go ahead.
Yes, and if we think that this is effectuating that purpose, then I'm good with the language. So I'm okay with it.
Okay, thank you.
But is commission twice on there okay? Is that what you're saying? I had a question about that as well.
Yeah, it's more of
Well,
a,
I guess the only thing when I look at that, and again, I may be reading it in a very obtuse way, but may submit to a commission initiated background, and then it's in a manner determined by the commission, and we haven't necessarily determined it yet, so it leaves it open to a future determination, which we haven't fully vetted. That's why I see commission there twice. I feel like it's almost 2 issues. One is you can apply to the commission, but we as a commission will still have to determine what that is. Do you get that? That's why I say it, commission is there twice, but it kind of has two different connotations. Does that make
Yeah,
sense?
that's very helpful context.
Does that, okay, right, that's how I see that. So, I like taking out words, so thank you for that.
I'm waving because I see our enforcement counsel, Rebecca Lopez, raising her hand as
Oh,
well.
Rebecca, please, Chairman, you unmute. There you go.
Sure. I appreciate that. Thank you very much, Commissioner Concepcion. I just wanted to clarify. So this section is not, this section of pre-certification is speaking to those individuals that have already been certified by the commissioner, otherwise deemed as SEPs or EEAs. This section is not speaking to individuals that may qualify for those designations. Is that correct?
Commissioner Concepcion, it is creating that opportunity for people to move forward with that background check to make sure that they're suitable, right?
What-
And so, Commissioner Concepcion, yes?
That Rebecca, that's correct. It's for pre-certification applicants, so it's for SEPs and EEAs to have access to that background check prior to going further along in the licensing process.
Or those.
But
who
does it
would-
also
or
capture
those who
that?
would- Or those who
Right.
would qualify. But again, it's the thought, and it's been a little bit clunky with all of the different definitions and trying to interpret what the legislature meant, but it's trying to remove whatever barriers those are. So it is a little confusing. We've literally been confused trying to put some of this together to make sure that we covered everything. But Rebecca, can you just restate if you have any further comments, like, you missed that, or?
Madam
Well, I
Chair,
think
the way that
I'll
it's
go after
written,
yeah.
sorry, the way that it's written is the way that our enforcement counsel is interpreting that. So if we wanted it to mean something different, we have to change the language here. Because as written, this would apply for SEPs and EEAs. And not for
Right.
that. Go ahead.
And that's something that I'm noticing here, just again, speaking from an enforceability standpoint. I could see there being a lot of confusion between what equity provisions apply to those who have already gone through our processes and been designated as SEP or EEA, and what is also applicable to groups who have not yet gone through that formal process, but could qualify. And I do understand, commissioners, that you have made a policy interpretation that the statutory definition of social equity business includes those who may qualify. Because I'm counsel for the organization, I do want to make sure that I draw your attention to some potential limitations or disadvantages to reading the statute that way, in the sense of the statute itself says that a social equity business is a marijuana establishment with not less than 51% majority ownership of individuals who are eligible for the social equity program or whose ownership qualify them as EEA. So I understand that there is some interpretation happening on eligible, but I want to fairly present to you that there is another way to read this that the plain language of the statute supports that may not be in line with the policy objective you're trying to accomplish. Pre-verification, that process is still a process that you can create and that is in the regulations. But in terms of the definition of social equity business, that is referring to a marijuana establishment, so a licensee who is eligible, so has already been determined by the commission to be eligible. So I just want to give you that perspective, because before you go down the road of trying to incorporate this third group into all of the equity provisions, you should be aware of that. And then additionally, if you choose to go down this road and incorporate this third group into all those equity provisions, you're going to need to use consistent terminology so that people are not confused. But I just wanted to, I apologize for the delay in bringing it up. I'm just trying to, get a sense of when I should, chime in. But I do feel that I have an obligation to bring that perspective to your attention.
Commissioner Concepcion?
Thank you. I guess I'll open it up for the other commissioners. I'm letting that marinate. I always, Rebecca, I've said this before, you and Kyle, amazing. And I appreciate that perspective. I just looked back at the statute as you were saying that. And I guess in my mind, I saw eligibility as meaning one thing, but it does not say may be eligible. It says eligible.
Yeah.
So now I understand that perspective, but I'll open it up for everyone else.
Yeah.
But if I could, I think that it was the intent that we broaden what eligible could mean, because it expanded opportunities for more social equity applicants. So I think that it was a conscious decision that we made to, in essence, expand what eligible is, and that we would expand how we would deal with those people or businesses.
You're saying in your working group, Chair? Is that
Yeah,
what you're saying?
we talked about this because this was something, again, it was in response to how can we reduce the barriers for social equity applicants to move to, I mean, frankly, if you get pre-certified, if you're deemed eligible, it might help you raise money. It might help you gain greater traction, within particular communities saying, look, I'm already not only here, but I mean, you think of some of these communities, like Greenfield or Uxbridge or, other places that have Holyoke, that have multiple, HCAs, and, you're never going to see someone get licensed. What this says is there's one less barrier there. And so maybe in picking and choosing, if there are limited HCAs, that this might be, a way that people can do that. But again, I hear what Rebecca's saying.
Yeah.
And I don't know if there's any pushback, because I think that the group, and we've gotten some feedback from, from others, including, people who are in the delivery business, saying that this might be something you want to do across the board. And again, we don't have a constantly open, we don't have an economic empowerment program that's open. We don't always have a social, equity program cohort that's open. And so we shouldn't delay or put a barrier in front of people. So I kind of open it.
Yeah, can I
think that we should expand that definition?
Well, I need some clarity because section 14, subsection 30, prioritize social equity program businesses and economic empowerment priority applicants and any other class of applicants the commission deems eligible for expedited review during the evaluations of applications and inspections. So I thought what you guys had said was you're going to pre-cert, even if you're not in a cohort.
Yes.
You're going to pre-cert.
Yes. If you fit that definition.
If you fit that definition.
Yes. Or am I getting that?
No. We're conflating two different things. Pre-certification is separate from pre-verification. So verification is something that's contemplated in these draft regulations. Pre-certification is already in existence here at the CCC.
Right.
And what this does is open it up beyond certain license types, but it remains only accessible by EEAs and SEPs. So this is not an expansion for pre-certification. The thing that we're discussing now is about verifying social equity businesses, and that was so that they gain access to funding and opportunities at the local level for their equity provisions. So I understand that we're kind of putting two things together, but pre-certification does not encompass people who are not already EEAs or people who are not or will be, who are SEPs, who we certify and have accepted into the social equity program.
I was on the working group and I'm still confused.
Right, I was gonna say, can we pause?
Yes?
Yeah.
Would you like to?
Yes. Can we also, I think we need to pause, because this is a lot, and I think that Attorney Lopez, I see your hand. I think it's also, it's new to us today, right now, and even if we take a 10-minute restroom break. But I need to process it, I need to understand it, because I think one of the questions that I had when you read the question, Commissioner Roy, I think some of it was that.
Yeah.
The SCP business versus the statute, and I think, Rebecca, you just I agree with what you're saying, and I think that we got to be very careful before we continue down the regs so that we're not confusing it a lot more. But I'll pass it back to the chair, but I know that Rebecca has.
Yeah,
I do think it's important for us to have these kind of conversations though,
Yeah.
because that's why we're here. It's like we want to get as much input. We want to hear from the different attorneys on staff to make sure
Yes.
that we're getting it right.
Yes.
So Rebecca, if you could chime in, and again, I've obviously confused myself here as well, so.
Well, so before the break, I would just say, so we're looking at the definition of social equity business in section 1 of 94G. And up until now, the focus has been on the word eligible, but I would encourage the commissioners to look at not only the term marijuana establishment, but the term are eligible and qualifies. So are in the singular is. So when someone is eligible, when someone qualifies, that means that their eligibility has been determined. And so I think it's important to also not just consider eligible, but the word in front of eligible, which is really referring to kind of the tense, the space of eligibility that's being referred to. That might be helpful too, but that's part of what is behind my my reasoning there. So I just wanted you to have that as well.
Okay, all right, I'll entertain a motion to take a 10-minute break, coming back at 11:40. Is that good? Will you so move it?
Yes.
Okay, will you so second it?
So seconded.
Moved and seconded. Camargo.
Aye.
Concepcion.
Aye.
Roy.
Aye.
Stebbins.
Aye.
Chair votes aye. We will be back at 11:40.
We have you guys here.
All right, thanks. All right, so heading back in and Commissioner Concepcion, and again, my apologies for the confusion, but I think that this is a healthy conversation. So because there's still a little bit of lack of 110% clarity on this language, one of the things in terms of understanding the process, so we can get through this today, because we still have a lot to get through. As I mentioned the term scope in the beginning, the tweaking of this language, after we submit this to the Secretary of State's office, after we get feedback from the public on these draft regs, we have an opportunity to fix this with greater clarity for the final version of the regulations. Correct, Attorney Carter?
Yes, Madam Chair. An example would be if we got significant feedback on the language of a particular reg, that it was unclear, it could be interpreted in multiple ways. We could review the feedback and then incorporate it and make sure that we are effectuating the will of the commission as the language is construed.
I have a
Commissioner, go ahead.
Yeah, so I hear you, Madam Chair, and I hear you, Mr. Carter. But I also hear Enforcement Counsel Rebecca Lopez, and I think that my question is, we're hearing from our legal team, you, Rebecca, Kyle, right, folks who worked on this stuff. I don't know if this is a public comment section, because we're talking about, so the sort of the thing in question that we have right now, sort of like the subject or the situation, it's a statute legal situation, right? So it's not like a bigger policy discussion. It's what I'm understanding
here would be within the scope. And I think that, again, maybe we need to kind of, I won't say regroup, but we need to get, we've heard, from Rebecca, and thank you, Rebecca, for being a diligent, dotting the i's, crossing the t's lawyer. I know what I envisioned.
Yeah, what you
when I was hoping we would expand eligibility. There has been some confusion even in our group with certification and verification. So the bottom line is we know what we want to achieve, but what I would suggest is we leave this language as is, and then we give ourselves another bite at the apple. And I would ask Commissioner Concepcion if you agree with that approach, unless you want to hash that out right now, and then Commissioner Roy.
I think I would like to just hear from, the other commissioners who haven't had the opportunity to be within our working group. And also I'll interject on Kyle's behalf. Kyle, I thanked him earlier, but he was not a part of the municipal equity working group. So
Sorry.
that's all, but he is phenomenal. Not to take away from Kyle, but I know he's probably thinking I didn't opine so much, but you're always welcome if you want to offer your opinion as well.
Go ahead, Commissioner Roy.
So I just, and I know we all feel this way, we want the regulations to be aligned with the spirit of the law, okay? And we're using certification and verification, and the statute is saying expedited review. Okay, so is that broader? And it's saying that prioritize social equity program businesses and economic empowerment priority applicants and any other class of applicants the commission deems eligible for expedited review. So I just want to make sure, to Rebecca's point, we need to be consistent, Attorney Lopez, we need to be consistent throughout the regulations, for sure, but they use expedited review. We're using certification and verification. I just want to make sure that the intent, from what I understand, the legislature was to remove barriers to access and open more doors. And are we shutting doors with a narrow scope if we have some leeway to have a wider scope?
Do you mind, you said expedited review. I'm looking at the statutory definition of social equity business. Where are you getting that language?
I can touch on that too.
Yeah, go ahead, Sean.
Sure.
Thank you.
Because I think now we're talking about three different things potentially.
we are.
So expedited review, we have regulations on who is expedited. And so as you know, but I think for the public's information, any application for licensure, and this is for licensure, is either prioritized, economic empowerment and or MTC, priority status. Those hit the queue first. The expedited review is contemplated by regulation. That's a policy choice of the commission, not a statutory requirement. It is now referenced, though, in statute in what is or would be Section 4 of 94G. That is, I believe, at least the legislature essentially adopted the commission's chosen policy of expedited review. As you know, it applies to social equity program participant businesses. It applies to independent testing laboratories. It applies to craft cooperatives, outdoor grows, micro businesses. And so I think what the legislature has essentially codified in statute is that reference to expedited review, but then also acknowledges that the commission will deem folks eligible for expedited review. So that's expedited applications. What I'm hearing too in this discussion is, I think, legitimate and appropriate confusion between what is pre-verification and what is pre-certification. Verification, to my knowledge, and I don't want to assume too much beyond this, is verification is for those communities that are evaluating whom to issue an HCA to. And is this person eligible in some way for the social equity program, either by being an active participant in the program or otherwise eligible and could be a participant, except for the fact that a cohort is not available to apply for. And so we would verify this individual or this cohort of individuals is eligible or is in fact a participant and meets that criteria. That would be the benefit of the community saying, okay, now I understand I may enter into an HCA with this business for the purposes of satisfying my own municipal equity requirements. Pre-certification is, it applies to licensure. And it's someone that could come into the commission and say, I would like to apply for a retail license in order for me to demonstrate my propensity to be licensed, and therefore either one of two things: go find capital, go find investors, maybe one of several things. Two things prominently though: go find capital, go find investors, or go find my community. And the pre-certification would, you are not obligated to have a location for pre-certification purposes. What I'm thinking is, and Madam Chair, to your point, do we use the intervening time between draft regulations and final regulations to try to both clarify the distinction between verification and we're getting hung up on that in particular. Maybe it's just frankly word change. What we have pre-certification.
We struggled with this, and I
That's
use
right.
them interchangeably, but they're not necessary.
They're not, right?
But I want to go back to Rebecca, and Rebecca Lopez, I almost kind of want you to restate your statement, because I hear you, we're talking about three things, but I think what I heard Rebecca say was we need to figure out this sort of the eligible or qualifier before we move forward, because it'll change everything else in terms of the regs. So
I can.
That's where I'm stuck on that.
Because I think the decision point for the commission to make at this point is, do you want pre-certification to apply to social equity businesses being now incorporating those that might be eligible, or do you want participants?
No, Sean, you were correcting to that point. Your breakdown is completely accurate in terms of the intentions of the working group in the current draft. Pre-certification was not conceptualized to include those who are not EEAs or SEPs. Pre-verification was, and I appreciate that breakdown that you gave. It was to be utilized by municipalities in their evaluation of host community agreements and who receives assistance that's geared towards equity. So that was the intent and the thought process around creating a separate pre-verification process. The confusion here, I feel like we can explain that. I can explain, sort of those processes and the different the different things between pre-certification and pre-verification. What I think the main issue here is around social equity business and the definition. And if my interpretation and the working group's interpretation was in fact inaccurate and not aligned with the overall intent and the letter of the law. And I think that's what Rebecca was raising. By all means, Rebecca, you can restate it. I hear what you're saying, and it made me go back and look at that as well, because the crux of that is for social equity businesses, the idea that we had at the working group was this included a universe that went beyond SEPs and EEAs and included people who may be eligible for our SEP program, but had not in fact had the opportunity to apply and be covered within SEPs, and therefore would qualify as SEPs, and we would verify them, and they would have access and be considered by municipalities as equity applicants before they reach the CCC, as the pre-certification process. So I'll take a step back. Rebecca, I'll let you kind of restate what you said earlier, and I guess we can take it from there.
Hold on one second. Commissioner Roy has a question and then.
And yeah, and I do want to hear from Attorney Lopez. It seems that there's a bigger benefit with a pre-cert has more value than a pre-verification. A pre-verification says you qualified for our programs and municipal. A pre-cert says you're a viable business, like, right? So it's more advantageous for an SEB to have a pre-cert to go to a host community because it's almost the next level.
This was what we were talking about, is that there is cost to, say, a query check and things like that, that the.
Yeah, there's no denying that, that's true, but that's not, are you asking why we?
Well, I'm just,
I guess
if the
I'm
spirit of the
trying to-
law is to cast a wider net to help more folks into market participation from those communities that were harmed, then having a pre-cert, expanding the definition for the pre-cert would cast that wider net in the spirit of the law, is what I'm trying to say, is worth more on paper than just the verification.
Yes.
That's what I'm saying.
And why can't we do that?
And why can't we do that? Rebecca?
So Rebecca, if you could respond. Because again, I don't know if we can't do that,
Pre-certification
but
is in
making sure that
anticipation of
we're-
a license. You're applying for a license when you're pre-certified. So I feel like there's some confusion about what pre-certification actually is here.
Right.
Let me take a step back. Rebecca, you can go ahead.
Sure. So I will just say, to restate, so the purpose of me bringing this up is, the purpose of me bringing up the social equity business definition is because it's foundational to the rest of what you are trying to build. So the commissioners are correct. This is a step 0 before we get to step 1, basically. And so the social equity business definition, it's the purpose of me bringing this to your attention is to make sure that you are building your policy based on a lawful application of the statute. There is room for your vision. Of course, you're the policymakers, but your vision has to be limited by carrying out the will of the legislature. And if there's not ambiguous language in the statute, then you are tied to the plain language of the statute. And in this case, the social equity business definition states that the legislature defined it as a marijuana establishment made up of individuals who are eligible or whose ownership qualify them as either SEP or EEA. And the legislature already had defined marijuana establishment as a marijuana cultivator, testing laboratory, product manufacturer, retailer, or any other type of licensed marijuana related business. So that is the limits, that's the space that you're operating in. I don't see a reasonable place, reasonable room to interpret that as encompassing a group that could qualify. And that's based on the plain language of the statute.
Okay.
So I just want to give you that before you continue to build, because it all seems to come back to that concept of what a social equity business is.
Yeah. So I will revert to my original suggestion that I think this needs a little more clarifying. I don't understand the rule. All right, so then what would be the suggested language that we should put here if we're trying to, it sounds like we're trying to ratchet back what our group thought we were doing correctly by
And that's okay.
expanding.
That's okay.
No, I know it's okay, but what I'm saying is either we have proposed language right now, or we say we need to work a little bit more on this to gain
is it the proposed language, Madam Chair, or is it the actual scope of the law?
Well, we're
I
talking
think
about
that
this,
that's where
which is-
I'm caught up
Well,
is.
then maybe I'd ask, did you have a point, Trent?
No, I think, to this discussion, and I thank you, Rebecca, for clarifying that, is basically that you can't be a social equity business until you're licensed, period.
Yeah.
And so therefore, anything that contemplates pre-licensure activities, including pre-certification, a social equity business would not, the definition doesn't fit.
That's right.
And so I think, Madam Chair, to your point, the language as I read it in the draft regulations would be therefore minimally sufficient.
But do we need clarification? And this was another issue, that sometimes the language is drafted in statute, I felt lacked some clarity, because my point here in looking at this is we talked about the business, and I said, wait a minute, if we're focused on everything that leads up to before you're a business, why are we talking about business? Because they're not a business yet. And they may or may not even be incorporated, or they may, you know what I mean?
Right.
So that's where I said that collapses in on itself in terms of the definition. So we've gone around in circles on this, and you can see we're a little dizzy from it. But it was because I said this leads up to, and some applicants are not at that they're beginning the host community process. They may or may not be incorporating, they may be doing, you know what I mean? There's a number of different things they could be doing leading up to this. So that's where I felt I was confused by the legislative language, and maybe we need to get some clarification from them. I mean, I got clarification from them on something we'll address, a little bit later about municipal impact.
I think there's two ways to react to that. One is with the lack of clarity, there is some empowerment of the regulating body to further interpret, and the commission therefore enjoys that leeway. The alternative, of course, is to seek that clarity in the legislature. And you can do both as well and say, we are interpreting it this way, but the legislation and the statute empowers this agency and this body, specifically the five of you, to interpret that statutory language. Again, but you're the policymaker. So by your vote, you're going to set that, you're going to dictate those standards that we will then implement. But you can also, again, one of three things. You can interpret it based on your comfort level. You can seek that clarity from the legislature, or you can do both simultaneously and say, this is how we're interpreting it. Does it meet with your approval theoretically? And that can be both formal and informal. The other point I'll make as
What is the formal way that you ask for clarification on
I
legislation?
would say this body takes a vote to say, seeking that clarity, similar to your legislative and executive branch outreach policy.
That's what I think we should do. I mean, again, that's what I was trying to do in that other section.
And this is a dangerous suggestion, but I think it's worth thinking about, because one of the things we're talking about as far as that eligibility question is because of the way we manage our social equity program in a cohort-based sort of chunk of time. We could take, and again, I'm almost loath to mention this or bring this up, but I think it might be an opportunity. We could, I don't want to say reimagine, we could explore our social equity eligibility program to keep that application open.
Yes.
Andrew's about to, his head's about to explode. I'm sure others in the background are similarly thinking about that, but that's a solution.
It is. I was going to actually bring it up, and
It's exactly what we should be doing.
I was hesitant to, and I was thinking the same thing. Instead of having just once a year cohorts, a lot of it can be asynchronous. It could be rolling.
It could be, it's significantly an asynchronous program, isn't it? I mean.
Yes, right. I think a lot of those concerns could be addressed if there wasn't a gap in time, which is what I think you're
Yeah.
trying to account for. And I mean, I think the comments of Councilor Lopez were quite persuasive when we contemplate the definition of a marijuana establishment, which includes language related to a licensee. So I think perhaps the definition as originally construed may work. We just need to strike out the or otherwise language.
Otherwise eligible.
Otherwise eligible that we originally inserted. Rebecca, does that address what we were speaking on?
It does. And it does, Attorney Carter. Essentially, that would keep it in line with the statute. And again, seeking clarification from the legislature is always an option available to the commissioners. I'm not sure where the ambiguity is in this language. So the law does require us to apply the plain language unless there's ambiguity. So I would keep that in mind.
I agree.
But can I ask Rebecca, Attorney Lopez, is there ambiguity when they're referencing business, when a lot of what we are addressing may be beyond business, maybe individual, you know what I mean? And again, when they said that we can expand that, that's what I'm trying to get that's right. I feel like I'm just having a hard time getting past that.
I think you're stuck on the policy, Madam Chair, because I know what your intent is. I know
Yeah.
that you want to help move equity forward, and but I think that I go back to the letter of the law. And
I just want to make sure that we have the letters right.
No,
I
right. I
feel
know,
like
I know.
we're Still a little confused on what those letters
I
are.
don't think we're confused. I don't think we're confused. I think we're confused on the policy and what direction we may want to go. I think in terms, I think, you know, you just gave us an example and Rebecca just sort of told us that we would fall into that. But I think to Rebecca's point, this is zero before we keep moving forward. And I know that this is still a conversation. So I don't know, that's where I'm at in terms of the conversation.
So how would you language this then?
I think
Yes,
just came up with it.
I think the original definition that was proposed under social equity business means a marijuana establishment comprised of at least 51% majority ownership of individuals who are social equity program participants. Earlier in the meeting, we added language or otherwise eligible. I think it would be advisable at this time, we strike or otherwise eligible, and we continue on, and it says, or who have been certified as meeting the commission's criteria for designation as an EEA, or, excuse me, Economic Empowerment Priority Applicant, or both.
So what does that do practically to the impact of what we're going to do? Or do we just go to Sean's idea?
So the way that I would read this, and one of the other lawyers can correct me if I'm wrong, but a social equity business is a marijuana establishment, meaning it holds a license that is at least 51% owned by a SEP program participant or who have been certified as meeting the commission's criteria for Economic Empowerment Priority applicants. So in that sense, I believe it is to a licensed entity as opposed to having a broad view of criteria.
Yeah.
Which I think is.
So what does that get us in terms of it?
What you want to do is,
Right.
more, I don't think what you want to do, it doesn't fall within here, Madam Chair. It's like you're thinking more policy, this is more kind of description and really defining what this is so that we can then create the policy. So for example, you guys are talking about, oh yeah, let's open up the SEP program all year round. That's like a bigger policy conversation and discussion that doesn't really pertain to this just now. So that's what I'm hearing.
I just want to put a real example to this. I had the opportunity to go out to Six Bricks with Peyton Shubrick, and under this, she wouldn't be labeled a social equity business. She'd be left out of that, right? Because she wasn't in the SEP program and she's not an economic empowerment priority application.
But she wouldn't be included either way because she wasn't eligible. So this would not include her.
Yeah, this is a bad example.
No, but I'm just saying, but the more inclusive definition of SEB.
She
Which-
wouldn't, it wouldn't encompass her
She's
situation.
not in a DIA.
That she came up in many of our conversations.
She's not,
that-
so she's not in a DIA
Yeah.
or.
Nope, and it's like the folks in Cummington, they weren't social equity either.
So this can't help her no matter what.
We'll say we yeah.
Yeah, that's not the best.
Yeah.
label.
But good point though, Commissioner.
Yeah, no, that was a topic on a number of different occasions.
I mean, we can move to adopt, the language that Andrew put together. I was trying to look for the thing.
It's in the draft. So
in the draft,
what you're
yeah.
saying is
We can,
maintain the language as drafted without the amendments that were proposed earlier in this meeting. The thing is, we will, if we're going through this entire document today, there's this impacts a lot of provisions within it. So we'll just see how that goes.
But can I ask, so if we remove that additional eligibility language, have we then gotten at what we want to do, or do we have to do that a different way?
We have to do it a different way.
different way. Yeah. But there's still a way.
Okay,
Yeah.
There's still a pathway to
okay,
it.
all right.
Yeah.
So now what do I do with this sentence?
Sure. So, Madam Chair, would you suggest that we've reached consensus as it relates to the social equity business definition and removing the inserted language that was made this morning, which was or otherwise eligible?
Yes, I agree. We have consensus. You have my begrudging consensus. I know what I want to get to. We'll circle back. All right, thank you.
We can't lose the spirit of your path.
Well, but
You
I'm
know?
just saying, I
Yeah.
think people understand, and this,
Yes.
this language was confusing, and again, when I
Yeah,
read.
this is
it,
real.
I don't think the
Yeah,
legislature.
yeah, it's real. This is complicated. This is complicated.
But I still think that we want to gain maybe clarity from the legislature. Because I hear Rebecca's plain language reading, but I still would like to know, what did the legislature mean? Because we've seen a couple different definitional issues coming from the statute that have created some confusion.
And maybe there's some stuff down the line. I mean, you mentioned that you got some
There's another one I'll
clarification
get to later.
on your
that-
own,
that-
so I
that-
think we
yeah.
got to figure out even what that,
There's
later
language
on,
that I
yeah.
came to later, the attorneys, GB and Lopez raised, I forget which, we'll get to it, but
Okay,
I had talked to one of the legislators, and they said that's not a local impact for social equity, and they said they did not mean.
we'll get there. Otherwise, we're talking about a fourth thing.
No, but I'm saying.
Yeah, yeah.
Our attorneys are reading this to the letter of the law, but I'm also saying that there may be a problem, not with how we're reading and interpreting, but maybe the legislature's language is not as precise as it can and should be, and I'd like to know the net.
Got it.
Go ahead.
Sure. There is a bit of a challenge with that, which is the statute is the legislature's will.
Right.
So that is
Right.
the document. So an individual member who voted on it may say, I voted for this reason, or I interpret it this
Right.
way. But we, as the regulatory agency, we have deference in our interpretation, so we look to the plain meaning. We also look to the legislative intent. So supporting documents, a good place to look, and it sounds very simple, is the title, right? So the title includes the word equity. I think that tells us what the legislature was thinking when they promulgated this reg. But when we say we should ask the legislature for clarity, I'm not sure what that means absent a change in statute.
Thank you, Andrew.
How have we requested a clarification on legislative intent, or what were the situations where we did that? Sean?
It was less so a question as to legislative intent and more so the example I used is actually HCA's. The commission in its evaluation early on in the commission's history noted that it did not believe it had authority over HCA's and conveyed that message to the legislature, thereby really putting that question to the legislature to say, if you believe that we do have authority, then we would ask that it be explicitly granted to us such that we could interpret it so. And in the absence of that explicit authority, we do not believe we do. And so it was a little bit of a hot potato, obviously, and here we find ourselves now implementing those or trying to promulgate those regulations. But that would be the most either appropriate and or direct ways, essentially posing the question to the legislature. You may not get an answer. The answer could be silence, in which case the commission is left to its devices to figure out a way forward. You may also, however, it could generate conversation. It could generate a path forward around a legislative change if necessary. But I think I forget exactly who remarked, but yes, to Andrew's point, actually, an individual member of the legislature cannot declare legislative intent. However, the legislature does not declare legislative intent by practice. So it's sometimes difficult. What we do in trying to suss that out is we do look at the various versions of bills that eventually become law. There's not a lot of documented testimony, but testimony is compelling as well, almost like meeting minutes would be. But again, we could pose that question to the legislature, and more often than not, you will receive silence or not a formal reaction, but it could yield discussions that could result in legislation.
Okay, all right, thank you. Okay. So re-clarify what we have consensus on.
Madam Chair, I believe we arrived at consensus related to the definition of a social equity business. And we have removed the language "or otherwise eligible," which was inserted this morning. So we are now consistent with what is posted on the website.
All right, thank you. All right. All right, so moving on. Again, the next several pages are just, typographical changes, and moving down to, this is section 3, 2 pages later. I'm just repaginating. Once all information has been entered into each section of the application may be submitted. Following commission review, the licensed applicant will be notified if the application has been deemed complete or if additional information may be necessary. Again, that doesn't really change too much. Any questions, comments? Hearing, seeing none. Again, through the rest of that page, it's all just different numbers. Moving down to 8B.
Sure, give me 1 second.
Sure.
Do you mind? Sorry, I just want to catch up. I know you've
Yeah,
been.
no, it's confusing.
It's at section 8, right?
8B, it's 2 pages after.
What section are you on? 500? Two sets of regs going on.
I know. It's, no, we're just doing the adult use now. So it is.
Let me see your page, the one that you're reading from.
This page right here, just getting to there.
Oh, thank you.
Again, it is confusing, and I do that.
Well, I have a copy on the screen and then I have a copy here, so thank you.
All right, you good?
Yes.
All right, thanks. Again, it's confusing. Documentation in the form of the most current executed HCA or HCA waiver entered into between a licensed applicant and a host community that complies with 935 CMR 500.180. And then following, in addition to this requirement, the host community shall state they've accepted the social consumption establishments. Again, that anybody have any questions or comments on this? Hearing none, again, we're going to continue to move through.
Oh,
Okay, so after that, it's 1, 2, 3, 4, 5 pages. Section 7, verification of social equity businesses.
I had a question.
Go ahead.
So there's no, and I just want to make sure I'm on the right, actually, could you mind reading it? Or I want to make sure I'm in the right
The
place.
one I went to before the one I'm going to.
Verification of social.
Verification of, all right, so I will read this. Verification of social equity businesses. Social equity businesses. An applicant may file in a form and manner specified by the commission an application for verification as a social equity business. The commission shall act on an application for verification within 30 days of receipt. Once the commission has confirmed that the application is complete and the applicant qualifies as a social equity business, it will certify the applicant's status as a social equity business. Social equity businesses certified by the commission may request that the commission provide confirmation of its status as a social equity business to a host community.
I'm fine there. It's the next paragraph.
Okay, anybody have anything on this paragraph? Nope. I'm going to be, if there has been a material change of circumstances after the submission of an application or received certification, the social equity business applicant shall revise this information and test in a form and manner determined by the commission. The applicant shall also notify the host community of a material change in its application or status as a social equity business as applicable. That section of.
Yes.
Okay.
So, I can't find my notes here, where I had it, but around material change,
Mhm.
so the paragraph before, it's 30 days of receipt, and it's open-ended on material change. There's no, they need to notify the commission, host community within 7 days, 30 days. It's just open-ended.
Mhm.
Was that by intent?
No. And as a matter of fact, the 30 days, that was done sort of at the waning days of our readiness.
Mhm.
Do we think we need to put in something similar?
I
And you
feel
know
we
what?
do.
And maybe,
but-
I think it's a good idea.
yeah, maybe Kyle Potvin, you know, if you have an opinion, and again, on the first paragraph, I put in 30 days because we had XX. And so when we were writing that, I suggested that. I would like Kyle's thoughts on, is 30 days, are you okay with that? I think that it seems reasonable, but I'd like Kyle to determine, you know, both there, and if 30 days is good, should we add that in here in the second paragraph here?
Good afternoon. Thank you, Madam Chair. I think to the executive director's point earlier on is that this is ultimately going to be a function of implementation. It's a possibility that this may not in fact lie with the investigations and enforcement licensing team. It could be a communications social equity team function. That's something ultimately, as the executive director said, that will be part of a conversation moving forward, and obviously with your inclusion. So my comments on this ultimately depend on that implementation aspect of it. Is whether, to your question, whether the 30 days is an appropriate amount of time. I think at this point it's a placeholder, but I think that further conversations, especially with the executive director and the chief of communications and the chief of investigations and enforcement, to try to determine where this may potentially land and in the sense of responsibility, can take place over the upcoming months. I think it's fine as a placeholder, but as far as the appropriateness of that time frame, I can't answer that right now. I think that requires further conversation.
again-
And I ultimately defer to the executive director if that assessment is correct.
I think 30 days, to Director Poppin's point, I think 30 days seems sufficient as a placeholder. What it's speaking to me about this language is ultimately, in the context of a social equity business, time is of the essence. And I want to make sure that we're properly prioritizing those applications so that we're not a hurdle that they have to overcome. And then how we support or staff that, it would be incumbent upon us. And then I think, Commissioner Ward, to your question, I did a quick scan of the other regulations as well to see if we put any other timeframes on material changes. We don't. So this language mirrors other sections. I hear you as far as it. We also may want to think about, and this might be guidance as well, what is a material change?
Yes.
And I think material changes for us, of course, are ownership issues, infusion of capital, new entities being introduced. Obviously, we think about suitability in the context of material change, if there's something that could implicate suitability. So in some instances, there's a sort of a work week 5-day window. There might be again, a 30-day window, but if we were to put a time frame on material change here, it may implicate other sections. It doesn't mean it's wrong. It just means that I was looking for something. Is there a benchmark we can just tie this to that's already in regulation? I didn't find anything. But I think, Madam Chair, to your point on the 30 days window, we ought to prioritize responsiveness to social equity businesses in particular.
And that's why I picked the shorter number, but I picked it.
And we can build out a reaction to that.
Yeah.
What that would take.
Just to go back, if I can.
Please.
The material change, definitely, I was like, what exactly does that mean? And we can't leave it to interpretation. So what do we do with that?
So I think, and this is, this may not be a satisfactory answer necessarily, and I'd certainly welcome others to opine or chime in. If there's something that would be submitted as part of an application that needs to be amended, that would trigger a material change. In other words, if the people you've identified as controlling persons changes, that's material change. If you're Disclosures on suitability or background check change or need to be updated, that would constitute a material change. So it's basically anything that is required as part of the application. If there's something that needs to be supplemented or amended, that would be considered a material change. If it's not something we're asking in the context of an application, so think of material changes could be, again, I spoke to suitability, individuals coming in or off the license, capital coming in or off the license, changes of address. If that's, we're moving, we see instances where the building is renumbering. We just need to, we're unit B instead of A or something.
So all that, all that you're saying right now, like, again, we're assuming that the reader and the applicant is assuming that, like, is there somewhere or is that just like an assumption, like, this is what it is?
Yeah, no, I'm speaking, I think, a little bit to the spirit of where is guidance helpful.
Okay.
And that could be, again, in the context of
That's it.
implementation.
Thank you so much.
Commissioner Roy?
For our registered agents, if they have a material change in address and they don't notify us within a certain time frame, right, then they are no longer, there's questions in there. So we hold registered agents to a material change timeline.
I don't know that I'm following. Are you referencing something specific that I can?
I'm trying to find it. So like within 10 days.
You're saying, would it pertain to them, Commissioner? Is that what you're saying? Like, is it?
All right, registered agents shall remain suitable at all times. An individual subject to 935 CMR 50802 shall notify the commission in writing of any change or conviction or an offense that would result in, okay, that's suitability.
Well, some other timeframes we hold standards to.
So.
Yes, no, so there's a few instances where we require two things. So I'm trying to think of things that we put timelines to. For instance, and I'm going to mislabel the requirement, but if there is an event, a reportable event or incident that occurs in a facility, emergency services being dispatched, fire truck shows up at your license, we've got to know within 24 hours. But then we require essentially a full report, an incident report within 10 business days. Similarly, a notice of deficiency requires a plan of correction within 10 business days. So though we have some thresholds either in practice or in regulation that have timeframes to them, but it might be based on the seriousness of the event or incident. Again, suitability is something that runs concurrent with the license. And so anything that would be updated, including charges or case disposition even, would need to be noticed to us. But we kind of have that 10-day threshold in practice, and I'm really just trying to compare it to something. But again, I think I want to be honest about material changes used elsewhere in the regulations without a prescribed timeframe to it.
So Commissioner Roy, do you have any additional suggestions or?
Well, we're putting a
something that we're
pin,
going
or
to-
we're just putting a
Yeah.
pin in it? Is that what we're doing? Okay,
I can flag that to come back.
okay.
You guys heard that?
Okay.
You guys heard that? The black.
Flag. And- Okay, are there any additional questions or comments on sections A and B here? Hearing none, moving on to C. List to be provided to the Department of Revenue. The commission shall provide the Massachusetts Department of Revenue with a list of social equity businesses 30 days within verification approval of a business as a social equity business by the commission. Hearing none, we'll move on to 500.102, action on applications. Again.
Chair, may I ask a question?
Please.
Sorry, I didn't, for number 7, I'm just wondering, if it needs to be reworked in any way, or just if we need to review it now that the definition of social equity business has changed, is it still in line with what you are trying to accomplish? Because, for example, 7A says an applicant may file an application for verification as a social equity business. Now that the definition of social equity business has changed, whatever policy objective you're trying to effectuate, that language needs to be reworked. So I I think that's something that the commissioners may want to discuss.
So how do we make this consistent? Because we've been,
Mhm, mhm.
what do we do? What is your best advice?
Sure. Well, I would say this, we had our discussion to arrive at potential consensus around the interpretation of the statute. I heard Commissioner Concepcion and now Madam Chair that this may impact pieces of your work. So I really think we may want to sit on it, honestly, and put the language out there for us to take the time to re-engage with our stakeholders, re-engage with the working group, re-engage with internal subject matter experts, and take the intervening time between filing and final promulgation to really drill down on what we're looking for.
Okay, I agree. Does any, Attorney Lopez, are you okay with that position? Because ultimately, I think we're gonna have to kind of go back to the drawing board. And I think we understand what our intent is. I think we understand that there's been some confusion about what the legislature may have meant and how we reacted to what we thought they may have meant. So I think that that's what we should be doing. And I just want to, the executive director, I don't know if you have any.
I agree with the approach, first and foremost, and I was just wanted to think out loud about a potential idea and perhaps solution, but I don't know if I'm suggesting necessarily to make that change now, which is essentially you have, and I think to Attorney Lopez's point, social equity business is a marijuana establishment, therefore not an applicant. However, in a perfect world, it could be that once licensed, a social equity business is attempting to open a second location or another license type, and therefore this language would qualify. The other approach would be that once licensed would be a social equity business. In other words, you could just add a qualifier in there that the business, an applicant, once licensed, would be a social equity business. Then this language cascades down to it. So
That's a really good
again, it's putting the pin, but there might be a.
But you understand the confusion that we went through, which is we felt that they were focused on very early stage ideas, thoughts, businesses moving forward. So I think that we can, all right, I think that we should, yeah. Okay.
Yes.
Sorry, Andrew, you're
Madam Chair, these are novel questions, right? And that is why we are engaging in this exercise for us to.
Yeah.
But can I,
Discuss
Sean,
it
do you
all.
have
Yeah.
proposed language now that we insert to the stuff?
I think you just said it.
Before, yeah, but I'm just saying, do we need to have you restate that and put it back so that it flows? So, you know what I mean? We're trying to unlock that key. And
It was a qualifier.
Yeah.
Sean, it's the qualifier. I think that sounds,
Just give me a couple minutes, I can do it.
okay,
Yeah.
I would say move on.
okay, all right,
Yeah.
thank you. And again, I want us to have a lot to cover still, but this is important. So again, I am under 500.102, action on applications for all, I didn't read this already, for all licensed applicants not subject to 935 CMR 500.102, section 1D2. The commission shall request that the municipality respond within 60 days of the date of correspondence that the applicant's proposed marijuana establishment complies with municipal bylaws or ordinances. Any questions or comments on this? Again, it was making sure we're shortening the time period within which people, within which municipalities can challenge something like this. And if they don't speak, they forever hold their peace.
what's the process here? I'm just curious.
The municipality at a certain sort of end stage of the host, they've already gone through the host community agreement. And then we basically send the letter to the community, make sure I'm saying this right, Andrew. We send the letter to the community saying, you've done what you've done. You've gone through this. We then receive it. And then we basically, it's almost like we're double checking that everything was okay, but it really is, everything's done. Am I saying that correctly, Sean? Everything's done. We're just basically, it's sort of a second check on that to make sure. So municipality should say yes, because at that point in time, you should have had everything, in place. It should be in place by then. So it was tightening that time so we don't have applicants waiting yet another month to get that approval.
Yeah.
Did I restate that correctly? I don't.
I'm looking at, Madam Chair, I know Kyle was not part of this group, but I am looking at Kyle on sort of process and licensing.
Kyle, did I say that correctly? If I didn't, please clarify.
You captured it essentially, but let me bring maybe some
Essentially,
additional,
good.
essentially. But
Nice,
if,
nice.
if I may, Madam Chair, let me, if I can bring some additional clarity into like maybe the finer details of the process, is where we are right now in the draft regulations as far as the municipal equity group, reducing for certain populations of applicants, that what is now commission policy is that once an applicant submits an application and it's been reviewed, it's gone through our due diligence process, and it's been deemed complete, which has been historical since the beginning of the commission, an interpretation of, hey, this application is compliant at this point. There is a requirement under statute to, at that point, once an application is deemed complete, essentially compliant, that we are required to notify the host community and ask about their compliance, the applicant's location, and their compliance with local ordinances and bylaws. Essentially, the key factor in that is zoning, right? So the time frame has historically been 60 days for all applicants. The municipal equity working group, under my understanding, is reducing that 60-day time frame in these draft regulations to 30 days for certain populations, i.e. economic empowerment applicants, social equity participants, and the proposed social equity business population. So it is essentially trying to get an answer quicker from the municipality as to compliance so that the process gets shortened and maybe more efficient for applicants to move through and get to the inevitable commence operations at the end of that line.
But Kyle is referencing the part I haven't read yet, which is shortening it. But Kyle, just to restate, I won't say that this is a formality, but literally by this point in time, and this is why we wanted to shorten it, is that by this point in time, things should be fairly well settled within a community. And so shortening this for equity applicants, we did not see this as a significant burden because generally by this point in time, sure, it's been laid out within the community and most of this has been completed. So is that, I'm correct in stating that, Kyle, that this is in essence like closing, basically putting the punctuation on this process after they've gone through the community, they've had those approvals. We now have the license, the application complete. And then in essence, we're doubling back with the municipality to make sure that all of that stuff, and as you mentioned, zoning, that is all complete. And so there are no barriers to this applicant moving forward. Am I restating that essentially correctly?
It is, so I have described it to applicants and licensees and other people as, yes, as essentially it's the municipality's second bite at the apple. It is a statutory requirement that we do this and afford them an opportunity to opine. But the time frame was originally a policy decision, from my understanding.
Yeah.
But you're right. It's essentially almost a second bite at the apple for the municipality to ensure the first bite of the apple, essentially, too, is the host community agreement, because that the certification of such, as of right now, is required as part of the application. So they would not be able to get to this second point unless we had that document certifying they had an HCA at this point. So yes.
Okay. All right. Thank you. Does that, okay. So continuation. So again, getting to this is more language, but I think we've got to the point of what we're trying to do. On determination that the application submitted by a social equity business for a business controlled by and with majority ownership comprised of economic empowerment priority applicants or social equity program participants is complete, a copy of the completed application, to the extent permitted by law, will be forwarded to the host community. The host community shall respond within 30 days of the date of the correspondence that the applicant's proposed marijuana establishment complies with municipal bylaws or ordinances. If a host community does not respond to the commission's correspondence within 30 days, the commission will consider the requirement to be satisfied without any further action by the host community or applicant. Okay, any questions, comments? Concepcion, I don't see you. And again, on the next page, these are, sort of numbering or lettering. And the next page, there's nothing. And then this was one, section 4, expiration and renewal of license. The marijuana
Madam
establishment.
Chair,
Go ahead, sir.
I'm sorry to interrupt. I just wanted to raise, and I apologize if I'm missing something, but back under 2 where we just were, it states the host community shall respond within 30 days of the date of the correspondence that the applicant proposed marijuana establishment complies with municipal bylaws or ordinances. Should it say complies or does not comply?
Yeah,
Okay.
yes,
Well,
yes,
do we have consensus on that one?
yes, we do.
Okay, I'm tossing it in.
All right, I'm welcome. Thank you.
Toss it in there. Big salad,
You hungry, Andrew?
Oh, I can wait.
big salad.
All right. All right, let's
Stay a step
get
behind.
through this. All right, so again, we're looking at section 4, expiration and renewal of license. The change, okay, so the marijuana establishment's license as applicable shall expire 1 year after the date of issuance of the provisional license and annually thereafter and may be renewed as follows. Unless an action has been taken based on the grounds set forth in 935 CMR 500.450. And the change here is no later than 90 calendar days prior to the expiration date, a marijuana establishment shall submit a completed renewal application to the commission in a form and manner determined by the commission, as well as the required license fee. Again, I believe this is extended from 60 to 90 days to make sure that those renewals of licenses are done correctly.
Madam Chair,
Yes,
do you mind
Commissioner.
restating where we're looking? I think I got a
Yes.
little lost in my draft.
Yes, so it's about 4 pages past what we were looking at, and it's expiration and renewal of licensure. It's section 4, kind of 2/3 of the page down.
Got
And
it.
it's basically just changing from 60 to 90.
Okay, thank you.
Go ahead, Commissioner Wright has a question.
Mr. Executive Director, can you explain like how this impacts the notification process on our end? Because don't we remind folks of renewal?
So yes, we remind folks of renewal, and I'm sure Director Potvin has far more specific facts than I do. I believe it's at least 120 days and every 30 days thereafter, including, I think the portal itself opens up 90 days prior to the expiration date. The application must be submitted within 60 days of expiration date. So we would continue those notifications. And those notifications, to be clear, are automated from the Mass CIP system. And then there might be instances as well as folks get closer to the expiration date that we would do some manual outreach through Kyle's staff as well. So
In light of that, should we open the portal earlier versus 90 days?
I believe that we'd likely have to. That'd be a change through our software vendor, JD Software.
Okay.
But there's nothing we have to do in terms of this language. No.
No.
Okay, all right, okay.
I don't want to throw a wrench, but it's not a
Oh,
wrench.
go ahead.
It's not a wrench. It's not a wrench. It's just more, I'm just thinking, Commissioner Roy, to your question, this is coming down the line later, but does this impact the 90-day clock somehow? So I don't know. I'm thinking, okay, all right.
All right, so we now are moving all the way about 100 pages to help me where we are. 'Cause I know where I am, but I don't know if I can direct people. It's basically about 100 pages.
Yes, 935 CMR 500.170.
500.170 municipal requirements, yes.
No, you meant 105.
Did I
100,
miss?
105.
Skip 105.
Here.
Operation requirements for marijuana establishments.
Page 187 of the board packet.
All right, here, do me a favor, just leave me that.
Highlighted.
Do people have this 500.105 general operational requirements for marijuana establishment? Oh, I thought, this just repeats, okay. A policy for the immediate dismissal of any marijuana establishment agent who has one, diverted marijuana. I won't read that. 2, engaged in unsafe practices, and now getting to 3, been convicted or entered a guilty plea of nolo contendere, or admission to sufficient facts, and taking out the word felony, drug offense involving distribution to a minor in the Commonwealth, or a life violation of the laws of any other jurisdiction. Anybody have any questions or comments on that? Do you have? Nope. Okay. Commissioner Concepcion, you're good. So we are now
I'm
moving
still
to-
going through my pages, but I know the section you're on and I don't have any questions on that.
Okay, all right. Again, it's like another 100 pages. So it's 500.170 municipal requirements, and I'll give people time.
Yeah, I gotta figure out where you.
It's like
If
about
anybody has the board package open from 2 weeks ago on your screen, it's page 203.
Oh, thank you.
I have both, but just in case, it's page 203.
It's funny. I'm a paper person, so usually
Yeah,
I
I'm a-
prefer to
No, me
look at the
too.
paper.
I got,
No, but
got both.
you, okay, after lunch, I'm gonna get on there.
I'm gonna send it to you on a chat. All you gotta do is open it.
Okay, great, thank you.
There it is.
No, we can,
Trust me, I know.
yeah.
It's a pain in the ass.
Commissioner Concepcion, I see her light dawns. I love it. I love when light dawns. You're so responsive.
I got to the page.
Good news or solutions.
Chair, I'm sending it to you now. It's really good. It's easy. Kim, I'm gonna send it to you as well,
Oh, okay.
Commissioner. Joy. I just sent it to you guys in the chat.
Do you want, can you send it to every?
I just did, yeah. Bruce already has it.
Long week. And you said it's 2:38?
Mm-hmm. Commissioner Concepcion, I'll send it to you as well if you need it.
Yeah, I mean, I have my notes on the hard copy, but it is easier.
I
to-
have it, Commissioner.
Okay.
Okay,
There. I don't know where it is.
all right, give me that, I'll find it. Just, it's pages, it's like 100 pages.
Is this it?
Here, there you go,
Am I there?
that's it. What, 70? Yes,
Yeah.
that's it. Okay, are we all here?
You don't want to say.
I'm not there yet, but yeah, I'm gonna keep focusing on the paper and then I'll get there. Okay, so now 500, are we all on the same page, literally? Good. 500.170 municipal requirements. 1, marijuana establishments and marijuana establishment agents shall comply with all local rules, regulations, ordinances, and bylaws. Nothing in 935 CMR 500.000 shall be construed so as to prohibit lawful local oversight and regulation, including fee requirements that does not conflict or interfere with the operation of 935 CMR 500.000. Any questions or comments on that?
I just want to comment, just take a pause for a second to just say, good job on the HCA. I know it wasn't easy, but I could tell you guys thought through and it was very thorough. So I know it's a lot, but thank you.
No comments or questions. Moving to 500.180, host community agreement requirements for licensed applicants, marijuana establishments, and host communities. Okay, I will read this section, but I may pause. This section is governed by Mass General Law, Chapter 94G, Section 3D1 through 5, as amended by Statute 2022, Chapter 180, which went into effect on November 9th, 2022. Pursuant to Mass General Law, Chapter 94G, Section 4A, the Commission is authorized to review, regulate, enforce, and approve HCA's and to develop a model host community agreement. Everyone is in agreement that that is clearly stated and understood. Section 2, general requirements for host community agreements. The Commission shall review and approve each HCA as part of a completed license application and at each license renewal. The parties to an HCA relative to an application for licensure are a license, applicant, and a host community. The parties to an HCA relative to an application for renewal of licensure are a host community and a marijuana establishment. Again, on that part, no questions and comments as to who the parties are. A, A licensed applicant seeking a new license to operate a marijuana establishment or MTC shall negotiate and execute a compliant HCA with the host community unless a compliant HCA waiver has been submitted pursuant to 935 CMR 500.1085. A compliant HCA or compliant HCA waiver must be submitted in order for a license application to be deemed compliant pursuant to 935 CMR 500.102. Again, I may waive the reading until I get down. Are there any questions here through C? Each applicant, each of the parties shall ensure the HCA satisfy the following minimum acceptable requirement. I think that this is just teeing up language, so I don't, okay.
Madam Chair,
Please.
I just wanted to note that the language in 2A, the second sentence, a compliant HCA or compliant HCA waiver must be submitted in order for a license application to be deemed complete pursuant to 935 CMR 500.102, not compliant. It should state complete.
Thank you. Okay, thank you for pointing that out. Okay, so now we were coming to the minimum acceptable requirements. Section 1, thank you, Rebecca. The parties shall ensure that references in an HCA to a licensed applicant or marijuana establishment are consistent with both the business entity name certified and recorded with the Secretary of the Commonwealth of Massachusetts and the business entity name stated either in a licensed applicant's license application or on a marijuana establishment's license record as maintained by the commission. Questions, comments, feedback? Hearing and seeing none. Moving on to 2. The parties shall ensure that HCA's set forth all of a host community's conditions for allowing a marijuana establishment or a licensed applicant to operate in a community. No host community may impose an unreasonable condition or term that is unreasonably impracticable in an HCA. A condition may be presumed reasonable if. Anybody here? Keep going. A condition is required under a host community's local rules, regulations, ordinances, or bylaws. The condition has been deemed necessary to promote public safety by the chief law enforcement authority in a host community. C, the condition has been deemed necessary to promote public health by the chief public health authority in a host community. D, the condition is a local requirement customarily imposed by a host community on other non-cannabis businesses operating in the community. E, the condition is required by law. F, the condition does not conflict with other laws. Or G, the condition is otherwise deemed reasonable by the commission based on particular circumstances presented by an HCA or contracting parties. Right, I'm going to pause there. Any other questions?
I don't know if I'll answer my own question, but unreasonably impractical. I don't know if we've defined that somewhere else.
We do.
We did, right? Okay, that's what I thought.
It's a statutory.
Statutory term.
Yeah.
Thank you so much. Okay, that's what I thought.
And again, I hear what you're saying, and I was thinking that, but again, we've said what's reasonable.
Yeah, yeah.
If it doesn't fall under there, then
Yeah.
we assume that it's
Yeah.
not.
I read these things like 5 times.
Yeah,
and
yeah,
I have
no.
notes.
But
I just had one question, maybe for the working group, if appropriate, which is, we say that the condition has been deemed necessary to promote public safety by the chief law enforcement authority, and then we also reference the chief public health authority. I'm just wondering, like, if we're thinking about the chief of police, for example, maybe we should just say chief of police, because oftentimes the chief reports to the mayor, so is the
the
mayor.
only thing I'll say is some communities have police commissioners who are the
Yeah.
top and not a chief, but that's not
Yeah.
all.
So I wonder if,
That would be my only response. I don't disagree with
do we want criminal law enforcement, just so there is?
I don't know.
I mean,
I think that the term is clear. I can't see where
right.
anybody would understand it as either the police chief or the police commissioner, and
Mhm.
that's,
That's fair.
I mean, I'm willing to entertain that, but I think that it's clear. I hear what you're saying. I hear what you're saying.
Can I ask,
Commissioner
what is,
Concepcion.
I just wanted, Sir Counselor Carter, I just wanted to ask you, what is the risk? I'm trying to think of, bring me into your mind. What are the things that we're trying to avoid by making a change here?
Yeah, I know. It's
Yeah,
exciting. This is like, what's that movie with John Malkovich? Anyway, go.
I guess my thought is to avoid confusion on the municipal level. So one of the ways that we've thought about HCA's right was through the context of the contracting authority, because that is different from town to town to town.
Right.
So municipalities have to read this and they have to be able to understand that. So we also have the ability to issue guidance if there is feedback that it's not clear. But to say chief law enforcement authority and then chief public health authority, we are not expressly stating who we believe are the ones who can opine and say that this is deemed necessary.
Commissioner Concepcion, I mean, is this something that guidance can clarify?
It certainly could.
Is it just language, Andrew? Because I know what you're saying.
Yeah.
I understand what you're saying. I'm trying to place that into the reality if this is in fact, if there would be confusion here by the municipalities. And I guess I welcome any other input from, Kyle, Rebecca, Commissioner Roy as well, in terms of your thoughts on this.
I have a question.
I'm comfortable with the terminology. If there is room for clarification, maybe we can do it through guidance.
I have a question more on the process when ready.
Go ahead.
Yep. Commissioner Concepcion, I'm sorry.
No, I see Kyle. I just wanted him to offer his input
Kyle,
on this before we go forward on anything else.
Yeah. Oh, okay.
Are you okay with that, Commissioner Camargo?
Sure. No worries.
I just wanted to give some context of why I think our working group and we made these types of statements, like Commissioner Concepcion was saying. We have 351 cities and towns in the Commonwealth, and there's different governmental structures amongst them and ways that they can function. And I think so we wanted to keep it open-ended, so not to close our opportunity to say the chief of police in the case of the law enforcement, in the sense of, for example, Boston, that has a police commissioner. That I think that can arguably be said, and I think the city of Boston would arguably make that argument that the commissioner is the head law enforcement officer in Boston. So we didn't want to unintentionally close our ability to seek the appropriate answer from the appropriate municipality based on that municipality. Because overall, this is an agreement between the municipality and the applicant or licensee. So we can interpret that. And I think Commissioner Camargo and I maybe reading where I think you are going as far as process on this is, how do we determine that? How do we know that, right? And as we will get further down into the proposed HCA regs, is that when we see a host community agreement and we see maybe an element or a condition that leads to public safety, we will have to ask ourselves as staff is identify the municipality. Who can we figure out on our own who the chief law enforcement officer is? And if we can't, we, as proposed, have the right to reach out to the municipality and ask them. Mm-hmm. So we can definitely confirm that information. Mm-hmm. I don't know if that's where you were going, Commissioner Camargo, but I thought I'd get that context as well.
May I?
Please,
Yeah. Yes. So Kyle, yes, thank you. That's part of my brain. The other piece was just sort of where it says a condition may be imposed, right, or put on in terms of these examples A, B, C, D, and E, F, and G. Is the process there? I know the condition says may be, right, and at the end it says if. So this is just, I'm just trying to think. I'm sorry. I'm literally trying to think the process. This is only if public safety or public health, like basically it's an option for public safety and public health to sort of put a condition, right? In this, like if they feel like it. Okay, all right. That was it. So I was thinking of who and then how and why. So thank you.
So, but also in my head, I just realized you might have been thinking like the chief legal counsel, or you know what I mean, that there could be some confusion, but.
Yes, but I mean, it sounds to me like the board has consensus and it's
Yeah.
comfortable with the language.
I think that the communities, they're opining on a public safety plan, right? And they have to check, and basically
Yeah.
that's what they're doing. It's the alarms, it's how does this connect to emergency fire and police? And so so I think it's pretty clear that if you're looking at basically response to crimes or potential emergencies, that comes under the police chief or the police commissioner. So I answered my question. I was like, oh, I see where that could be confusing, but I think that we're comfortable.
Yeah, I think we're good. I was just gonna say, these are conditions stipulated within a host community agreement. This doesn't necessarily mean community impact fees.
Mhm.
And I didn't want them to get conflated. This is a condition, like whether it's security plan, alarms, it's not necessarily a CIF.
Right. Yes, it's what you tell them you want them to do if they're gonna conduct business in your community. Hey, are we good? Any questions or comments? Nope. Okay, moving on to number 3. I have this, the parties shall ensure that HCA's include a statement of all stipulated responsibilities between a host community and a licensed applicant, or between a host community and a marijuana establishment, including but not limited to the following: a provision requiring a host community to annually transmit its invoice of alleged impact fees to a marijuana establishment within 1 month of the anniversary of the date of a marijuana establishment received. Is it having received?
Having
Having
received, I think we'd have it in
Having
there.
received. It's of the date of the date of the date, wait a minute, I may be adding within 1 month of the anniversary of the date, it's not. A marijuana establishment received final licensure. I misread the words going up to it, and so I got that, sorry. Only because this is my first opportunity to really have these conversations. Can we just talk about how this practically works? And maybe I'll get through talking about the invoice. How do we, well, maybe I'll just keep going. We'll keep going, then I'll ask the question again. B, a provision explicitly identifying any generally occurring fees to be charged by a host community. Generally occurring fees are customarily imposed on other non-cannabis businesses operating in a host community and shall not be considered an impact fee, e.g. routine water, property tax, sewer, trash pickup, etc. Commissioner Roy.
So I have a question for the working group, which on A, so in statute, it's a public document. So annual renewal, okay, should be public record. So is it just the host community agreement that's public record, or is this invoice of impact considered public record as well? Legal counsel?
You're on 3A, Commissioner?
Yes.
Yes.
Commissioner Roy, I guess I generally would defer to most likely Andrew Cotter or the executive director on this. Andrew Cotter being our public records officer. But I guess I could probably maybe start us off with the fact that regardless of any statements in our regulations, public records law is a law that is applicable to us and therefore has its own structure and exemptions and exceptions that would have to be complied with regardless. But I ultimately defer to the executive director and Andrew.
I could try. This is my public records pop quiz, maybe. I believe I'm reading the statute now. Thank you, Commissioner Roy. And for me, as I read it, it references the documented costs are a public record. Those two things are contained in the same paragraph. And so I would argue, therefore, that documented cost is indeed a public record in addition to the HCA. Now, granted, I think any community could, how they manage their public records would be their prerogative, certainly. But as this is now a statutory clause that in fact deems it a public record pursuant to the public records law, and it does speak explicitly to the cost in that documented the documentation of those costs,
Yeah.
that would be the public record.
So my point is, I know it's in statute and I know there's public record law.
Mhm.
But do we have room for language to say that in here, that this shall be a public record?
Sure.
Can we add language in here at this point?
What I would, if that is the commission's desire, what I would recommend is that you explicitly reference that statute, but not create a new standard of, the
Right.
commission is not in a position to deem things public records or
Right,
not.
that's
But the statute has,
reference it.
and so I would reference that specific clause of 94G though.
And is this the appropriate place to do it? I think it might be. I would, if the commission agrees, I would like to put a reference to statute that it is public record.
Commissioner, may I offer a suggestion?
Yeah.
Please.
Since this concerns the invoice that is part of the community impact fee process, it might make more sense to put it in the community impact fee section. Because
Okay.
this section is about the HCA's, the contract, what can be in, what can't be in. But I think that that's what you're trying to do, kind of that restatement of the public record component, could fit well in the community impact fee section.
Okay, perfect. Thank you.
So how do we facilitate?
We can just revisit that topic.
At that time,
Okay.
at the CIFs.
Okay, all right. Everybody good?
Yep.
Okay, moving on to 4. The parties shall ensure that HCA's include the following information. A, the specific marijuana establishment license operations permitted under the terms of the HCA, the name, signature, and title of the individuals authorized to enter into HCA's on behalf of the host community as a contracting authority. C, the name, signature, and title of the individuals authorized to enter into HCA's on behalf of a licensed applicant or a marijuana establishment as an authorized representative. D, the dates of execution by both parties. E, the effective date of an HCA. And F, the duration of an HCA. Any questions on this section 4? Hearing and seeing none, moving to 5. The parties shall ensure that HCA's provide clear, specific terms regarding a host community's assessment of a community impact fee, if applicable, including but not limited to a provision requiring a host community to transmit its invoice of alleged impact fees to a marijuana establishment within 1 month of the anniversary of a marijuana establishment's final license date. Any questions?
Yes, there
on
was
that
a question
section? Yeah.
proposed to the group.
Yeah.
There was some wordsmithing and proposed language to replace alleged with,
Yeah.
I think, proposed. So I just want to run that by the group.
Go ahead.
Yeah, no, I think that's my question. And it's referenced earlier, and I think going back under section 2. Again, it's wordsmithing. The terminology around alleged sounds like
Yes.
we're not trusting
Yes,
the
exactly.
authenticity of
Yeah.
what's being invoiced. So I don't know if. we
Could I,
use
could I
the
gain
word
consensus? I think
Proposed.
this is easy. Can I gain consensus that we put in proposed as opposed to alleged? There?
Can I just ask before, because I do agree with Commissioner Stebbins, but I just want to make sure there are no like legal implications around changing that terminology. So I'll ask our counsel there, Andrew Carter.
Answer.
Thank you, Commissioner. What I would say is this, it's a little difficult for me to opine off the top of my head as I did not include the word alleged. So what my commitment to you is we will make the change, but I will also follow up with the drafters to see if there's implications. But I may also call on my colleague now, Councilor Lopez. If you have any perspective or insight, that would be very helpful and appreciated.
Thank you so much, Attorney Carter. I just wanted to add, I think proposed might lose the essence of what this clause is trying to convey. So understanding that alleged is not a word that is preferred, absolutely, you as the policymakers may choose a different word, but proposed sounds like the town is suggesting these are my impact fees. So maybe another word could be asserts or reportable. rather than making it appear as if the town is asking for permission to, have its impact fees be considered and certified as CIFs. The town is making a claim. They're claiming these are my impact costs.
Claim.
So it's really about capturing the claim element. So alleged, absolutely take that out, but replace it with the word that captures the claim
Like claim.
assertion
How about
issue.
claims?
Wait, I have a, statute uses the word documented.
Yeah, but we're I hear you.
Statute. So.
If-
Transmit invoice, documented impact fees.
If I may, Madam Chair,
Yeah, please.
Commissioner Roy, yes, it says documented, but as part of the working group, we interpreted it, and I definitely defer to you and Commissioner Concepcion on ultimately what I'm about to say. But as we get further down, we, as a working group, did ultimately through you propose an additional process of verification and certification of community impact fees, which was maybe not necessarily required by statute, but it was a policy decision where we as a group did go down. Based on the fact that we went down that, and as we're going to go to it, and part of that proposed process says we as a commission or as commission staff may say that what you are documenting to us is not what we will certify. So the terminology there, as far as being part of that process, and I agree with everything that Rebecca said, that I don't think the appropriate word is documented because of our additional steps in making this process and proposing this process through you. I think there has to be some terminology that says you're going to send us something we may not agree with you. Therefore, we want to make sure it's clear that it's maybe not alleged but claimed.
I just say, can I?
But it's not.
Claimed, I think claimed might be the word, that they're claiming it. See, when I look at the definition of alleged, it says of an incident or person said without proof to have taken place or to have specified illegal or undesired quality. It's that.
Negative connotation.
Yeah, I think it's the negative, but would people think that claimed might be a good, that they're claiming, they're asserting, claiming,
What do commissioners?
So,
your stuff, let's give us a word. Come on.
And I appreciate Director Potvin and Council Lopez's come. So I think the first place it pops up, which kind of caught my eye, was going back to 3A. A provision requiring a host community to annually transmit its invoice of alleged impact fees. If we just, and again, it may vary as we move further into the process, I think to Director Potvin's point, but if we start there with a provision requiring a host community to annually transmit its invoice of impact fees. It's essentially saying, here's your bill.
I do think you need the word claimed or asserted, because again,
Yes.
we're going to, there's going to be a determination
Mhm.
that they're going to say, yep, we're saying this, and then there will be an approval or verification that they're valid.
I agree.
I like asserted or claimed, I mean, let's take.
I like asserted or either one, but
Yeah.
I agree with you, Madam Chair.
Audience? Oh, no, I best gift I ever got,
I'm comfortable with claimed.
yeah, I kind of like claimed better because, yeah, assert, state of fact or believe confidently and forcefully. Oh, so but claim, I think it's almost their opinion, because they maybe, I mean, I don't know. We take a vote on
I'm okay
claim
with
versus
claim.
asserted. I know it sounds like a silly thing, but.
Executive Director?
I just want to look at, all right, so here, a claim is an assertion of the truth of something, typically one that may be disputed or in doubt.
Going with claimed.
Yeah.
You,
A demand or request for something considered one's due. Are we okay?
I'm okay with claimed.
Best gift I ever got was a thesaurus. Are you good with that? Okay, all right.
Declared.
Can we go?
Declared. Surge claimed.
I just think claimed is they are saying, we want this, we think we deserve it, and then we have to determine whether or not that claim is valid.
We've entered it in.
Okay, all right, thanks, sorry, that's, no, I know it sounds silly, but then you put it here and then you put it in that next.
Madam Chair, it's in.
Very
Very slow. It's perfect.
They put it in the Bible. This is like the reg Bible right there. It's an egg, but it's also.
Yeah, the word alleged pops up a couple other
Yeah.
places.
So is the consensus to remove them?
I just
The
think that
alleged.
claimed is the
Insert.
synonym for alleged that lowers the kind of negative or legal connotation.
Okay, perfect. We can make that change.
Are we good? Again, I know that this is like silly wordsmithing, but that's what you get paid for, silly wordsmithing, so. All right, so we're back at 4. I think I went through 4, okay. Yes,
5D.
5. Now I'm on D, okay. So I'm on 5D, yes? Yes, the parties may include a clause in an HCA whereby the parties voluntarily agree to bring HCA disputes before a private mediator retained by the parties. Neither party may unilaterally compel private mediation. I think that makes sense. Okay, approval of HCA's may be conditioned on a host community being in good compliance standing with the commission relative to any HCA to which the host community is a contracting party. Can you just explain, I think I understand it, but I'm not sure, is that we're saying that if the host community does not have other compliant HCA's, we're gonna open it up for everything? Okay.
Yes.
And we'll get to more of that as we go further along in the HCA provisions also.
All right, great, thank you. All right, moving on to F, the commission may deem a provision of an HCA invalid and therefore unenforceable based on a finding that the provision violates Mass General Law, Chapter 94G, 935, CMR 500.000, or 935 CMR 501.000. The commission may also declare an HCA or a provision of an HCA voidable upon deeming the HCA as a contract of adhesion. Having been out of law school a long time, I know that you have worked on this. Can you just talk about what a contract of adhesion?
Where there's an unfair playing field where one party has much more power over the other party and you can't negotiate fairly.
So we would determine that this is a contract of adhesion. Would we make that determination? That it was an unfair balance, parties not equally coming to a meeting of the minds? Is that what you're saying?
So the legislature has granted us the authority to review, regulate, enforce, and approve.
Yep, okay, so, okay, but I'm saying we would be the ones who would declare.
We
don't think
can
that
call
this
balls
was-
and strikes.
Okay, all right,
Yes.
okay, good, thank you. And again, I think it's also clarity for people listening, because this
Yes,
is going to
yes.
be kind of, yeah, go ahead, Commissioner
I
Carlo.
could go back to D,
Mm-hmm,
5D,
D, yep,
can you just elaborate on that a little bit?
voluntarily.
Either party, the unilateral.
Because I think that some communities were not allowing there to be.
Yeah, so some of the HCA's wouldn't, there was a lot of them. There were a no challenge clause. And if you were to challenge any provision within the host community agreement, you would lose your standing with that host community. So that's impractical. That is a contract of adhesion, an example of it. So we're putting here that both parties have the right to seek mediation. They also have the right to go to a court of competent jurisdiction,
Okay.
and that's not preempting that. This is just another means.
So it's just like with any contract, but it's making sure that the playing field is level, and historically, this has been a,
Yep.
That- The other element of that, I just want to add an additional context to this, because we have reviewed a number of different HCA's that were worrisome, is that it was a unilateral thing where the other party, the licensee, was forced into a private mediation without being able to come into that agreement on their own accord. So this would mandate that both parties had to agree to that being the way to resolve any disputes. Like regular, other contracts have this already in place, but our HCA's would cover that as well.
I appreciate that. And parties can still go to court and sue each other.
Yes, that,
We're gonna
that's
get-
what's.
We're gonna get in dispute settlement
Putting that back.
further in this document. We're
Okay.
gonna go through that.
Good. All right, so we're on G now. G, we're good. The commission may decline to approve an HCA on the basis of any other ground that serves the purpose of Mass General Law, Chapter 94G, 935 CMR 500.000 or 935 CMR 501.000. We're good?
Sorry,
That's okay.
I gotta go back. I think, give me 1 second. So under 5D, complaint alleging non-compliance. Parties may clause in HCA which have to agree to. No, I'm sorry, wait, this is another section. Give me 1 second. It's just in my notes, but I just had here if the complaints alleging non-compliance within 935 CMR 500/180. I had it under 5D, but maybe another
I
section.
think it's another
Is
section.
another section?
Yeah,
Okay,
yeah.
because you know what my question is?
I have your, I have it.
Okay.
Yeah, I have the questions.
It's just about that is still donations to nonprofits. So I just want to make sure I don't miss.
Yeah, I.
Yep.
We're going a little quick, so,
Yep.
thank you.
All right, we'll get there.
Yeah.
Thank you. All right, H, a marijuana establishment that seeks a name change or location change pursuant to 935 CMR 500.104 subsection 1 must submit respectively a new or updated HCA in a form and manner determined by the commission. Upon submission of a change of ownership request for the transfer of license, an applicant may propose a name change with the application submission. If elected, an applicant must submit an amended HCA. Any questions, comments? Hearing and seeing none, move forward. And I, prohibitions. 1, no, like, oh, go ahead, sorry.
I have notes, so I just want to make sure, because I know this is the opportunity for us to get it out. Back to G. The commission may decline to approve an HCA on the basis of any other ground that serves purposes, blah, blah, blah. So the commission may decline to approve an HCA. What's the process afterwards? So
They would have to amend the HCA, right? They have to amend the HCA.
Okay.
The-
Is that-
If it's a contract that is deemed something that we don't think is enforceable or meets the public,
We don't have to define that in here, though, I guess is my question.
well, we kind of have, we kind of
Okay,
have
okay,
defined that
okay.
here.
Okay.
Referencing the
Yeah,
regs.
so, but again, there will,
Thank you.
yeah, okay, all right, okay.
It's a lot of reading. I'm
Yeah.
sorry.
No, you.
I would just note that that particular G is sort of a catch-all.
Okay,
Um,
okay. Thank you, that's helpful.
Good, thank you. I, prohibitions. 1, no licensed applicant marijuana establishment or host community shall enter into an HC that includes a promise to make a future monetary payment, in-kind contribution, or charitable contribution. A licensed applicant or marijuana establishment may voluntarily provide organizations with monetary payments, in-kind contributions, and charitable contributions after executing an HCA, as long as the licensed applicant or a marijuana establishment's actions are not performed because of a condition imposed by a host community, whether explicitly or implicitly. So this is where I
I have a question on this too, the explicitly or implicitly. I'm curious as to how we charge that.
So, well, can I, my original question is, we allow charitable contributions to be made when we're approving a license. So can you just explain to me, because this is also maybe wrapped up in some of the other things that we were sort of looking at in terms of, what, this is strictly from the statute, but
Statute,
we
yeah.
still allow that. For meeting
Yes.
our positive
But
impact. But we don't let, we're just
it's
saying.
not mandated, it's an
No, no, no,
option.
But as an option. So what you're saying is like that, like we say, it's an option that a charitable contribution, but we can't say you have to give it to Father Bill's place if you want a licensing place.
How is Father Bill's place reasonably related to?
Wait a minute. Wait a
the
minute, wait a minute.
operation of a marijuana establishment or,
Okay.
right?
Okay,
So-
yeah. no,
Can
no,
I
no,
It's in
jump in on
statute
this
too,
one?
But it's in statute.
Go ahead, Commissioner Concepcion, but I hope you.
So the language also still permits a charitable contribution. It's just not compulsory. It's not
Right.
under the direction of a municipality. And that I won't go so much into detail about past practices of what has happened, but it needs to be at the choice of that entity or licensee, the same way that we promote and encourage charitable contributions. We don't designate where that has to go or how it should be done.
But this, I think, gets to your question, which is implicit or explicit.
But I think we're also encouraging donations that may not have anything to do with anybody's positive impact plan.
Yeah.
So I think we're allowing the space for that.
Well, I'm reading directly from statute. The community impact fee shall not include any additional payments or obligations, including but not limited to monetary payments, in-kind contributions, and charitable contributions by the ME or MTC to the host community or any other organization in statute.
Okay, but we're just saying this to the municipalities, but when we are taking the bigger picture look in approving an application, we allow them to make reasonably related contributions to charitable events as long as it, yes, okay, all right.
We're not saying that, I'm sorry, we're not saying that to
No.
municipalities. This is about
No,
licensees.
no.
Okay.
I'm just saying, we're getting very explicit that they can't mandate that. If they want to do it, try to, because in order to perhaps get us to approve their positive impact plan, they may say, I would like to contribute to the local drug rehab center. And we can approve that as part of the positive impact plan. But we're saying as part of you negotiating the contract, that can't be one of the provisions that you mandate. I just want to make sure I kind of understand that. I think it's a
I
little.
just want to, Commissioner Concepcion, you said it could be, but it can't be compulsory, but it
Yes.
can't be. It can't be, even
Well,
if it is agreed upon.
No, so I'm not saying that it cannot be a part of a condition of the contract, but our language here states that after that HCA has been executed, the license applicant or ME, they can in fact contribute to have a charitable
That's what you're saying.
contribution.
Okay, I
That's what I'm
misunderstood
saying.
you. Yes,
But
I
no, but
misunderstood.
this is what I was trying to get. We can't, the municipality no longer can do that.
You can no
Right.
longer do that.
However, that's part of gaining the HCA. In order to come to us for approval of their license and they put together a positive impact plan, we determine whether or not it's suitable, related, whatever. If we determine that Father Bill's has maybe drug rehab or something like that, that we could include that in the positive impact plan. We're just saying as a part of that negotiation of your contract on the local level, you can't do that. We're just taking that out.
That's right.
Yeah.
Okay.
Madam Chair, I would
I just
even
wanna
go
make-
beyond that because yes, it can be done to satisfy a positive impact plan, but any licensee or ME, if they want to make a charitable contribution, by
Yeah.
all means, they have the ability and the freedom to do so, even if it's not to satisfy our requirements for positive impact plans.
No, but I just wanted to make the distinction of the different levels of approval and,
Right.
and at the local level, can't do it. Coming to us, there are options where they get credit for
Mhm.
making a charitable contribution, but it's part of our licensure approval process. That's all I was just trying to just sort of.
And
What I'm trying to clarify is that at the local level, after they have an executed HCA, before they're even licensed by us, they can still go forward and make charitable contributions. So I don't want there to be confusion about
But
having
no
to wait
relation-
until you get to us.
But
Yeah, no relationship.
No relationship to the negotiation of the contractual. Yes,
That's
okay, sorry.
So-
Again, and I
You're
hope
right,
I
you're
didn't
right.
make it more confusing. Sorry.
so I want to go back to the last part and I appreciate the conversation and making it clear that we're not, I think to Commissioner Concepcion, on your point, somebody may make a donation as part of their positive impact plan. Somebody may make a donation because they're just being a good neighbor. I want to go back to the last piece of this, which says, as long as a licensed applicant or marijuana establishment's actions are not performed because of a condition imposed by a host community. We understand that part of it is verboten. But it's the enforceability question for me around the last piece of this is whether explicitly or implicitly.
Mhm.
So are we reading that from the HCA, or is it a case of a licensee comes to us and says, gee, you know, the mayor kind of pulled us aside and said, make a donation, not written anywhere. It's a he said, she said story between two parties.
Mm.
I want to make sure that that last piece has some enforceability to it, some logical
tell you,
enforceability to it.
I'll tell you my read, and then I see our enforcement counsel, Rebecca Lopez, raising her hand, and I'll kick it over to her. But my read is that it for the implicit language, it's based on a totality of the circumstances. So you would gather that information and make a determination based on all of information that is provided and accessible. But Rebecca Lopez, I'll let you also offer your opinion.
Thank you very much, Commissioner. I agree with you, and thank you for the question, Commissioner Stebbins. So essentially what this last sentence is doing, and the regulations, you know, we can't always lay out the framework for every last eventuality, but what this last sentence is doing is it's taken from the statute and it's setting the table for us to hold a town accountable if we are to learn that there has been a condition imposed outside the four corners of the HCA. So in terms of enforceability, the way this would likely come to the attention of the agency would be a complaint to the enforcement department alleging that the host community has imposed some condition outside of that document. And then our enforcement department would follow the standard custom of investigating that complaint, that allegation, and seeing if, opening an investigation if appropriate. So that is how it would likely be enforced, is through the complaints process.
Okay.
Thank you.
Yep.
Okay. Are we, all right. So getting down to prohibitions 2, a contractual financial obligation other than a community impact fee that is explicitly or implicitly a factor considered in or included as a condition of an HCA is unenforceable, subject to the following exceptions. A, references in an HCA to a marijuana establishment's obligations to pay any fees associated with sales tax, excise tax on marijuana and marijuana products, optional local tax, or as otherwise provided in Mass General Law, Chapter 94G, Mass General Law, Chapter 64H, and Mass General Law, Chapter 64N. References to an HCA to a marijuana establishment's obligation to pay a host community for generally occurring fees associated with operating in a host community, including water, sewer, property tax, etc. So any questions on this section? Sean, you look like you're, no, okay. Are you hungry? Yeah, no, let's get through this section 2 and then we'll break for lunch. We good?
Yes.
Okay. Andrew wants to go home, so. As you guys. Oh, I thought you wanted to, I think you're like, no, do more. Okay.
No, I am hungry.
All right, I am too. All right, let's look through this here. Okay, 3, no host community may mandate or otherwise require that a community impact fee be a certain percentage of a marijuana establishment's total or gross sale as a term or condition of an HCA. A host community shall not demand a community impact fee exceeding 3% of the gross sales of a marijuana establishment as a term or condition of an HCA. Again, any questions?
That's listed from statute.
What? Yep. Okay, anything here? Nope.
Inducement is, you're saying, I'm sorry,
That is from statute.
That's from
That's
statute.
not maximum 3%.
Okay, but I'm saying the word inducements, are we defining it? Can we define it, or will the CCC define it?
No license, marijuana establishment or host community will use inducements to negotiate or execute an HCA. Go ahead, Andrew, I'm sorry.
Sure. Oh, Rebecca, please, Councilor Lopez.
No, Attorney Carter, I think you were already going to go there, so please take it away.
Turn to the.
It's been explained to me that an inducement, as an example, prior to us getting authority and implementing it would be, if you don't sign this,
Mhm.
the guy in front of you already signed it, the person in front of you already signed it, and the person behind you will sign it. And if you don't sign it, like, so inducing someone, that's almost like a contract of adhesion. You need to have, it's the HCA's now will be a negotiated in good faith between two parties. And no one should be induced into doing anything that's not negotiated in good faith between two parties. Where in the past, it wasn't necessarily that way.
My question is, is it defined, is that a definition somewhere? Like, do we know?
Yes, yes, it is. It's in .002. And inducement means money or any other thing
Perfect.
of substantial value intended to persuade or influence a person or entity to take action or refrain from taking an action,
Perfect.
similar to what Commissioner.
Thank you,
Thorpe
thank you,
just
thank you.
described.
I want to make sure it's on paper.
Okay, all right. And J, the following terms, conditions, or clauses are prohibited in an HCA. A provision that discourages any party from bringing a civil cause of action or other legal challenge relative to an HCA or to an individual term or provision of an HCA. 2, a provision that requires a licensed applicant or marijuana establishment to make upfront payments as a condition for operating in the host community. 3, a provision that affords a host community sole and absolute discretion on how a community will spend a community impact fee. 4, a provision waiving a marijuana establishment's ability to dispute whether impact fees alleged by a host community are reasonably related and properly due and payable as a CIF. A provision that categorically deems a host community's alleged impact fees to be reasonably related or that otherwise excuse a host community from calculating impact fees based on the actual operations of a marijuana establishment. I'll pause right there. Anything in this?
Just a quick question, because we talked about the unilateral mediation clause before. Does that fit into 1A or 1?
Say that again. I missed what you were saying.
We had the conversation about you can't unilaterally bring something to mediation. It has to be in agreement of both parties. Does that mediation step fall into
5.
that provision number 1, discourages any party from bringing a civil cause or action? Or is it not related? Enough related.
It's in dispute resolution. It might be clarified when we get to that.
But we're looking at stuff that are actually forbidden from being in an HCA.
Mhm.
Just thinking of that mediation clause.
That's a good question.
HCA can't say that one party can unilaterally bring something to mediation if there is an agreement by both parties.
Oh, I see what you're saying.
Meaning you're saying discourages any party from bringing a civil cause of action or request mediation. I mean, are you saying that?
I'm just wondering if that's contained in that, or do we need to?
You want to lift the language that previously stated and put it in here?
Well, I think I'm confused. So,
Well, I think that this is, you can't preclude someone from bringing a civil cause of action. And in a separate section, we have allowed mediation and we've established that it has to be, again, mutually agreed to. So.
well, a lawsuit doesn't have to be mutually agreed to.
No, I know, but I'm just
Okay.
saying, that's what I'm saying is I don't think it has to be here because this is saying you can't say you can't sue, right? And we're also saying mediation generally is something that both parties want to get to because they want to avoid suing, right? And so what we've said is if you don't agree to mediation, you don't have to, right? And so we've already said that, but we've also said that the terms of that mediation agreement have to be established on an equal footing. So that's why I don't think it needs to be there.
You don't think compel mediation, a prohibitive clause, compel
But we-
mediation,
but
we're
we've
saying
already
you can't, we've already said you can't
Yeah.
compel.
Right.
But just to go back to the other language, the parties may include a clause in an HCA whereby the parties voluntarily agree to bring HCA disputes before a private mediator retained by the parties. Neither party may unilaterally compel private mediation. I'm just saying that language is there and that may be enough to stand alone. The question is, do we want it as under this section, which says the following terms and conditions or clauses are prohibited in an HCA.
We ask legal.
I understand now that
I
so
don't-
Commissioner, you're saying kind of place it here saying that any term unilaterally compelling mediation is invalid on its face. Is that what you're saying?
Yeah, that's what it's saying.
Yeah,
Okay.
I mean, it might be covered where we say you may include that clause as long as neither party may unilaterally compel private mediation. I'm just saying as a term, condition, or clause that is absolutely prohibited, do we need to kind of restate that there, that any HCA which has a clause which says you may unilaterally compel private mediation should not be allowed, or it's a reason for
But I think we've already said it,
prohibited.
though.
Yeah.
We've already said it,
Yep.
and I hear what you're saying, but the fact is mediation is generally seen as a positive thing to get around.
Oh, absolutely.
But it's also, the point is that there has been, that non-equal, you're gonna do this, you're gonna do that. We've maintained that it has to be voluntary. We've maintained that it has to be a mutual meeting of the minds. But nobody has to, you know what I mean? It's not a prohibited clause, but it is, if you're gonna do this, this is how you do it. So Commissioner Stubbins, but in other instances, no, but
Go ahead.
lawsuits are adversarial,
Mhm.
right? And so it's in nobody's best interest to sue, but you're.
If I'm
basically
understanding
in
him
the
right,
same
though,
case.
if I'm understanding Commissioner Stebbins, he's not disagreeing. I think you're suggesting that we reaffirm that here.
Okay. All right. Do we need language?
Again, unless it falls under,
Something else.
and I'm not the lawyer, but if it would mediation fall under a civil cause of action or other legal challenges? Is a mediation considered a legal challenge or no?
Mhm.
Well, Commissioner, just so I understand, it sounds to me like you're saying the two provisions are in conflict.
No, I'm not, no, I'm not saying that. I'm saying further back, we say parties may include a clause in an HCA where parties voluntarily agree to bring HCA disputes before a private mediator, right? We want to encourage that.
Yeah.
That's a good thing to put in an HCA. The last sentence in that is neither party may unilaterally compel private mediation. I'm suggesting, and now I'm reading the language, neither party may unilaterally compel private mediation. Should that also fall into terms, conditions, or clauses which are prohibited in an HCA? Like,
In other words, right, a prohibited clause would be one that compels mediation unilaterally.
right, you can, if you have a clause in an HCA that compels or provides for unilateral mediation, we don't want to.
It's prohibited. Yeah, it may be duplicative as far as or redundant. And it could be encompassed or captured with that legal challenge. Because there's also the risk of discouraging mediation as well.
And we don't want.
You don't want that either. So I would say it is encompassed in was it J1? And otherwise adding it explicitly would just be redundant.
I think it also gets into our alleged category, that there's sort of an implication that, you know what I mean? I think what you just said kind of
So
makes you think that maybe mediation is a bad thing.
Madam Chair and Executive Director, may I
Please, Ted.
give additional information and context possibly?
Kyle, then Rebecca. There we go.
Ultimately, I do defer to the ED and our legal team, but from my legal experience, and Commissioner Stebbins does have a point, I don't think they're in conflict, but generally in the course of an adversarial litigated type of position or cause of action, mediation typically gets started before a filing of a case. That is not always the case, because, for example, you could file a complaint in a district or superior court, depending on certain factors, where then part of the judge's order and the court's order is that you enter into mediation, which is a real possibility and it occurs all the time. So I think to your point, Commissioner Stebbins, is I don't think they're in conflict, and I think your fellow commissioners are trying to represent the policy objective behind it, is where the prior statement about mediation not being unilateral is that the one party cannot unilaterally force another party into mediation. And I think that was the policy objective. But when we're talking about civil actions, we're talking about the court system, and mediation can happen before the court system is involved. It can also happen afterwards. So it might be advisable to maybe reaffirm the previous policy statement unless a court of competent jurisdiction issues it via a court order. Because obviously we cannot, it would not be advisable to have a policy that would underestimate or underappreciate or and give deference to our court system. But that's, I guess in practical terms, I give you that information for you as policymakers to take into context, that both mediation before and after civil suits and a complaint is filed and the court is involved, they're both real actionable possibilities that occur on an everyday basis.
Okay.
Okay, Rebecca Lopez, Attorney Lopez, if you have a further comment.
Yes, thank you, Madam Chair. So Commissioner, I want to respond to your original question, which was whether or not the term, the phrase or other legal challenge in J1 would capture the prohibition on unilaterally compelling mediation. And I will say that from an enforceability perspective, I do not think it would, because J1 is referring to scenarios of provisions discouraging someone from bringing a cause of action, whereas what you're pointing to is a provision forcing someone to do something. So I don't think they really are in the same universe necessarily. There is no harm to reinforcing the prohibition on unilaterally compelling mediation in this section of the regulations if the commissioners choose to do that. But if you want to reinforce it, I would suggest a new subsection outside of one that speaks to that versus trying to fold it into one, because one is just covering a different kind of policy concern and scenario of discouraging, not compelling. So that's just something to consider.
Okay. No, I appreciate that. Thank you.
So do you have a preferred?
I'm comfortable leaving it where it is.
Okay. I think that I mean, again, I heard you, but then I think that we have covered it. But if you want to add anything or you want to propose anything, are you good having heard all these explanations?
I'll mull on it over lunch. Maybe.
But again, you can always fix.
Yeah.
This is again, what I want to say. This is a first draft. There's going to be public comment and someone may say, oh my God, you have to put that in there. And it's going to be very persuasive letter and it's going to have little flowers on it. You're going to, oh my God, I love this. So anyway, we can include that at another time. So, okay. Andrew's looking really hard.
Madam Chair, I'm either gonna bring my lunch in here.
Okay, we have more. Well, these two more. Okay, 6. A provision that imposes legal, overtime, or administrative costs or any costs other than the CIF on a marijuana establishment, with the exception of a marijuana establishment's tax obligations or its responsibility for paying routine, generally occurring municipal fees. Again, any questions on that?
No, I
Commissioner
don't have a
Boyd?
question on that, but I do have a lot on 7. So I would respectfully request we break before
Respectfully,
7 because I
You
do
can
have,
always make a motion.
I make a motion to go to lunch.
Okay, all right.
I'm starving.
Okay, I'm going to second that
Yes,
motion.
second,
Commissioner
please.
Barrow.
Yes.
Margot,
Yes.
Concepcion,
Aye.
Roy,
Aye.
Stevens.
Aye.
We will take a break. We will come back promptly at 2:15. Okay, so we haven't gotten to 6 yet.
We will be talking about 7 bonds.
How much time, Madam Chair?
2:15.
Okay, thank you so much. Okay, next
I
time.
brought
lunch. Is this room getting locked or what are we doing?
Take a
All our stuff in?
No, doors stay open
Okay.
football times.
Is somebody staying in here? We take our laptops?
Just a second. La, la.
Okay, we good? We're back from lunch. And so so we did not totally finish 6, a provision. This is prohibited by an HCA, a provision that imposes legal overtime or administrative costs or any costs other than the community impact fee on a marijuana establishment, with the exception of a marijuana establishment's tax obligations or its responsibility for paying routine, generally occurring municipal fees. Can I just ask, overtime, how do we? I didn't understand. This is anything that imposes overtime, legal costs, administrative costs, other than the community on a marijuana establishment. So what if you have to do overtime? What if you have to? No? How do we determine that? You know?
Well, go ahead, Commissioner.
No, I wanted to hear the question again.
Well, I'm looking that we are prohibited to put in a provision that imposes legal, overtime, or administrative costs or any costs other than a community impact fee on a marijuana establishment. I'm just missing what this means. And again, I've admitted to being obtuse today, and I'll admit to it again. But
That's for
overtime, you know what I mean?
municipalities.
Mhm.
So it would prohibit municipalities from asserting any overtime by city employees on licensees through a community impact fee.
Okay, could you give an example of what that might be? Again, I won't belabor, because she's gonna belabor 7, so I'm not gonna. That. So, all right, I think that's fine, okay. I don't have any more questions, so all consensus, yep. 7, a provision that obligates a marijuana establishment to set aside money in an escrow bond or other similar account for a host community's use or purposes.
Okay. I'm going to apologize up front.
I just already did.
All right, so, and let me just start with saying that I agree with this concept and the premise of this prohibitive condition. In light of that, I want to make sure we are on sound legal footing. In our own regulations at 500-105-16A, bond. Prior to commencing operations, a marijuana establishment shall provide proof of having obtained a surety bond in an amount equal to its licensure fee payable to the Marijuana Regulation Fund to ensure payment of the costs incurred. The destruction of cannabis goods necessitated by the violation of Mass General Law 94G 500, 935 CMR 500. The cost in compensation of a court appointee, the cessation of operation of a marijuana establishment, such other uses that the commission may authorize to ensure public health, safety, and welfare. All bonds required under 935 CMR 500 shall be issued by corporate surety licensed to transact surety business in the Commonwealth. If the marijuana establishment is unable to secure a surety bond as required by 935 CMR 500-105-16A, it may place in escrow a sum of no less than $5,000 or such of the amount approved by the commission to be expended for the coverage of liabilities. The escrow account required pursuant to 935 500-105-16C shall be replenished within 10 business days of any expenditure required under 935 CMR 500-105, unless the marijuana establishment has ceased operations. Documentation of the replenishment shall be promptly sent to the commission. Now, we are one government agency telling another government agency, a municipality, we can do bonds and escrow, they cannot. And are we in violation of state law, general law, chapter 44, 53G1/2, which provides municipalities the option to, under the new law, GL's chapters 44, 53G1/2 cites cities and towns may not reserve any cash or other surety they require of applicants or contractors by the adoption of bylaws, ordinances, rules, or regulations that set appropriate standards for the disposition of the surety without appropriation or other legislative body action upon the satisfactory completion or default of the second obligation. So that's in statute. I want to make sure we're on sound legal footing, that we are not going against state law, and we are one government agency requiring bond or escrow, and we are telling others that they cannot. So I just need a legal opinion on this, please. And who,
I'm sorry.
Kyle or Rebecca?
Thank you, Madam Chair. Because there's a legal question on the table, ultimately I will defer to the ED and legal. But I think one thing that I think that might answer your question, Commissioner Roy, and is that there is the law that you just cited, the Chapter 44, and the requirement that we have in the proposed policy that has come from the HCA working group.
Yeah.
It's ultimately, I think it's probably the easiest thing is to identify who, in the sense of an escrow or bond, with setting it up, who is the surety, who is the beneficiary. In the sense of the commission's current policies that you were citing as far as 10516, it has been interpreted in the past that our policies we are the beneficiary of an escrow account, and we require such statement to that effect. Same thing with a bond. We require that we are the surety, and essentially one of the primary reasons is for, you know, the unfortunate case of the dismantling of a marijuana establishment. In the where you were citing Chapter 44, and the question that you were posed, in that situation, it would be the municipality that would be the beneficiary or surety of which the proposed regulations are preventing. I don't necessarily see a conflict. I think the intent behind that from the working group, and please correct me if I'm wrong, Commissioner Roy, Commissioner Concepcion, is to ensure that there is not somehow, some way, a loophole, and to also reduce barriers to entry. And just to also call an HCA what it is when it comes to financial impact, which is the CIF, those generally occurring fees and taxes, and that there's not another avenue via, say, a bond or an escrow account that could be created. We require it for a public policy purpose, which is subject to, obviously, to your discretion. But I think that's the distinction, is who's the beneficiary, who's the surety of those bonds or escrow accounts. In the case of what you stated and the question that you had, that would be the municipality. As far as 500-105-16, that's the commission, and for a distinct public policy reason. But again, I defer to the ED and legal if that interpretation is wrong.
May I cite just a little bit more from that law? Often a local permitting board, commission, department, or officer may require cash, bonds, escrow accounts, negotiable securities, or other financial sureties in order to guarantee any performance obligation required of a third party as a condition of obtaining a license, permit, approval, authorization, or contract. And we check the box on a few of those. I just want to make sure we're not vulnerable, and I want to make sure we're on sound legal footing here and we're not overreaching. That's all.
Because I was just gonna say, one of the instances where I've seen, and I'm not even sure, again, this may or may not have been illegal, but, you know, some smaller towns who go through this process of approving, you know, host community agreements, they may not even have a full-time, you know, town manager, and certainly don't have, you know, a lot of full-time people managing the business of a municipality. And so I don't know if we even allow for any fees to be paid. For instance, I'm, you know, municipality, you know, you're going to have to hire a lawyer to review something, you know, unless we now have this, you know, so this would be the case for a teeny tiny town. Do we allow a community to impose those costs on, you know, a licensee to get a host community agreement? Again, this is like a drop in the bucket for a Boston or a Springfield, but for, you know, my example is always Peru. You know, for Peru or a Charlemont or, you know, one of those other places, there actually is an expense that could be, you know, a significant impact. That's where I initially saw that, is put this into escrow. And if you get the HCA, you know, you get it back. But otherwise, if you don't get your HCA, and that can happen for a lot of different reasons, that we get to keep the money that we expended, teeny tiny town, to take a look at your application. Now, I don't know if we even allow that. Again, I've seen it. And, you know, maybe, you know, Kyle or Rebecca could tell me, is it legal for a community to impose costs or to gain reimbursement on costs that a community bears when they're reviewing a host community agreement application? Do we allow that?
Thank you, Madam Chair. I'll defer to Enforcement Council on this. But that provision, I just, for clarification and absolute transparency, I want to make sure that based on the subsection that Commissioner Roy just brought up under that chapter 44 or 40, again, not being able to give a legal opinion on the spot and not being able to certify that as legal advice. But with the context that she just brought up with that additional subsection, I think in transparency and honesty that would definitely require some looking into and legal analysis further. But I want to put that and make sure that there's some understanding on that.
Okay.
But
Right.
I will defer to Rebecca at this point.
Please, Attorney Lopez. Could
Yes.
you answer my question and then deal with the more complex legal, unless we don't have enough time in this moment. Again, we have reserved the opportunity to do a remote meeting tomorrow morning. I prefer us getting it done today, but if we can't, and we need some time overnight to.
Where are we, Madam Chair? Because there are two different things on the table. So I know Commissioner Roy.
She's asking about the legality of us being able to say it. What I'm trying to get at is, why would they even need an escrow bond? And there may be a valid reason why they might do that. But I'm not, again, I've seen it, but I don't know if it's legal. I don't know if it's legal at all.
Thank you. I just wanted
Does
to
that make sense?
bring it back.
Sorry.
So there are a couple of points that I would note here. I think that this is a very good question, and in order for us to serve you effectively and appropriately, the legal department should be given time to conduct an analysis of this. But what I will say is the statute is very clear that the community impact fee cannot include additional payments or obligations. Then the statute also says that a host community agreement cannot include a promise to make future monetary payments. We have built into these regulations exceptions for generally occurring fees. What we have also built into these regulations is that conditions that are reasonable are allowed, and that a condition may be presumed reasonable if it's required under a host community's local rules, regulations, ordinances, or bylaws, or if it's required by law. So there is certainly, if this had come up on the other side of these regs already being implemented, then there would have to be some further digging and analysis, but the regulations do provide safeguards for any provisions or requirements that we introduce to be countered by other legal obligations or what the law says in other respects. So this bond requirement would be an example of, okay, it's a condition. We would have to look at whether it's a reasonable condition. So I don't think it would be prudent for us I'll let the legal department speak for itself. I know that from an enforceability perspective, there are other provisions here that capture that particular scenario. If a legal analysis were to find that we could not limit the bond element, then we would have to change the regulations. But in terms of your question, Chair, you asked about whether or not we can prohibit or limit those other fees, and the statute does expect that.
Wait a minute, could you say that the statute expects
that? So the statute says that the community impact fee shall not include additional payments or obligations. It also says that a host community agreement shall not include a promise to make future monetary payments, in-kind contributions, or charitable contributions. Essentially, the only cost that is due and payable under the HCA is the community impact fee if the host community elects to go there, or those generally occurring fees that would otherwise be charged to other businesses operating in the space. And that's what is fair game and what's not fair game. So perhaps after legal review, the answer will be that in addition to generally occurring fees, some language needs to be incorporated that also accounts for the ability to set money aside by the town in order to be compliant with that law. That is going to require further review, though.
Okay, so, all right, so we will put a pin on number 7 and either, I mean, I think we're gonna need at least a brief phone call tomorrow. Do you agree? Or I don't want to be tying anybody's,
You mean in general for another meeting?
well, I'm just saying, if we need to come back, or how do we pin this? Or do we say that this language is sufficient to go out to the Secretary of State, get commentary, and then we have time to do this? Well, we're not saying we're going to figure this out this week.
Yeah, I would suggest the draft as currently construed would be sufficient to put out there. And then I think maybe the next phase would really be a conversation with municipalities or DOR. I think also would be an excellent resource to make sure that we are consistent with other laws and obligations. I do think that Attorney Lopez did raise a number of good points as it relates to other points in the regulations that speak to some of these practices. So from my perspective, I am comfortable with the language, but I'm not familiar with the statute that you've raised. So I think we should dig into it.
May I recommend a phone call, since you're talking about phone calls, to the Division of Local Services, which
Is that under DOR?
that's under the Secretary of A&F.
Commissioner,
That's
do you
DOR.
want to
DOR.
send folks that link? Because I know I just asked you for it, but maybe sending folks
Sure,
the law that you read off would be helpful.
Okay, all right, all right. So we will leave it as is, understanding that we still have some additional questions to determine. Okay, section 8, a provision that requires a marijuana establishment to make any additional payments or obligations, including but not limited to monetary payments, in-kind contributions, providing staffing, advance payments, or charitable contributions by a marijuana establishment to a host community agreement or any other organization. So, we good with that? Okay. 3, review and certification of host community agreements. The commission, through its executive director or the director's delegate, shall review an HCA submitted by a licensed applicant or a marijuana establishment and make a determination certifying whether the HCA in whole or in part satisfies the commission requirements.
What do you want to share? I'm sorry.
Number 3, we were just doing 7, the one 7 you were looking at, and now we're down to.
Oh, that was a question. That's why I asked that. This was somebody's question. Was it
Yeah.
yours, Commissioner Camargo?
Yeah, it's actually, well, I would say it's a question. I think this one is going to fall under. Oh, yeah.
Yeah, it says
Yeah,
under
yeah, I
review
got
and certification,
Yeah.
commission through its ED.
Yeah.
Does that assume the ED or delegee is the final say on HCA? Like, what do we do now for all licenses when ED signs off on the license for final agenda? I think
Yeah.
that's your question.
Yeah, totally. Oh, thank you for reading it out loud. I was gonna explain it. I also have like another section in here that we just need to be consistent because we say the executive director, but then we don't say delegee. So I thought you were going there. Yeah, Sean, my question was just really based on the power and authority that the commission has given the executive director's role. We assume that you, the executive director, is the final say in the host community because of the process that we already go through, i.e. like the licenses, right?
Yes and no. How I would describe it, especially as the HCA would be filed accompanied with a provisional license application. Ultimately, it's the commission that would determine, much like suitability though. So I guess I want to compare it to that process a little bit, which is that initial evaluation will occur at the licensing specialist up to the Director Potvin's level. That's where we may issue RFIs to get more information for instance. However, at any point in time, especially when an application is presented to you, that is you're entitled to raise any questions you deem appropriate. And you could also on your own assess the HCA. Our responsibility would be to prepare it for your consideration, but not make that decision for you.
So do you think is that appropriate? Like I guess that was my question. When my first reaction was like, why the ED and maybe not enforcement counsel? Because I'm like, I just think about all the workload sometimes, right? So I think like process, I'm like, does the executive director need to be the person okaying this stuff, or obviously as delegee. So that was sort of my thought process there.
And that's a great point too, because for instance, suitability is a good example. I don't do the suitability determinations or evaluations myself.
Right.
As an administrative staff. It's handled at staff level. I would make the recommendation though on behalf of the staff. So in that instance, that the lion's share of the work would be done by our licensing staff most likely. But then it would be prepared and ultimately signed off on for your consideration or recommended by me, I guess, on behalf of the larger staff.
Do you think it's appropriate here?
I do from a standpoint of processing and making sure that you have as complete and compliant information as possible.
Thank you.
Okay. So moving on to section A, subsection A, the commission shall complete its review of an HCA within 90 days of receiving an HCA from a marijuana establishment. The commission may request additional information or send a determination notice identifying deficiencies within the HCA. Submission of an amended HCA resets the 90-day period of commission review. Okay, any questions, comments? Okay, review.
Yes.
Oh, you do.
Yeah. We're on the, I know we're gonna go further down as well.
You have a question about the 90-day period?
General, yeah, so my whole kind of thought with the 90-day clock is, I just wrote to myself, we need to clarify how additional information, findings and non-compliance stuff and submissions will affect the 90-day clock. If the clock stops at any time, we need to be specific when it stops and when it starts again. So I know it's a back end question, but I think about our licensees of like, they're going through the whole process. When does that 90-day, how do you know that the clock started internally? How do you know it stopped, externally? Because, you have to submit something else, or so that's like a tricky one. And we already know that licensees are anxious to hear from the commission, to get, word of you're on the agenda. So with this, I'm just very curious how this is going to work. I get the 90-day clock, but I'm just very curious how this really works practically.
I don't have an answer to that.
Does that make sense though?
Well, no, I hear you. And again, this is one of the things that, basically you have an HCA with a non-compliant term or terms, and you want those term or terms to be excise edited. Does it take 90 days to, if either, could Kyle opine on this? Why?
And if we don't have all the answers, that's fine. We can put a pin on it, but I'm just saying, like, we're agreeing to some stuff. Well, that's gonna.
So I think what you're saying is that we're literally, it's making it start from the very beginning when it sounds like there may be a deficiency, that a term has to change. So it's not rewriting the whole thing.
No, it's more also.
No, but I'm just saying it's, I would ask Kyle.
How are we envisioning this?
Yeah, but I'd ask Kyle if you could, do we need to totally reset that for 90 days? Do you think that we need that? Because it feels like, now it's going to be 180 days or whatever, you know what I mean? It just could be a very long period of time, and someone could lose a significant amount of traction in money if this is not dealt with quickly. Again,
We know
and we know that you guys are working to turn around things even faster, all the time. But what do you think about that, Kyle? Do you need that 90-day period to review this?
Well, that's Kyle, I'm sorry.
What's your question?
Yeah, Kyle, I'm sorry. I hear what the chair's saying. My initial question or thought was just the 90-day clock itself. And I know this is a whole section on it, right? But I want to make sure that, at least for me, that I understand how the 90-day clock works, because there's a behind the scenes and then there's a public, right? The licensees that are waiting for this. So the 90-day clocks, does it?
But what is your?
I'll finish. I have information. I'm sorry. I've put in my stuff. Now there's a deficiency, or I have to submit something else, or there's something's non-compliance. Does the clock start again? So how are we envisioning that?
But this is what I'm saying, is that if it's resubmitted, the clock starts again. That's what I read here.
Got it.
And I'm asking you, do you think 90 days, I thought you were saying, is 90 days too much?
No, I'm not worried. If you guys pick 90 days, I trust that you guys figured that out, but I'm more thinking on an operator side, how do I know, you guys are asking me for all kinds of information, submissions, there's deficiencies, there's information. How did
it basically says it resets it. So you have there's a whole 3 more months that they would have to wait And I guess maybe now I will ask the question for myself, not on your behalf. Is 90 days necessary when this is a resubmission?
Madam Chair, if you'll allow Sean, if you're amenable to me responding to this.
Please.
So I would say there's a corollary to an existing process right now with the 90-day aspect. There's a provision that's been in Chapter 94G since Chapter 55 that once an application is deemed complete, we have 90 days as a commission to vote on that, yes or nay. It has been interpreted that in such circumstances, like we've talked about previously, is if there's substantial changes or a negative response from a municipality or a suitability issue, that 90-day clock stops by the issuance of a notice of deemed incomplete. That's in 500-102. This is a corollary approach to that. But with that said, is with Chapter 180, the legislature has required that within commission receipt of an HCA, that we have 90 days to review it. There has been an interpretation, and I will defer to Commissioner Concepcion and Roy on this, but that requirement in the statute that says we have 90 days of a receipt of an HCA to review it. That's the maximum. So that's not the minimum. That's probably not what's going to be expected anyways. So to your point, Madam Chair, is that situation where it turns into 180 days. I think that's very, very unlikely in our current state of our licensing program. But the reason why I think that interpretation and that policy recommendation, and again, I would defer to the two commission leads, is to make sure that we can account for all different types of situations, because we could receive an application with an HCA that has maybe one thing that needs to be corrected. However, during our review and our prep and our consultation with each other during the working group, we've seen a lot of HCAs that require a lot of edits. And that requires time for them to renegotiate and engage with each other. And that will also, and if they do that, which is favorable, and they submit what they think is a new HCA that will be completely different in a lot of situations, that's going to take substantial review on a contractual basis. Like, that's a contract analysis. So we do think that the interpretation is, again, I defer to the commissioners. I think it's consistent with the law. I think it's consistent with the other practices. And I think it is part of our due diligence plan to make sure these HCAs are in compliance with this new law. I'm happy to answer any questions. And also, if that did not answer your answers, please let me know.
No, it did.
Your questions.
It answered my question. Go ahead, Commissioner Roy.
And Kyle, thank you for that. I'm wondering, to alleviate some of the concerns about the 180 days, if we put at maximum. So submission of amended HCA resets the 90-day period at maximum of Commissioner. Like, in other words, we're allowing ourselves that, but we're not, it doesn't seem on its face that it's going to be another 90 days.
I defer to that. That's kind of wordsmithing, and I get why you're saying that, is to make sure that it's messaged appropriately.
Yeah, that's all. Yeah.
Yeah, I would defer to you as one of the commission leads. But I also, from a legal analysis, from a position, it's a statutory requirement. I don't know if it's necessarily needed, but again, I defer to the executive director and
Maybe
you as
it's
the policy makers.
overkill suggestion. I realize that. I'm just trying to, Rebecca.
It's a possibility that it may not be needed through regulation. Again, I defer to the ED and legal, but that's something that could be messaged through an FAQ or a guidance document during the implementation stage.
Yeah.
But
Commissioner Roy. Sorry. Sean, Rebecca.
I would just add that if we put at maximum into the 90-day that it resets the 90-day period or resets the 90-day period at maximum 90 days of review. That could lead to an implementation issue because it could be construed as that is the absolute cap on further review. And what if on our second review of the amended submission, there are still issues? We want to be able to reserve for ourselves the ability to review those documents again. And that 90-day period, which the legislature gave us, as Kyle referenced, the review could be straightforward, but we have to prepare for it to also be very complex. So I would caution against putting at maximum.
Okay,
Madam Chair. Out there for suggestions.
Yeah,
Commissioner Margot?
Yeah, I was gonna say, no, thank you for answering the question, Kyle. Rebecca, I think I'm good. I think it's going out for public comment. I would want to see what people think, how they interpret it, how they read it in terms of understanding the 90-day clock. And I think it's in here, so thank you.
Okay, thank you. Moving on, Commissioner Stebbins, you good? Okay.
Good.
Section B, review of HCA's submitted for license applicants. All applications for initial licensure submitted on or after May 1, 2024 must include an HCA that complies with 935 CMR 500.000 at SEC or a compliant HCA waiver. Looking, no, okay. Okay, the commission may request additional information from a licensed applicant or a host community in connection with its review. The commission shall send a notice of its HCA determination to both a licensed applicant and a host community agreement within 90 days of receipt of an HCA. If the commission determines that a licensed applicant's HCA does not comply with 935 CMR 500.180, then the HCA determination notice shall state the following. A, the factual basis for the commission's finding of noncompliance, including identification of the noncompliant terms, conditions, or provisions of the HCA if applicable. The party's option to correct the noncompliance and submit an amended HCA. The party's option to submit an HCA waiver that complies with 935 CMR 500.180 subsection 5. And D, either party's option to discontinue relations as host community and license applicant. Any questions, comments here, Commissioner Stebbins?
I just have a concern about D. I'm not sure we should be in that space. We're telling people, telling an applicant, telling a host community why the HCA is not compliant. Parties have, some options available to them. Obviously, you jump down to the next one. I know we're getting a little ahead of ourselves, but failure to submit a compliant HCA or compliant HCA waiver with an application for licensure essentially leaves a licensure remaining incomplete. I just don't think we should be in the position of suggesting to a host community and a licensed applicant that you have the option to just discontinue your relationship with each other. But I don't know if
I'm going to refer to Rebecca because I think
it's really, it may, so again, a licensee, and a community, and this is also one of the things that's respecting sort of local control. A community may say, I don't like those terms. The people at town meeting really don't like those terms. So to heck with it, I'm going to walk away from the money. And so, or a licensee can say, oh, that sounds, I think it's more likely that a municipality will be upset with limitations on host community terms, agreement terms. So, but that's what I think this is that if a community wants to walk away, and I think, Sean has been very good in clarifying for me when a sort of legal right attaches. And this would be perhaps when it's declaring a legal right does not attach when a community says, I don't want it. Is that kind of what we're saying here?
I'm seeing a few different things, and I wasn't privy to the working group's decision-making here. I can see the logic of, oftentimes, I'm looking at Kyle a little bit, when we send out notices regarding, let's say, an RFI, we try to be as articulate as possible, as complete as possible. Oftentimes that includes sending alongside the RFI any guidance documents that could be helpful. One of the things I imagine that could come back, and I don't know this for certain, but we're sending out a notice that says this HCA does not comply. an applicant, especially an applicant, I think would be in a position of, well, what do I do now? Now, so I can't get the community to comply. They're not willing to budge on those terms. What are my choices? And I do think there's value in the commission saying you can elect to amend if the community is willing. You're also not obligated to be in that community. You have choices elsewhere potentially. Now, granted, does that need to be in regulation? No. Could that be a templated notice? Perhaps. But I guess I can see that being the logic as to why something could be included in there is what are my next steps? Where do I go from here? And without giving, not direction, because we're not telling them to do something, without giving them that option, I don't know that it would be necessarily apparent or obvious to an applicant. Am I bound, because I've started my application in this location, am I bound to that location?
But this is what I'm saying, is that it says that it truly is a continuation of what, you know, the contract of adhesion, that this is fully voluntary, no property right attaches until, right? And that's, and again, I'm not, you know, I don't really know what I'm talking about half the time, but that's what I see this as, is being able to walk away and no one can say, hey, wait a minute, I've been negotiating. I mean, again, Peru, terrible too, but I've been negotiating with you. I've spent all this money and now we're, you know, on the hook. I couldn't put money in escrow to cover my legal costs in my teeny tiny little town. And so I can't go after you because you have a right to walk away. So I don't know if that's what was meant here, but that's how I interpret that. So does anybody have any other questions or think that, you know, we should excise this or? Hearing none?
Madam Chair, Executive Director, if I may,
Sure.
just as a piece of information that I think is relevant to this and why it's there. Again, defer to Commissioner Concepcion and Roy, but essentially why this is there is an overall legal concept of the freedom to contract. There has to be essentially, as we all know, a meeting of the minds. An HCA is a contract. And people, whether depending on the factors of every individual case, people and businesses and municipalities have the right not to contract. So I think this was one, like the executive director was saying, is not so much to promote this option, but to make sure that it is an available and identifiable option that is communicated so that everybody is aware of the playing field. Mm-hmm. This is in fact a legal option for both parties. So I think that's where the working group was coming from, but happy to be wrong via Commissioner Concepcion or Roy.
I want a t-shirt that says that, happy to be wrong, but anyway.
I'm just curious, Kyle.
I won't put it in writing.
That with this option here, and second thought, would it mislead someone to think that they could walk away from would be that breach of contract if they walk away from a contract midway through, because according to this, either party's option to discontinue relations as a host community license. I don't want anybody to be misled into creating a breach of existing contract based on this one statement.
So for your consideration as well, I would say, you know, some sentiments that have been shared by you and other commissioners today is that our regulations can be legally dense, but sometimes maybe necessary because they are in fact a legal document. This statement is it's stemming from a legal doctrine. Whether we promote it and advertise it is one thing, but and obviously as you as policymakers to include it in your draft regulations or not, it's still going to be available. So it's going to be available no matter what, because it is a legal doctrine. So that's a policy decision for you and for the body to say, hey, this is an option. So at least you're aware it's an option for those who cannot afford lawyers, those who are not legal experts, that they know that this is a possibility, and at least making them aware that this is a possibility that we may not as an agency and you as policymakers could possibly interfere and force a municipality to contract, because the interpretation is that we probably cannot. But I don't know if that answers your question.
I guess on renewal or an existing licensee who has an existing contract, and if they feel they can just walk away, I just don't want to make anyone vulnerable, a licensee to law being sued because they created a breach of contract, walked away because we told them they could. And if there's an existing contract that's already signed, sealed, delivered, approved, and they would decide to walk away because we said they could, I don't want people vulnerable to litigation.
I
Well-
think, I just want
Yeah.
to jump in for a second
Please,
because
Commissioner.
this section is for HCAs that are not approved. It's in
Right.
fact the opposite. They're not in
Oh,
compliance
pre-approved.
with the law or our regs.
Thank you.
This is pre-approved.
Yeah.
Okay.
But this is,
The
no, but
lines
this is
are blurred.
basically, no, but this is, but this is the stuff leading up to. Once there's a contract, there's a contract, right? And so if there's an enforceable contract, but, the two parties to the freely entered into meeting of the minds, that's a whole separate, we can't protect against that. But what we can protect against is making sure that people coming to the table have the ability to contract freely. And that if people decide, I don't think I like this contract, I have every right to walk away.
Mhm.
So this is pre.
Not
The
signed,
other,
Not signed.
not signed.
the other thing I think that Commissioner Roy was getting to is about at renewal, because we will review HCAs at the point of renewal, is, to look and validate HCAs to determine whether or not they are in fact in compliance. And if they're invalid under the law, then they cannot be
In compliance.
enforced, essentially.
Mhm.
And so this is really, it's a notice provision. And I remember, I think I might have been the main proponent behind this added language is because I was familiar with its usage in other capacities, both when I was an attorney in the Senate and a few other spaces, but it's really just a notice, as Kyle stated as well. It's just a fact, but we're adding it here so that it's very clear to licensees that may not be familiar with the law.
Okay.
Again, and I'm happy to leave it the way it is. I'm just looking at the language that we're issuing a HCA determination notice. And certainly appreciate the arguments on both sides, and certainly both a community and a licensed applicant could walk away. Again, I'm uncomfortable about us being in that role, but pulling it out and almost creating a new number 5 or a new number 6, which says either party has the option to discontinue the relationship. And I would say they have a requirement to notify us, so we're not sitting in the dark for, waiting on a new compliant HCA or HCA waiver to come in. If they choose not to continue negotiations, that's fine, but they should also both notify the commission that that's what they intended.
I think I'm missing something, because it's like until there's an approval, theoretically speaking, until we approve an HCA, the HCA has not been enacted. I mean, I know I'm taking a little bit of license with that, but I'm conceptualizing. So we're saying that we, at our review, we receive a perspective, an HCA, we're going through it to make sure that it's compliant, or if it's not, and then we determine that there are provisions within it that are inconsistent with the law and our regulations, and we say that this cannot be, we can't affirm this. That I guess I'm still missing it, Commissioner Stebbins, and maybe Rebecca or Kyle, maybe you can jump in and explain that as well.
Commissioner, because I guess to both of your points, this is more, I think this is more a process question that it already exists. So, but for clarification, how it's been envisioned, at least, is at least in this section where this is a new applicant, how are we being notified? We do put some onus and responsibility on the applicant that once we send an RFI and we reopen your application and we tell you, hey, we need more information on this, so this may not be compliant. Please give us this. Please submit the compliant documentation with extensive notes. And it does lead the applicant back to the point that we, as far as process, we're not going to see this again until you hit submit. Whether you hit submit and you do not maybe comply again, which is the multiple RFI issue, we will review it and we will notify you and we will be responsive to you. But the onus is on you to submit this stuff once you're giving an official administrative notice. So that's a built-in process that already exists that I think could logically and potentially be extended to HCA notifications.
Can I ask a question?
Please go ahead, Commissioner Carter.
Commissioner Stebbins, I heard you say something I hear what everyone's saying, but I heard you briefly say that you would possibly pull it out and make it another number 5. Can you kind of just walk us through that? Because I kind of understand what you're saying as to why.
Yeah, and my apologies. I don't want to dwell on this point.
No, don't apologize. It's
I think it's, 4 starts with, if the commission determines that a licensed applicant's HCA does not comply, then the HCA determination notice shall state the following: the factual basis for the commission's finding, blah, blah, blah. The party's option to correct the non-compliance and submit an amended HCA. The party's option to submit an HCA waiver that complies with the appropriate regs. Again, I'm struggling, but I guess I'm not too fastened to excluding this part, but I would say that's everything in our HCA determination. If we want to create a new number 5, which says, hey, you should both know either party's option to discontinue relations as a host community, each party has the option to discontinue relations as host community and license applicant. To me, that
Like that.
maybe reads better as a standalone as opposed to something that's in that determination notice, but.
So maybe the discontinue relations could be the title of it. I'm working with what you're saying to get the example. Because I see what you're saying. I understand what you're saying, both practical and visually, and I understand what our legal team is also saying, but
Yeah.
I'm just trying to understand because I understand what you're saying.
Yeah, I'm comfortable to leave it where it is. Obviously, as we've talked about, we have time to kind of put
So
up.
can I just say, in the hopes of getting through most of this today, can we agree to keep it as
Yep.
is? And again, this is something, again, it's not written in stone. We'll be able to fix it. And if there are some different ways to do it, again, I think we understand what the language is, what it means.
Mhm.
And it's really more a kind of stylistic thing. So if we could move on from here, just because I want to make sure we've got a lot of reading to do. So, and again, I think of the previous group of commissioners and the fact that they did this every single day. So, all right, number 5, failure to submit a compliant HCA or a compliant HCA waiver with an application for licensure may result in an application remaining incomplete pursuant to 935 CMR 500.102. Any questions? Hearing and seeing none. Then going to C, review of HCAs submitted by a marijuana establishment. 1, all renewal applications submitted on or after May 1st, 2024 must include an HCA that complies with 935 CMR 500.000 et sec or a compliant HCA waiver. 2, the commission may request additional information from a marijuana establishment or a host community in connection with its review. The commission shall send a notice of its HCA determination to both a marijuana establishment and a host community within 90 days of receipt of the HCA. The determination notice shall identify whether the HCA in whole or in part complies with 935 CMR 500.180. You with me? We're good. Okay. 4, if the commission determines that a marijuana establishment's HCA does not comply with 935 CMR 500.180, then the HCA determination notice shall provide the following. A, the factual basis for the commission's finding of noncompliance, including identification of the non-compliant terms, conditions, or provisions of the HCA, if applicable. B, the party's option to correct the noncompliance and submit an amended HCA. C, the party's option to submit an HCA waiver that complies with 935 CMR 500.180 subsection 5. D, a host community's option to discontinue relations with a marijuana establishment. A municipality shall notify a marijuana establishment if it no longer intends to continue as a host community for a marijuana establishment, and a marijuana establishment's option to request equitable relief from the commission in the event that a host community declines to continue as a host community. There's a lot there. Are there any questions or comments.
Yeah, just really quickly on D, it would seem to make sense municipality decides to discontinue relations with the marijuana establishment. They notify the marijuana establishment as well as the commission.
Wait a minute, so D, notify the marijuana and the commission.
Yep. And then on E,
I think everybody's in agreement on that, consensus, yes? Sean, do you have an issue?
Just a question, I don't know if we can compel the municipality to do something necessarily. I'm looking at Andrew, unfortunately, sorry to put you on the spot, but I don't know if we can impose the burden on the municipality to notify us.
we're compelling.
Burden on the establishment to forward that notice along to us, no?
Put a pin on it.
Yeah, I'm not gonna want to opine on that. Commissioner Stebbins, I will write down your suggested.
Meaning if you reference like the other, you have 60 days or 30 or whatever we did, we can't tell you what to do, but we're giving you this long to reply.
Yeah, and the other thing, right, we could include the word may.
I was gonna say that.
So we could say, the municipality may inform the commission as well. So I guess it depends on the level, like, do you want it to be a?
What is the point that we're getting at? I mean, if we put the obligation on the licensee. I mean, maybe the may, a community's like, these people are falling down. They've run away. They've, you know what I mean? You could have, basically someone who almost abandons the business.
We could also potentially require the licensee to forward it to us.
Yeah.
So.
That'd be fine. I just don't want us
Yeah.
kind of being left in the dark.
So how about something to the effect of on receipt of the discontinuance notice, the licensee shall submit to the Cannabis Control Commission, licensing division, or whomever.
Yeah.
Okay, so we got through there. Anything else on this section up
Just
through
E,
E?
wondering if I can get a definition of what equitable relief is.
Yes.
Well, it basically means you can make them do stuff.
Yeah, but is it, are we define, I have the same question. Are we I know we define it a little bit towards the end.
Equitable, I'll get another. Attorney Lopez, do you want to explain equitable relief?
Sure.
Give us an example.
In terms of the kind of policy purpose behind it, I'll defer to the commissioners to kind of explain that. But in terms of, again, enforceability, I will say that in these draft regulations, they do give a sense of what equitable relief could be in section 5C.
Yeah.
So 5C identifies that what equitable remedies could look like, that it could be an extension of a license expiration date. It could be the waiver of a change of location fee, or it could be something else that we want to leave that flexibility to be able to respond to particular circumstances or particular requests tied to particular circumstances. So I'll just point you to that regulatory provision. But in terms of the background on the thinking and the objectives to be served by that, I would, return that back to our leaders on the working group.
So maybe we get to 5 and walk through what the examples of equitable relief are. Does that?
Yep.
Okay. If a host community discontinues relations with a marijuana establishment, then a marijuana establishment may submit a request for equitable relief to the commission. A marijuana establishment's request for equitable relief must identify facts, information, and any documentation to support why a marijuana establishment should be considered for equitable remedies. A marijuana establishment shall ensure that the request for equitable relief includes a host community's notice under 935 CMR 500.180 subsection 3C4D. B, the commission will conduct a paper review of the petition and make a recommendation to the commission. The commission may exercise its discretion to grant one or more of the following equitable remedies to a marijuana establishment. Romanet 1, I guess I get this, extension of a license expiration date without incurring additional prorated fees. Romanet 2, waiver of a change of location fee. Romanet 3, other equitable relief as determined by the commission. And then finally, D, if the commission grants or denies equitable relief to a marijuana establishment, the agency will provide notice of its decision to a marijuana establishment and a host community. A host community or a marijuana establishment may seek relief from a court of competent jurisdiction. It's a mouthful, but are we okay with all that? Does that make sense to you? Go ahead, Commissioner Roy.
On C, now it's our purview, right? It's our discretion whether we grant equitable relief, correct? So we don't automatically, we take it case by case. So therefore, I think C, we should add none, because the commission, as it reads, it sounds like we minimally have to provide one or more. And I think we should put none, which reserves the right for us to not provide equitable relief if we don't see fit. So the commission may exercise its discretion to grant none, one, or more of the following equitable remedies. I'm proposing to add the word none, comma, before one.
In the alternative, the commission may exercise its discretion whether to grant.
Yeah.
One.
Yeah. Whether to grant.
Yeah.
Whether. The qualifier in there.
Exactly.
Yep, okay.
And then can I just, on the last one, Romanet number 3,
Mhm.
other equitable relief as determined by the commission. Again, I guess, Sean, this is determined by the commission means internally you all will create other equitable reliefs, or is it us commissioners creating those other policies? And is this like a placeholder for the future?
Madam Chairman,
Yeah.
I think too, I believe it might have been Attorney Lopez that references, it's each circumstance, and I think to Commissioner Roy's point as well, is really going to spin on its each unique own individual facts. So that equitable relief may be extraordinarily unique. And so by not limiting it, you're preserving the ability to be flexible and accommodate that unique need.
And it always implies the situation, right? And it's not a rule, it's the situation and it's the contract.
Can we just,
Please.
going back and looking at this, just so that we're consistent, can we use the term, say, we're interchanging equitable relief with equitable remedy? Can we stick with equitable remedies so it's
So you can
more clear?
find that, you're good. Are we all good with that? Commissioner Concepcion, I'd like to hear your thoughts on that.
All good. Sorry, I had a coughing fit and went off camera.
Yeah,
Yes,
no, I know.
Kyle, do you have a thought?
Just a point of information and maybe a request that before a decision is made on this, just additional clarification. Equitable relief and equitable remedies has a place in common law and case law throughout our history as a Commonwealth. And from my limited recollection in a limited time, these terms could be used interchangeably, but there's a purpose with using these terms. So I would just ask that maybe additional legal research go into before solidifying a certain term.
Thank you, Kyle. We will not make any changes until we conduct that research.
Thank you. We good? Okay. Moving on to 6, failure to submit a compliant HCA or compliant HCA waiver may constitute grounds for denial of a renewal application. 7, any action subsequently taken to deny a marijuana establishment's renewal application due to failure to produce a compliant HCA or a compliant HCA waiver shall afford marijuana establishments a right to hearing pursuant to 935 CMR 500.500. A, if a marijuana establishment elects a hearing pursuant to 935 CMR 500.500, the administrative proceeding must be conducted pursuant to 801 CMR 1.01, formal rules of adjudicatory practice and procedure. And B, a host community may seek intervention as a party to the hearing. Complex, but I think it's. Any questions or comments? Seeing and hearing none, we'll move on. Subsection D, complaints alleging noncompliance with 935 CMR 500.180. Consistent with its power to enforce HCAs, the commission may, at its discretion, investigate any complaint alleging any complaint, sorry. Any complaint alleging non-compliance with the requirements in this section and take enforcement action as provided in 935 CMR 500.000.
Madam Chair,
Yes.
I'm gonna ask, I asked it earlier, and I know it says any, and I know the answer to this, but I'm also gonna just say it out loud and publicly, does this include donations to nonprofit organizations through positive impact plans?
Wait a minute.
So consistent with the power to enforce HCA's, the commission may at its discretion investigate any complaint alleging non-compliance with the requirements in this section.
No, it's host community agreements.
And we're saying they can no longer control things in the PIPs?
No,
I just wa-
this doesn't relate to positive impact plans. It's only for HCA's, and it's the same when we talked earlier about including terms for
Mhm.
charitable contributions not being
Mhm.
permissible in the HCA. So this is
Got
only
it, okay.
relative to the HCA's.
Okay.
No.
And yeah, I guess when I read it was, I guess because maybe I was thinking in the past, sort of like, oh, I have an HCA and I also was told by a city I have to make a donation to X organization. So I was thinking of it beforehand. Okay, thank you.
That is now no longer allowed. And that's
Yep,
based on
exactly. Yep,
statute.
yep.
Yeah.
That's why, yep.
Okay, moving
Triple
on.
checking. Thank you.
Section 2, thank you. An interested person may file a complaint with the commission alleging non-compliance with an HCA requirement under 935 CMR 500.180. Nothing in this subdivision shall be construed to prevent a marijuana establishment or a host community from bringing a private breach of contract action in a court of competent jurisdiction regarding an alleged breach of specific promises mutually agreed to in the parties' host community agreement. Can I just ask a question? Any interested person, no standing, nothing, what's the definition of interested person? I don't even know. Do we care? I mean, I'm just asking, and I may just withdraw my question, but if you could just.
Yeah, it's interesting, right? Because it is written quite broadly, as opposed to when we think about it in a civil context, right? Like someone has to have suffered a harm.
Some sort of standing, yeah.
Yes. It could be a matter we put out for public comment and we see, I mean, when we say interested party, I mean, it's to alleging non-compliance with an HCA requirement. Isn't the interested party the licensee?
Well, that's what I'm saying, is that it seems, you know what I mean? I just, not that I don't think that we want to make sure that someone's compliant, but any interested party, can file a complaint. And again, I don't think this is going to be, I think a lot of what we're doing right here is we're not getting floodgates here on some of this stuff, but we don't have to do anything on it now. I just would, after the commentary, this is one of those things that just making sure that we're not opening something up for someone wants to mess with somebody. And I don't mean to be a dope, but they could do it without any knowledge, but I'd like to mess with someone because I'm an interested party and I don't like them, or I'm a neighbor and I don't like them, or whatever, so.
I understand that. Councilor Lopez, your thoughts?
Yeah, sorry. I keep wanting to say.
Thank you.
Commissioner Lopez.
So I just want to make sure I'm understanding. So you're asking about the language allowing any interested person to file a complaint with the CCC, right? Because the standing issue is really about the civil cause of action, and there we've specified that that's reserved for a marijuana establishment. So the term any interested person, that is consistent with how complaints run through the enforcement department currently. Any person who is alleging that there's non-compliance, it could be a town official, it could be a neighbor, it could be a former employee. It doesn't, it's not limited to a licensee complaining about another licensee. So
I'm good. I'm good. I just, you won me. I got it. Thank you. Sorry. Number 3, if the commission substantiates an allegation of non-compliance with HCA regulatory requirements, then the commission may take administrative or enforcement action against the licensee or host community, including sending a notice of deficiency, requesting additional information, or otherwise taking action as provided under 935 CMR 500.000. Any questions, comments? Hearing none, move on. Failure by host community to correct the non-compliant conduct may result in one or more of the following. A, issuance of sanctions pursuant to 935 CMR 500.360. B, loss of a host community's good compliance standing for purpose
purposes of 935 CMR 500.180 subsection 2E. C, publication of a host community lack of good compliance standing in a form and manner determined by the commission. Or D, abstaining from consideration of any new license applications affiliated with the host community until the host community's good compliance standing is restored. That's a pretty good penalty. Any questions or comments? Okay, we will hear about that later. 4, community impact fees. A, general requirements pursuant to MGL Chapter 940G, Section 4A.5. The commission is charged with establishing criteria for reviewing, certifying, and approving CIFs. To qualify as a CIF, and an impact fee alleged by a host community must be reasonably related. On certification by the commission, a CIF becomes properly due and payable unless disputed by a marijuana establishment, consistent with 935 CMR 500.180 subsection 4C 4A. Anybody have anything in there? Any questions? I don't see any. Moving on. A host community may assess a community impact fee as a condition of allowing a licensed applicant or a marijuana establishment to operate or continue to operate in its community. A host community may also opt not to assess a community impact fee. 4, a host community shall ensure that the initial invoice period of alleged impact fees covers a 1-year period that starts from the date the commission grants a marijuana establishment a final license. A host community shall further ensure that all subsequent 1-year invoice periods are consistent with the anniversary of a marijuana establishment's final license date. The commission will not certify any impact fees attributable to dates outside of the applicable invoice period. Commissioner Roy.
Thank you, Madam Chair. I just want to remind, we have alleged, I think we flipped over to asserted. Thank you.
Oh,
And then secondly, I think Rebecca, was this the spot where we would refer to statute as a public document for the impact invoice?
So that's a great, I think 5 maybe would be the spot, because that's where we say host community seeking to assess shall transmit the itemized invoice. That could be
Okay.
the opportunity to
That's-
incorporate.
To insert that. Okay, thank you.
okay. No, I lost my place.
You got that?
Which one am I on?
I just wanna make
I have an
sure that-
additional comment.
Please.
We said, I'm sorry, I just want to make sure I understood where we landed with the claim versus asserted. Are we at asserted or claims? I just want to make sure it's consistent with what we have at the beginning.
I think it was claim.
Okay.
Which one was it? Claim.
Okay, I just want to make sure it's consistent throughout.
Oh, I thought it was.
Yeah. Yeah.
Thank you for bringing that up, because I thought it was still asserted. Thank you.
Twitter knows.
Okay,
So we're gonna insert that.
okay. And what are we on?
Commissioner Roy,
Yes.
as it relates to where you would like that language inserted, was it sub 5?
5.
Only because I'm reading the sunshine requirements also underneath, which a host community.
You think that's
shall
more
ensure-
appropriate?
Yeah, I'm wondering if it would, because it's sort of around the same topic, right? Transparency and disclosure. So I just wonder if it's a better spot to put it there. But ultimately, I defer to you.
We're number 4, right? Are we there yet?
Finishing 4 here.
Most communities. We're at 4 right now.
Yes, we're on 4, and I just want to make sure we have buy-in, okay?
I'm okay with it at 5, but Commissioner Concepcion? Are you okay with referring to statute as it's a public document at 5, or do you think it should go the next line down under sunshine requirements?
Recommendation, Madam Chair, Executive Director, and Andrew. Just because we're talking about public records requests that we are in fact in a custodian of said requests. I throw this out there as a suggestion that possibly it might be more appropriate to do it under subsection 4, community impact fees, number 6, when we're actually in receipt and we have it, as declaring that public records obligation.
What is the link? So I know that we're we're stating the law that this is something, information that is available through public records through a request. But what is the language that's being proposed? I don't know, Commissioner Roy, did you have actual
I
language
have
that you're
the
offering?
statute language we're going to refer to is the annual, let's see, I'll start from the beginning. Any costs imposed upon a host community by the operation of a ME or MTC shall be documented by the host community and transmitted to the licensee not later than 1 month after the date of the annual renewal of the final license to operate the ME or MTC center, and it shall be public record as defined by clause.
Got it. Got it. Okay. And then Kyle, to your point, or you're saying that because we are the custodian, that we need to have the opportunity and the time to respond. That's what you're saying is like I'm trying to piece everything together. Do you mind restating what you were saying, Mr. Poppins?
Absolutely, Commissioner. So I'm going off of the recommendation of Commissioner Roy to have some type of statement about these invoice statements that are submitted to the commission being public records. In furtherance of that, where to put in if the commission wants to have that statement somewhere. My opinion is it would be appropriate once the commission's actually in the regulatory process policy of the regulations, which is number 6, when we're actually a custodian of the documents. To do it, there's wiggle room to do it, but I just think that's the cleanest thing because we're also talking about the interchange between a licensee and a municipality. A municipality is also subject to a public records request, and we don't want to entangle ourselves with them based on our obligation as a state agency. So that's where the recommendation comes in for why I think that would be the appropriate place under number 6 once we're the custodian.
That makes sense. Commissioner Roy, I defer to you in terms of placement. I think go ahead.
Yeah, I agree, Kyle. That makes in the process of the pipeline of that receiving that information, when we are the custodians of it, to remind folks it is also a public record. I think that's very appropriate suggestion. Thank you.
And it's a public record at different levels because we're talking about multiple governmental agencies, but in a jovial type of manner, I would also defer to our public records officer, Andrew Carter, if he has an opinion on it.
Very jovial.
Always.
Yes, toss it in there.
Yeah, I'm not sure I have the best answer because I kind of want to reiterate Kyle's point, which is municipalities are also subject to the public records law, and does matters need to come to us before it is publicly disclosed? So I think that we may want to contemplate what role the municipalities have in following this piece of the statute, which is to say they need to also be effectuating these records as public. So I would prefer to take an opportunity to contemplate that a little bit before inserting it somewhere that I'm not sure. But that's a personal opinion and I will respect the policy.
And the reason I'm advocating for this so much is because I've heard countless stories where an ME has paid over $1 million in CIFs and they can't even get a receipt.
Yeah.
They can't even get a receipt. So this is part of the transparency, the oversight, the accountability, the sunshine is just, it's in statute. And just as a reminder, if we can just refer to it and where it goes. I mean, I'm not so particular necessarily where it goes, as long as it makes it in this document, because we've heard countless stories of people who can't have an accountability for where their money went.
Yes.
Sorry, Andrew. Commissioner Roy and Andrew, please correct me if I'm incorrect on this, but to not intentionally overcomplicate this a little bit because of the municipality, the state agency, 2 governmental bodies. There is a 3rd governmental body that's involved in this, which is the Secretary of the Commonwealth's office, which will answer appeals regarding public records requests. Going to your point of somebody asking a municipality, hey, why are you not giving me this invoice? So there's another governmental agency and other applicable laws to take into context, but that's, again, not to overcomplicate it, but to just show you the scope that there's other factors here. But Andrew, if I'm wrong on that, please correct me.
No, you would be correct. So the law says it's a public record. So if a municipality refused to give it up, they would go before the secretary, and the secretary would say, well, the law says it's a public record, it has to be produced. So for me, when I'm thinking about this, right, we always think, who is the record custodian? We might receive these records, but these are not agreements that we have entered into. And when it comes to sort of the first place of production, I think it probably would be the municipal level. We can incorporate similar language if we have the records, 2 sets of records, for example. But I just think it's an item that we want to think out a little bit further. And we can connect on that if it's helpful, but if you also have a strong belief, we can move forward in your direction as well.
And so we have municipalities now who are government agencies. And are they able to produce these records of where this money went? Do they, because does the licensee have afforded to them an avenue? I guess they could request it, but is that information even available? And, like,
They're not collecting that information now. Which is why we get 0, 0, 0. I don't think that they're collecting, you know what I mean? And we're telling them they have to be more transparent now about their HCA process there, so there is going to be, but I don't just necessarily disagree with you, but I'm just trying to figure out. I mean, we're now going to be holding them accountable for these community, these fees. And so we're going to have that information, but it may just, if they want to get it in real time, they're going to have to deal with the Secretary of State. But I don't necessarily disagree with you. I just don't know what we're already telling them when it comes to their host community agreement processes, they have to be transparent, right? And we've talked about, they've got to look at their website or other publications. They've got to, I'm just wondering if maybe we add that in there at that point where we're talking about transparency and we add the process, the scoring,
Yes.
and that stuff. And you need to publicize that as well.
Yes, the municipality proactively putting this information on their website, I think is also a good avenue for us to explore and contemplate.
But that could come in that other section where we've outlined the transparency that we're expecting.
Yes, and because it's part of municipal equity.
Right.
The transparency is associated with an equity.
So maybe that gets at what you're saying, but we just put it someplace else that's talking about transparency. And then we add that as a factor. Does that?
I guess what I'm saying is it used to be some of these cases like a wink and a nod with this money and there's no accountability.
Well,
And
they're winking and nodding because they're not really assessing it. They're just taking the money without really having a rational relationship. There are some communities that have made that relationship, but again, every month, 0, 0, 0, 0.
Contracts,
Right.
they had contracts, they did have contracts, but the payments were a wink and a nod.
Can I just, Commissioner Roy, I think we're all agreeing with you. I think it's a matter of where do we put it? Should it be in here? And I think maybe put a pin in it and come back, because I don't think it's part of the major scope. I think we can add it
Okay, so we
later, but.
agree. I guess I wanted to find out.
No, I think you're,
Agree that-
well, at least I'm hearing what you're saying, Commissioner Stebbins, I don't know.
No,
Claire,
I
you can
agree.
Manage, but I think, because
I think
we
it's
hear
part of
you.
the transparency.
Yeah, we get it.
It's part of the
Okay.
transparency. And so
some
we
of
add that factor.
and I think just to sort of take a moment, because we know so many behind the scenes stories, we want to also see it in the regs, right? And I think to your point, it's kind of like, hey, put it in here, right? I think Commissioner Stebbins, even with your situation, a couple of lines ago where you're like, hey, let's add a number 6. I think it's the same thing, right? We know so much behind the scenes of what's happening really with applications and HCAs that we want to make sure that these new regs, it's very visible and people could see what's in it. So I hear you, Commissioner Roy. Yeah, I think we should leave it to legal and come back. Yeah.
I can't tell if Kyle is looking perplexed or looking something up. No, it's just he was looking intent and I didn't know if he's looking down on us or what. Kyle, were you thinking of making a comment or just looking very thoughtful?
Thank you, Madam Chair. I was really admiring Commissioner Camargo's nails and the whole Bobby reference earlier. But that goes to another thing that I won't engage in with right now.
Thank
But
you, Kyle.
to Commissioner Roy's point, and I think what her policy initiative and the policy initiative behind this is incredibly valuable. It goes to our mission. But I guess to give some type of level of a security blanket in a sense of that this is going to happen anyways, there is a state agency tasked by law to enforce public records for governmental bodies.
Yeah.
And we also don't want to entangle ourselves with that, but at the same time, as policymakers, you have every right to interpret that. But I just want to reinforce the fact that we have always been in since day one as a governmental agency subject to public records laws like every other municipality. And these things there's a government agency, the Secretary of the Commonwealth, that is tasked with overseeing appeals and decisions and making decisions on this. There's a system in place by law to accomplish what you are trying to accomplish. But reiterating that fact, absolutely. Is selling that fact from a communication strategy, does it need to be in regulations, or is it a guidance, or is it anything else? Ultimately, that's up to you, but by law, this has to occur anyways. And there obviously are exceptions and exemptions, but just to reiterate that fact that this exists.
By law, it has to happen, but the process can be unduly burdensome, timely, and expensive. And what we're trying to do is address primarily the smaller business operator that's, not an MSO that's got 5,000 lawyers behind them, but we're trying to sort of, look at that. So I think we can properly place this in the rest of our transparency stuff. And again, we can move on from here if people are comfortable. And I think we can accomplish what you want. And again, your legal advice is absolutely correct, but I think that there's a way to do this and stick it in place where I think it is just part of the transparency that we're aiming for. Anyway, I have not read it. Thank you. Thanks, Kyle. Okay, 5, a host community seeking to assess a community impact fee shall transmit an itemized invoice to the marijuana. Okay, I've read that. So sunshine requirement, a host community shall ensure that impact fee invoices include a specific description of how, and again, we're taking it alleged impact fees, claimed impact fees were spent, including each line item for each good or service charge, stating its cost, purpose, and relation to a marijuana establishment's operations. B, a host community shall transmit its impact fee invoice to a marijuana establishment no later than 1 month after the anniversary of the date the marijuana establishment received a final license from the commission. A host community's failure to transmit the impact fee invoice to a marijuana establishment within the prescribed time shall result in a forfeiture of any community impact fee for the applicable year of operations. And then C, a host community shall ensure that the impact fee invoice is restricted to the license numbers operating from the licensed premises alleged to have impacted the community. For CMOs, a host community shall transmit an impact fee invoice to a marijuana establishment and wait a minute, to a marijuana establishment and an MTC. What am I getting? And is that why am I? Sometimes you look at words that don't make sense. A host community shall transmit an impact invoice fee to a marijuana and an MTC. And is that what we want to say? It feels like you have to.
Feels like a word though.
Read it again.
Or is it the marijuana establishment or MTC? Do you see how I'm reading that and it's sounding weird?
So perhaps I can assist with this one.
Oh, please, thank you.
So CMOs, that's, in situations where we have co-located marijuana establishments, there will be a medical side of operations and there will be an adult use side. This provision is stating that the host community has to transmit an impact fee invoice to the marijuana establishment and the MTC. They cannot submit one impact fee invoice covering both of them.
So is it, I know this is to the marijuana establishment and the MTC? Is the word the rather than a? maybe I'm
So
wrong.
typically, I think typically in the regulations manual, I think the preferred language is a marijuana establishment because you're opening it up to the universe of marijuana establishments versus making it specific to a particular one. But ultimately, it's your decision.
No, I just
as
thought
a
it was
body.
in reference to a particular establishment. That's why I was reading it kind of weird. But I'm okay if you want to keep it at A, and if the booklet says that, then I will recede from this question and move on to 6 unless anybody else has a question. Within 30 calendar days of receiving a host community's invoice of claimed impact fees, a marijuana establishment shall submit the invoice and any supporting documentation, if applicable, to the commission in a form and manner determined by the commission. Anybody, we good? A marijuana establishment that has agreed to pay a community impact fee under its HCA shall annually pay an undisputed community impact fee no later than 8 months from the date of receiving a host community's invoice of claimed impact fees. This subdivision shall not be construed to require a marijuana establishment to pay a CIF if a marijuana establishment's payment obligation is the subject of a non-frivolous legal dispute before the commission or a court of competent jurisdiction. Can somebody, non-frivolous, you know what I mean? Can you just explain what this means? Use my voice. Is the subject of a non-frivolous. Who's defining non-frivolous? How does that work?
Well, I think non-frivolous, if there was a question of whether, so the purpose behind this is that we want to, I believe the working group, and of course I would invite Commissioners Concepcion or Roy to step in, but the purpose is certainly to leave space for that dispute. If there is a live dispute that's happening at the time of that the CIF payment would normally be due, to kind of leave space for that and not penalize anyone for being in that position. In terms of non-frivolous, we do want to make sure that this allowance of an exemption is not abused or exploited. So non-frivolous is in there to kind of maintain that accountability. How we would determine frivolousness would again probably come in through the complaints process. If someone was alleging that it was a that it was a frivolous complaint for the purposes of just buying time or getting out of the CIF payment, we might conceivably receive a complaint to that effect, and then we would have to review that and explore whether or not there's merit to it.
Okay, thank you.
Quick question.
Yeah, Commissioner Stebbins?
Is there background on how we settled on a date of no later than 8 months?
Yes. Kyle, this was your, Kyle's the architect.
There was a, and it could and potentially may need to be amended, but the original idea behind it was the submission of the invoice was tied to the actual renewal of the licensee. From my recollection of the working group's discussion. And as we all know, an annual renewal is due 1 year and annually thereafter of the issuance of a provisional license. With that being said, this itemized invoice it's tied to the issuance date of a final license. So the idea behind it was multifold. And again, I invite Commissioner Concepcion and Roy to add additional input or correct me where I'm wrong, but it was tied to the fact that originally that it was tied to our official renewal process under 500-103. That changed a little bit, but also the aspect of once there's a certification by the commission of what we think is the appropriate community impact fee, was to make sure that our businesses, large and small, had the opportunity and the time to make sure that they made those payments in a timely and compliant manner. So again, that might need to be reevaluated in context of other applicable laws, but that's the context that I can give you.
and if I may add, Madam Chair.
Please.
Also, in statute, there was wiggle room. There was, in other words, payment of the community impact fee shall be due annually to the host community, with the first payment occurring not sooner than upon the first annual renewal by the commission of a final license. So there's a room for us to interpret there when the payment is due.
I think that's where the working group led, but ultimately that's an interpretation question for legal, and potentially a policy question for you, and therefore also Matt Giancarlo. But I defer to you on that and legal to give an official interpretation of that.
I'm amenable to just leaving it, but
Yeah.
might want to revisit it at some point.
Do you have an alternative proposal?
No, again, on the surface, at the 30,000-foot level, it doesn't appear the marijuana establishment is necessarily challenging the impact fee that they're being asked to pay. I'm worried about it on the other side for the community that's waiting potentially up to 8 months to get that payment. But I hear what Director Potvin's saying, so I'll mull on it for a while.
Okay, I would entertain a motion for a brief break, coming back at 4:07. I'll entertain that motion. Commissioner Camargo? Commissioner Roy? Commissioner Camargo votes. Commissioner Concepcion?
Aye.
Commissioner Roy?
Aye.
Commissioner Stebbins, chair votes aye. I will do my best to drink a little water and try to speed through this. There's really about 5 heavy duty pages, and then there's some, then obviously we get to that, but we may or may not get this all done today, but we anticipated that we might need tomorrow. All right. 4:03, I don't know. 4:07. I think Betsy is going to remove that. I mean, it's not a big deal. They can see where.
Tornado in New Hampshire.
Okay, the most important natural thing was the 3 whales reaching in sync. The greatest thing.
Wait, where was that?
Off of Peton yesterday. It's great. Gotta look it up.
Synchronized.
I know. Okay, so we are now moving on to B, prohibited practices. A host community shall not attempt to collect impact fees relating to any operations occurring prior to the date a marijuana establishment is granted a final license by the commission. A host community shall not attempt to collect impact fees from any marijuana establishment that has held a final license for more than 9 years. It sounded like someone had a question about that. Do we want to get to the 9 years issue?
Sure. Yeah,
Yes.
Okay.
Please.
as you know, this is not prospective costs, but what incurred costs. So you bill for the previous year and the following year. So when you get to year 8 as an operation, then you're billing for the previous year. And so once you've hit the 9 threshold, that's the last, looking in the rearview mirror, that's the last calendar year they can, or for final license, a renewal year, they can assess, charge, whatever fees, claim fees.
Thank you for that description. Any other questions or comments? Moving on. In circumstances where the licensed premises is the site of multiple final licenses, no host community may amplify its assessment of alleged impact fees by assigning the same impact fees to each final license operating from the licensed premises without regard to the distinct operations of each licensed entity. I think we understand what that is. Moving on, no host community may include additional payments or obligations in its invoice of alleged impact fees, including but not limited to monetary payments, in-kind contributions, and charitable organizations by a marijuana establishment to a host community or any other organizations. We don't have any questions about that. A host community shall not include any legal cost incurred by a host community to defend against a lawsuit brought by a marijuana establishment in its invoice of alleged impact fees. Again, clear. 6, no host community may modify the effective date of a pre-existing community impact fee for any final license that becomes subject of an ownership or control change under 935 CMR 500.104 subsection 1. Section C, commission review and certification of CIFs. The commission, through its executive director, shall review a host community's invoice of alleged impact fees and make a determination certifying in whole or in part the community impact fee that may be assessed for the preceding year of a marijuana establishment's operations based on a finding that an impact fee or fees is reasonably related to a marijuana establishment's operations.
Madam Chair,
Yes.
I think we have, in a similar area, we have, through its executive director or designee, or delegee. So I just want to make it consistent, unless that was not the intent here.
So should we add and his?
Or his delegate.
Yes. Commissioners Concepcion and Roy, are you?
I think that
Yes.
makes sense. Yes.
Okay, yes. Okay. You all set? Okay. 1, a marijuana establishment shall provide verification of its gross annual sales, including wholesale revenue generated by marijuana cultivators and marijuana product manufacturers, to the commission with its transmission of a host community's invoice of alleged impact fees. A marijuana establishment shall submit a summary of all sales of marijuana products, marijuana accessories, and marijuana establishment branded goods
for that license to consumers and other licensees as applicable. B, if product was wholesaled or otherwise sold or transferred to other licensees at no cost or reduced cost, a marijuana establishment shall apply the average cost per gram or milligram to the amount sold or transferred to establish and report the fair market value of the product and include that amount in its summary submission. Could somebody just walk me through this? I think I understand it, but
Sure. I'll raise my
please,
hand
thank
here.
you. Mm,
So this aligns, the reason why this provision is included in the draft is because by law, municipalities cannot charge a community impact fee beyond that 3% threshold. So we need to be able to, calculate and understand what that threshold is for each licensee. So this is to make sure that the impact fee being imposed does not go beyond that 3% limit.
And therefore, just to piggyback on that someone who's, let's say, co-located just isn't selling themselves for $1 or in deflating.
Oh, okay. Got it. That's what I meant. Okay, good. Any other questions on that section through this page? Hearing, seeing none, moving on to number 2. The commission may determine the gross annual sales of a marijuana establishment using the following factors. A, consumer sales as represented by a marijuana establishment. B, consumer sales as represented by the commission's seed sales system of record. C, fair market value of wholesaled or transferred marijuana products, marijuana accessories, and marijuana establishment branded goods. Any wholesale or transferred marijuana products, marijuana accessories, and marijuana establishment branded goods that have been refunded or is otherwise the subject of a voided sale. Okay. E, value of services rendered wholesaled or transferred marijuana products, marijuana accessories, and marijuana establishment branded goods as represented by the commission seed to sale system of record. And F, other factors as determined determined as necessary, determined and necessary. As, I think it's as, determined as. See, we're reading all this stuff, but we are finding stuff, so.
Yeah.
Okay, I this is so boring for everybody, but anyway. Okay, no, I just lost it. F.
Madam Chair, you could also just remove and it would read as determined necessary by the commission.
Thank you, okay.
Thank you, Counselor.
By the commission to calculate the gross annual sales by the licensee in the absence of available information as listed in the subdivision. 3, the commission may make a final determination on gross annual sales relying on factors in 935 CMR 500.180 subsection 4C2 and any additional information gathered. The gross annual sales determined by the commission pursuant to 935 CMR 500.180 subsection 4C2 shall be used for purposes of the CIF in circumstances where product was wholesaled or otherwise sold or transferred to other licensees at no cost or reduced cost, and shall not be used for any other purposes related to other obligations, including tax filings for a marijuana establishment. So that's the continuation of the language you were talking about. Okay. 4, the commission shall provide notice of its CIF determination to a marijuana establishment and a host community. The commission's notice will provide a marijuana establishment with the following options. A marijuana establishment may request an administrative hearing before an independent hearing officer of the commission pursuant to 935 CMR 500.500 to challenge the findings of fact and conclusions of law. Any administrative proceeding elected by a marijuana establishment must be conducted pursuant to 801 CMR 1.01, formal rules of adjudicatory practice and procedure. The host community may seek intervention as a party to the hearing, or B, a licensee may seek court intervention to independently review a host community's impact fees by bringing a breach of contract action against a host community in a court of competent jurisdiction. Are there any questions in that mouthful there? Hearing and seeing none, moving on to 5. The parties may elect to bring a dispute between the parties before a private mediator retained by the parties at any time if such mediation is a term of the HCA or is voluntarily elected by the parties. That
6, after a community impact fee dispute has resolved, a marijuana establishment must provide proof of payment of the certified CIF with its renewal application. All right, moving on to 5, waiver of host community agreements. A host community agreement may waive the regulatory requirement to have a compliant HCA by submitting an HCA waiver to the commission that complies with this subsection. B, an HCA waiver constitutes a total relinquishment of the requirement that an applicant or marijuana establishment enter into an HCA with a host community. No party to an HCA may use an HCA waiver to waive individual provisions of an HCA. An HCA waiver may be submitted relative to an application for licensure or an application for renewal of licensure. A host community and an applicant or marijuana establishment may submit an HCA waiver after both parties have executed an HCA. So I'm through C. I was just going to say, any questions? We've been,
Suggestion on that one?
yeah.
Where did I put it? Hold on.
I'm sure it's brilliant, so. Read it.
Yeah, I'll keep reading it out and I'll.
Okay.
look for it.
Okay. Are there any other questions at this point? Okay. Acceptance of an HCA waiver. You found it?
I found it.
Okay.
So, HCA waiver section, I had put an HCA waiver may be submitted relative to an application for licensure or an application for renewal of licensure, and a host community and an applicant or marijuana establishment may subsequently choose to submit an HCA waiver after both parties have executed HCA. I read it as they must have an executed HCA. Like I read it read awkward to me, like, the second sentence. A host community and an applicant or marijuana establishment may submit an HCA waiver after both parties have executed an HCA. So it sounds like you need to execute HCA before you can do a waiver, but that's not necessarily the case. You can do a waiver at any time, right? So this way it reads, it sounds like you need an HCA. The second sentence, it sounds like you need the HCA to be able to submit the waiver. Host community and an applicant or marijuana establishment may submit an HCA waiver after both parties have executed an HCA.
So you added a subsequent to.
Yes.
Say that again. I just want to make sure these guys have
Yep.
it.
So as it reads,
I just want to make sure you guys are.
a
Okay,
host
sorry.
community and an applicant or marijuana establishment may submit an HCA waiver after both parties have executed an HCA. That's how it reads now. So it sounds like you need the HCA. I'm proposing that you can put, where'd my notes go? Where'd my notes go? I'm losing it. Okay, subsequently choose to. I'm proposing to add subsequently choose to submit an HCA waiver after both parties have executed an HCA. Prior to or so way it reads now, it sounds like you have to have an HCA in place before you can do the waiver, and that's not necessarily the case.
It's clarifying in nature, the feedback.
Mhm.
I think it's, is it, I read the may is the language I'm dwelling on, which is it therefore it becomes an option, but to your point, if that clarifies the intent, I think that's.
Okay. Everybody good with that?
Well, I was saying, I mean, or do you just delete after both parties have executed an HCA? Am I?
Yeah.
If you
can
just,
get that rid-
yeah, if you delete after both parties have executed an HCA, does that work? Or am I missing something?
It sounds like host relationship has already been established, then you can
Mhm.
go back and have a waiver, right?
So I just want to ask, if that's deleted, does that, Attorney Carter, does that? Well, I just want to say, if we delete after both parties have executed an HCA, which implies that it must be after, well, it says may, but after both parties have, we're not requiring it to be after an HCA. So do we just take that out? That last part of the sentence?
Well, after both parties have executed, strike
I
that.
would, I would invite Director Potvin to join us. Get his hand up.
So thank you, Andrew. Thank you, Madam Chair. There's, as far as a process, as far as different permutations of a process with the Chapter 180 and the fact that that HCA waiver is enshrined and codified in such, there's different ways that this could go. So for, at least from my perspective, there is a situation in which an applicant could go to a municipality and the municipality says, hey, we're going to waive this HCA requirement, we'll execute this waiver. There's a situation in which there's an existing licensee that is going through the renewal process, or maybe has come across in the situation that we discussed earlier, that we have found some deficiencies in the existing HCA, where then the licensee and the host community come to a conclusion, let's just waive this. Let's just come to terms on this. So I would be careful about the terminology, especially about the mays and the shalls and the nots, and say, but to Commissioner Roy's point is, yeah, you could spell it out. Once an HCA is executed, the parties may choose to elect to have an HCA waiver. Before an HCA is in existence, the parties may elect to use the HCA waiver process so that you can encompass the majority of the different permutations.
Right.
Please let me know if that was clear and if you have any questions.
So do you agree with striking that final few words?
Yeah, Kyle, if we strike after both parties have executed an HCA, then it doesn't mean that that's
Then
the
it-
only instance that
Then
we're
it can
talking
apply to
about.
all those permutations.
Let me, if Madam Chair, let me invite Enforcement Counsel as she has her hand raised and she is.
Attorney Lopez.
Hi there.
Slam dunk here, yeah.
Me.
So I guess when we're talking about this section, if we take out after both parties have executed an HCA, then we're not clearly conveying to the parties that they have that option to submit the HCA waiver after the license application has been submitted. If there's, if they decide that they want to waive at some other point. So I just, if that's the objective, if that's what you want to do, of course you can do that, but just want to make clear that right now it's offering that option. Taking it away, it leaves kind of that open question of can I not? So that would be my thought there.
I think this needs to be reframed. Sorry, Commissioner Stebbins, I don't mean to jump in. Go ahead.
No, I apologize. I didn't put my hand up. I like the new language you added. I like leaving in after both parties have executed HCA because it just gives both the community and any licensee or applicant an option.
Okay.
But
think that was
what
to
about the
Rebecca's
other
point.
permutations Kyle mentioned? We're silent on those.
It's implying that you have to have an executed HCA.
It is implying and you don't necessarily have to because there's waivers you can do prior.
Right.
So it's implying you have to have that.
So, Madam Chair, if I may.
Please go.
So again, to kind of statutory interpretation of what we're talking about here is to the point of a host community and an applicant or marijuana establishment. So we're talking about applicants and licensees may submit an HCA waiver after both parties have executed an HCA. I guess in context, and again, defer to legal, the concept of an HCA waiver is a new introduced concept through Chapter 180.
Mm-hmm.
Prior to Chapter 180, there was no concept of HCA waivers. Essentially, the requirement was a marijuana establishment, MTC, needed to have an HCA to operate and to continue to operate. So I guess the assumption that maybe the working group was coming from that at this point is that every operational MTC has an active has a active HCA. And therefore, if that naturally leads to, if the municipality and the applicant or licensed future applicant and current licensee decides maybe the current HCA doesn't comply with your current policies, let's just waive it. But the May concept is the thing that I think is essential, where it's optional. I think it does give some latitude to the commission, the executive director, and ultimately to staff to interpret that policy determination, which Commissioner Roy, I think, is where you're going.
What if we put the word even after both parties have? That's what we're trying to say.
Or including?
Including, so it's implying there are other situations. Including after both parties have executed an HCA?
They submit an HCA waiver even after both parties have executed the HCA. Subsequently choose to submit is what I had said.
What is it? Just say, can you say it again? So these.
Well, I had proposed to subsequently choose, which is May, I guess you could say that's May. They subsequently choose to submit an HCA waiver after both parties have executed.
Would it be helpful to suggest some language? A host community and an applicant or a licensed applicant or marijuana establishment may submit an HCA waiver relative to an application for licensure, an application for renewal of licensure, or after both parties have executed an HCA.
That sounded super confusing to me, but
You thought so? Sort of 1, 2, 3.
Application
Yeah.
relative.
Well, you could also just add in also, kind of to what Andrew's kind of creating that flow there. You could say a host community and an applicant or marijuana establishment may also submit an HCA waiver after both parties have executed an HCA.
Yes.
Okay, that was what Commissioner Roy had suggested also is probably a better word.
Yes.
Okay, so put in
They
also
yeah.
submit. All right, moving on. Acceptance D, acceptance of an HCA waiver is limited to the specific application or license number or numbers stated in the HCA waiver request. The commission shall determine whether an HCA waiver complies with this subsection. An HCA waiver that sets an expiration date or any conditions is deemed non-compliant. An HCA waiver determined to be the result of an inducement is deemed non-compliant. H, if a host community elects to submit an HCA waiver, a host community's submission shall be in a form and manner determined by the commission and include at minimum the following information. 1, identification of the specific application or license number intended to be exempt from the requirement to have a compliant HCA. 2, identification of a licensee applicant. Licensee applicant or license applicant? License, okay, so license applicant or marijuana establishment in a manner consistent with both the business entity name certified and recorded with the Secretary of the Commonwealth of Massachusetts and the business entity name stated either in a license applicant's license application or in a marijuana establishment's license record as maintained by the commission. 3, printed name and signature of the individuals authorized to represent and act on behalf of the host committee. When you say printed, do you mean this needs to be a paper copy?
Printed and signature.
Okay. But when I see printed, I feel paper here, but am I wrong?
Not necessarily. There's a way to e-sign.
Yeah, okay, all right. printed name and signature of the individuals authorized to represent and act on behalf of an applicant or marijuana establishment. 5, the date of each party's signature, and 6, an attestation that the HCA waiver was mutually agreed upon by both parties and executed in good faith. And then Romanet, I don't have 2, looks like, is that H, are there 2?
Oh, it's an I and a J.
Oh, I can't see that. Okay, great. Sorry. It's my vision. I, an HCA waiver must be signed in the presence of a notary of the Commonwealth. J, an HCA waiver that is executed and recorded with the commission remains in full force and effect until such time as it is rescinded. An HCA waiver may only be rescinded on commission approval of an HCA subsequently executed and submitted by the parties. And then K, an HCA waiver is not subject to review under the criteria in 935 CMR 500.850 regarding general waivers. Can I just raise the question again, in the presence of a notary, because we do have e-sign and DocuSign and you know what I mean? I do worry a little bit about in the presence of a notary, and I'm wondering if there's any more post-COVID modern language that implies, and again, I don't know if we want to do that, because I know that I've like had battles and other things that I was looking at around voting, you know, around wet signatures, and I don't know how, whether we, you know, can do this.
I know there were certain accommodations made during COVID by the
Right.
Secretary, the
Mhm.
Commonwealth relatives and things, so I don't know what, if any of those have been preserved in either.
I thought they were, well, can I just ask the team to explore that? Because if we can, the less time consuming we can make this, the better. So if there is still, I think that the bar association, I don't know, but I do think that there was something done that you don't have to be, quote, in the presence of a notary in their ways. Yeah,
Yeah, maybe presence has been broader defined.
or just say notarized.
Yes, or that was the other thing, is the document needs to be notarized, and
Yeah.
whatever the governing rules are, I think that.
Can I make that suggestion? And I don't know if anybody, Commissioner Concepcion, if you have any issues with that, the only reason I say that is that I just want to make sure that we're not putting an additional burden here, and that if there is modern post-COVID state of the art, that they can do it, that we allow it.
So it will read, an HCA waiver must be notarized.
No.
And then do you want in the Commonwealth? Because that is also something. I'm just thinking, I don't know. if
Yeah,
maybe Republicans-
Yeah, I would. We want it to be the Commonwealth because we don't want someone in Utah telling us what to do.
Yeah.
Sorry, Utah.
And we will leave it there.
Do we agree that notarized in the Commonwealth? No, you know, the other thing is, do we just take out in the presence of?
Yes, so,
They have to be.
yeah, I think.
I mean, notaries are all over the place. But
Um.
we're saying it has to be a Massachusetts notary.
I think we should strike that and just say it's notarized in the Commonwealth.
Okay,
An HCA waiver must be notarized in the Commonwealth.
Can I ask the question, why are we asking it to be notarized? I'm looking at when in an application that a host community and a licensee certify that their certification form is notarized. We don't ask for it to be notarized. I'm just wondering what the reason for that might be.
is because it's well, is it because this is sort of outside the normal course, or we're providing, I mean, I don't know if it does need to be
The
notarized.
authors of the,
Right.
maybe the drafters of the language would have some thoughts.
I just put that line in.
Yeah, why does this have to be notarized?
I mean, I didn't add that one. So, I mean, he.
Commissioners, I'll just say that it doesn't have to be notarized. That's for all of you to decide. So
All right, can I move that we don't notarize? Okay, strike it. Oh, that felt so good. So the next time we read through this.
We're gonna do it again.
No, I'm kidding, I'm kidding.
Just go like.
No.
Wait,
Well,
strike it though.
Okay,
Commissioner, tell us.
Well, why would something have to be notarized? Provide legal protection, have your documents notarized can help prevent contract disputes and litigation. Elevate the credibility of the document. Many documents are not legally binding unless they have been notarized.
Is it something we've done in the past, or we do it for any document?
We have to notarize some things, but not everything.
Maybe tell us if we do any of that.
Yeah, Kyle, if you could, what do we notarize now and what don't we notarize?
Kyle,
So, go ahead, Andrew.
I believe it's my recollection that in the early days, waiver requests had to be notarized. And then I do believe we removed that requirement.
So Andrew is correct, and it does extend to certain very limited documents. But I say this as to you as policymakers, is initially as we were sodding the foundation of this agency and making sure our T's were crossed and our I's were dotted, there was an element of notarization that the reason why it exists is that there's some type of solidarity and confidence behind the fact that the person who's signing it is the person who's signing it. Also, at the same point, we endeavor to be a 21st century agent, 21st century state agency. And that essentially is up to you as policymakers, whether that's a policy that you want to adopt. I don't think it's not necessary. And the absence of the security blanket of the notary, if for some reason it comes to our attention, especially speaking from an investigations and enforcement perspective, if we're notified that it's not possibly official, we will take the necessary steps pursuant to current process to investigate it.
But again,
it's you as policymakers, whether you want that to be a policy.
But can you just give me, what do applicants have to notarize now in the application process? Are there many things?
So as of right now, as currently, to the best of my understanding, one of the things that is required to be notarized is regarding agent registration, where it comes to their attestation. And again, that has a legal connotation to it. Their attestation not to divert marijuana, which is a requirement under your policies, but also at the same time to state their limitations on their ability to operate within their marijuana establishment. There's also, based on commission policy, the background check element, where somebody who is associated with a marijuana establishment under a license that has to have a background check within 30 days, but then may apply for the licensee at a different location, not to overly burdensome the licensee to run another background check. That waiver request also requires an attestation as of now.
Yeah, but in what I'm hearing, so these are all sort of individuals ascertaining a very high level of understood behavior and compliance. Here we have a contract where you have two parties, right? And you can't just have one party sign it. It's going to have to, you know what I mean? I mean, there's almost like a check and balance in the fact that it's a two-party document. Does that make sense or does that not make sense? Because I'm saying here the notarization is I am guaranteeing I am who I am. I'm guaranteeing I've done what I've done. There's nobody on the other side going, whoa, wait a minute. We are doing that because it's an individual making a super duper promise to us. And here it's just, are the terms of this agreement mutually agreed to? And so that could be self-policed fairly quickly by law.
Chair, just to
Please, yeah. If I'm
maybe
wrong, I mean,
for a
yeah.
clarification purpose, a notary public is not going to certify, they're not a lawyer necessarily.
Mhm.
They're not certifying the terms of the document. They're
Right.
certifying the person who's signing it, and by visual identification of their legitimate government ID, that they are in fact the person who's signing it. But they're not qualifying the terms and whether it's compliant with the law.
No, I understand. But my point is that I feel, well, again, I don't think we need it to be notarized, but I will defer, if you're more comfortable having notarized, I just want to make sure that the language makes this as non-burdensome as possible. And do we require a notary for the initial HCA or just the waiver?
I would have to go back and look, but
No, but I'm just saying, so we don't ask for it for,
We don't,
so
Sean, do you have perspective?
well, we'll get it now.
Sean?
he says he doesn't think that we require notarization of an original HCA. So what do you want to do, madam?
Well, I'm just trying to protect the little guy that can't afford them. I mean, I know that notary's not a lawyer. I'm just saying,
But the notary is not going to protect the little guy.
well, okay, so I hope we never have a situation that says, well, I didn't sign that. My name was forged. This isn't me.
No, but we don't do it with an HCA, so should we be doing this for an HCA, an original host community agreement? Not being,
But what do we,
well, we don't.
I didn't see that language in the HCA context. Outside of the waiver.
As I was saying, I'm just trying to figure out, is the waiver,
Oh, I
does
see
the
what you're
waiver
saying.
have a heightened kind of interest? The problem is the little guy. The little guy's still gonna have to have a lawyer look at, you know what I mean? And this is fairly, I think, easily discoverable when all of a sudden someone's gotta go, wait a minute, I didn't sign that. And I don't see the municipalities forging someone's signature. You know, maybe you have an errant. I don't know.
I think you have to look at what is the incentive to forge? in
Yeah.
this instance. It would most likely, it could be on the licensee's part to say the municipality's waived it
Mhm.
here.
Yeah.
Said Joe Smith, Jane Smith. Otherwise, because I've looked through the regulations, the only place we require a notary by regulation is on the core acknowledgement form, background check purposes.
Yeah.
And that's going to be, I think, to the discussion here, the utility and the value of having that certified as being that person signing it and releasing that information to us, I think is valuable. In the context of a waiver, it seems perhaps unduly burdensome. However, and I think it might limit our ability to achieve it or get it through electronic means. Given that,
okay.
I just looked up as well, those virtual notarization process expired in actual July of 2020.
Oh, okay.
Okay.
So that can no longer be done
Okay.
virtually.
I'm good.
Okay, so what do you think, man? You okay? So is there a consensus that we don't need to notarize the waivers? All right, keep going. I've already went through J and I already went through K. Okay.
Yes.
All right, good work. And I truly applaud the work of this group. You had the hardest job. Oh my God, my head's spinning. Anyway.
Nice
Yeah.
job.
Good job.
Okay, all right, moving on. 500.181 minimum, sorry.
Can I interrupt you? Just a quick kind of time check. It's 4:43, so I guess there's some questions running around in our chat. There's a thunderstorm on the way. Not that I don't know if it matters for anybody, but also how long do we allowed to go for today? What do you
Oh.
want to do?
I would, let's see, we sort of have
2 subjects left.
2 subjects left and I'm hoping, I mean, could we go till 5 o'clock and see how far we get? That's what I would, yeah, if we could,
Curious, I don't know.
if people
Yeah,
would
just-
with that.
Yep. I just appreciate somebody sent us a link saying that bad weather was about to roll through, but
Oh, really? People wanted to know because I just had some folks here who will have to leave. And I think that scrum will get pushed anyways.
that's what I'm saying.
Well, rain is expected in 10 minutes.
Yeah, no, it
So,
doesn't matter.
Oh,
Just
yeah.
checking. I'm not in a rush for this in case.
okay,
And you guys,
Tomorrow's virtual, right?
yeah, but can we maybe get till 5?
Just, you want to start fresh tomorrow?
Well, I will be fresh, no matter what, tomorrow. But I'm just wondering if we could just go for another 10 minutes and just see where we go, because I really don't want us to be going. I mean, I will tell you, I have to leave, I have to leave tomorrow. I'm getting on a plane. And so I just want to make sure that
What's
I,
our time limit tomorrow?
I probably have to be done by, I don't know, 2 o'clock, maybe 1:45.
And we're starting at 10.
Yeah,
We can't start at 9, right? It's too late to start at 9.
yeah, we already noticed it. So that's what I'm just saying. If we can just get through here, and I don't know if anybody
I don't
else.
have a lot for this section, so I'm
Yeah.
open to.
Let's just, if we just try to, if we could just go till 5 o'clock and just see how far we get, okay? Minimum acceptable equity standards governing municipalities and host communities. 1, this section is governed by Mass General Law 94G subsections 3 and 4 as amended by statute 2022, chapter 180. Pursuant to Mass General Law 94G section 3, the commission must establish minimum acceptable standards for host communities to promote and encourage full participation in the regulated marijuana industry by people from communities that were disproportionately harmed by marijuana prohibition and enforcement, and to positively impact those communities. Excuse me. So 2, Mass General Law, Chapter 90. Oh, sorry, go ahead.
And I know Commissioner Concepcion and yourself were part of this, and you guys have all the team for this. I just want to say thank you. But within that first section, I don't have the specific 100% of the language, but also just, I'm curious if we can possibly either build it out a little more or even be more straightforward. I kind of just wrote something: municipalities may meet the mandate, statute, or minimum accepted equity standards if it adopts an ordinance or bylaw to exclusively license social equity businesses for 3 years or until 50% of operating cannabis business who come from social equity businesses. So I'm curious if in that opening statement, it seems like there's still some space or there's some things missing. So I kind of just put this together. So I don't know.
I think this was taken from the.
Yeah, no, I know it was taken. Yeah, I know. But I'm bringing it up in terms of, if there's.
Commissioner
if you-
Camargo,
Yeah.
sorry, Madam Chairwoman.
Oh, go ahead.
I just wonder if you can repeat that again, because you're offering new language to this section, and I just want to make sure I understand it
Yep.
correctly. So do you mind restating it?
Yep. So I was thinking just adding to that. I know that this was taken from it, but maybe something, to sort of allow the municipalities or reader to kind of just see something a little bit more straightforward. Municipalities may meet the mandate or statute, I don't know, of minimum acceptance equity standards if it adopts an ordinance or bylaw, either or, to exclusively license social equity businesses for 3 years or until 50% of the operating cannabis business come from social equity business. Again, it's an example.
But can I tell you?
Yeah.
That to require exclusive, that is something that we considered and.
Yeah, tell us, yeah.
Yeah, and determined that not all communities could
Yeah.
manage something like that.
Mhm.
And so I, for instance, smaller, more rural, suburban, maybe people don't want to drive 50 miles, who come from a disproportionately impacted area because we have such broad distances between those two areas. So I would ask that, putting a pin in that, if you want to share the language, but when that's a pretty significant mandate that we're going to be putting on a lot of communities. And this is the conversation that we had before. If we were starting at the very beginning, this is probably where we would have been, right?
Oh, 5 years ago.
Yeah. And, this is, I believe, what they've done in Cambridge, right?
Yes, Cambridge, Boston has the
right,
one-to-one.
Right. So we did take a look at this. We did have an understanding, again, because, in particular, because of the disproportionately impacted areas, that this could put some additional burdens on some municipalities that are more rural, more further flung. And so that was the reason that we decided not to put that in. So if you would like to, and I would suggest you share that language, when we come back, we can, pull it apart, but it goes beyond the sort of broad description here.
I hear you. And I think what I'm saying as well, and I will share this, but I think as well as we can be a little bit more, and I know this was taken right out of the language and the statute, but I'm just curious if there's still space to add something there that's very straightforward.
Well, I think it's
Can I
straightforward.
opine?
It's just you're adding an additional, sorry. Go ahead.
I just
Commissioner
wanted to,
Concepcion.
so if I'm understanding this correctly, Commissioner Camargo, you want to include a presumption and like
Yeah,
an optional presumption that if a municipality does this, then the minimum requirements are satisfied?
right, right. And I guess, yes, correct. But also like, did you guys think about it? Did you guys, maybe elaborate a little bit? Because I think, yes, you're absolutely correct. Yeah, because there's ways to do it, right? And I know that it's some of it is in here, but I'm just, again, putting it out there.
I think, so what you're suggesting is a little bit separate from what we contemplated. So that's why I'm like, I'm open to that because it's not a mandatory reg. It's a presumptive determination based on that satisfaction that you're offering. But I would like to see the language too, but I hear what you're saying.
Yeah, and I mean, and I know that we do have towns like Cambridge, like Boston. So I mean, obviously, in some cities and towns, the 1-to-1 may not work for cities and towns, and it may be too late, right? But again, it's still an option. So part of me is like,
So if I
It is-
could just, if you
yeah.
could share the language,
Mhm.
because I feel like I need to get my head wrapped around it, and I would like us to get as far as we can before 5 o'clock, because we will revisit this. So if you could share that language with all of us, because again, I have been in our group, I'm the voice of the sort of little far-flung,
Sure, sure.
non-DIA communities
Sure.
that, again, like my hometown of Whitman, that initially did not allow cannabis to come in, and it may or may not be attractive, practical, whatever. So I just want to make sure that we're not creating some problems for some of those smaller, more rural or suburban.
Yeah, no, and
communities.
I don't want to see that problem either. I think it's just more, when I read this, I felt like there was still space here to sort of add something that's very forward or presumption, Commissioner Concepcion, like you said, and yeah, maybe it's not the 3-year, but maybe it's, so that cities and towns, when they read this, it's a little bit more than just the legislative language. I mean, we are talking about equity and municipality. This section of the regs is a big deal.
Oh, yeah.
It's a little late in the game,
Mhm.
but it's a big deal. So,
Yeah, so
I'll
if you
add
could
that.
share that, we'll take a look at that and we'll
Yeah.
get back to that.
And I think it's not just the language, it's also the concept. So, but I'll share it.
Okay, all right, thank you. 2, Mass General Law, Chapter 94G, Sections 4A, and I'm going to say Romanettes because I don't know what those numbers are, 11, 12, or no, 31 and 32. Empowers the commission to establish procedures for municipalities to promote and encourage full participation in the regulated marijuana industry during negotiations of HCA's and social equity businesses, and to develop minimum acceptable standards governing HCA negotiations with social equity businesses. The commission is further authorized to develop best practices for HCA negotiations between municipalities and licensed applicants that have been designated as social equity program participants or economic empowerment priority applicants. And none of the conversations we had before is going to overlap on this. So any questions or comments? Hearing none. 3, equity standards for host communities to promote and encourage full participation in the regulated marijuana industry. A host community shall adopt the following transparent practices to promote and encourage full equity participation. 1, a host community shall publicize certain information in a conspicuous location at its offices and on its website, which shall at minimum include all required steps of a host community's local approval process, including but not limited to all associated fees, deadlines, and meeting schedules for local bodies involved in the local approval process. B, identification of key individuals involved in a host community's local approval process, including but not limited to their name, title, business address, and business contact information such as email address or phone number. C, a list of all documentation required by a host community's local approval process in downloadable form and paper form. D, identification of application criteria for local approval to operate a marijuana establishment and scoring methodologies relied on by a host community. E, general scoring information for all applicants and a host community scoring of each individual applicant. F, a host community's explanation in narrative form of its reasoning for the approval or denial of an application. And G, any other information required by the commission. Does anyone have any comments? Yes, go ahead, Commissioner
There's
Stebbins.
2 just quick suggested edits. Under A, it might be appropriate to also include all appropriate zoning information. And then in A, to kind of kick it off, host community shall adopt, but not be limited to the following transparent practices to promote and encourage full.
Wait a minute, can you tell me where because we had zoning in here and I don't know what happened to it.
I had that question as
Yeah.
well.
No, we literally had zoning in here and I don't know where that is now. Okay.
Was it part of the guidance that was issued from municipalities?
memo, yeah, but we-
Out of that June date?
Well, I think we do need to, so where should we, but not including two deadlines, meetings such as for local bodies included in local HCA approval. I remember the sentence, involved in the local HCA approval process and zoning or something like that. Zoning and local HCA approval process.
Yes,
Yeah.
so local approval process. Oh, go ahead, Rebecca.
Go ahead.
Counselor
I
Levin.
was just gonna respond, Madam Chair, that there is a zoning provision in section 4B. A host community may waive or reduce fees for an equity party to an HCA negotiation, including but not limited to CIF's zoning and occupancy fees. So I don't
But-
know if that's what you were
But
referring
no,
to.
but this was, what we wanted to do was to create transparency because again, our Peyton Schubrick example, one of the things she said is, I was young, I didn't have a lot of money. I didn't know who I should talk to. And it's understanding the ebb and flow of both who makes the decisions about HCA's, but as important, because that's as complex, who is responsible for zoning? Who do you have to talk to? How often do they meet? When do they meet?
Where is it?
That's what I'm saying is that.
What part of the city or town am I eligible to open my doors in?
Yeah, but that's, I'm looking at this and going, wait a minute, I thought we had this in
One of the
here.
questions I
maybe.
had, because I didn't see it.
Go ahead.
Same.
Commissioner
We definitely
Concepcion.
contemplated this, and I wasn't under the impression as well that it was included, but I guess we can sort of come to a conclusion here by saying, we agree, Commissioner Stebbins, that it should also indicate that this applies to zoning as well.
Yeah. And again, my problem is that I wrote the memo, and so I knew what that said, and I was less, the other group got more into the details here, and so I probably just imbued it in there.
Does it sound like we want to add a zoning?
Yeah.
So, local approval process is a defined term. So then if we go to the corresponding section, where we are now, all required steps of a host community local approval process. So that really should be capitalized because it's a defined term.
Mhm.
And the defined term also encaptures permitting. So we could insert it, but then it would be redundant. So my thought would be if local approval process is a defined term, let's get the definition right where we want it, and then we just insert it everywhere, and then we're not
Okay.
having a.
That
lot of
makes
kind of-
sense.
Yeah.
Wait a minute, it's approved, it's in there already. So, Andrew, it is, the definition for local approval process has been revised to include zoning.
That's where I saw it. I knew I saw it. Yeah. No, I knew we'd written it. And that's what I'm saying. It's like you see this so many times. So it
You
is,
did.
so we are hitting 5 o'clock. If you would, we don't have a lot more, but we're not going to get through all this.
And just to go back to 3A, suggesting language that say shall adopt the following transparent practices, but I'd like for it to say shall adopt but not be limited to the following transparent practices to give some municipalities some
Creativity.
flexibility and creativity.
I had a follow-up question or comment to the zoning piece, and maybe this is for tomorrow, but
Mhm.
it would be good to just hear what conversations you all had around zoning and, was there any conversation around too restrictive zonings, obviously for.
We can't get into that. That is not us. That's a local issue. We can't tell them how to zone,
No,
and this is an issue.
Yep, I know
And
that.
we know that this is being talked about outside.
Okay.
And I had a conversation with Sean about this, last week. We can't tell a community how to zone.
Right, yeah.
And even if it's restrictive, even if, you know what I mean, the statute says that, but then they have a right to sue.
Mhm.
And people are
Mhm.
suing because certain municipalities, appear to have overly restricted zoning laws. But the
Got it.
problem is we can't tell them.
We tell them not to zone 500 feet. School.
Right,
Yeah.
right. Okay, that's helpful.
By
But,
law.
yeah. So, okay.
So even,
So,
I'm just gonna say this comment out loud because it's part of my notes, but just And the reason I ask, and I hear you in terms that you can't talk about it, but it's just, you know, some of the zoning in some of these cities are inequitable.
Yeah.
And I know it's a situation. I've heard of operators, you know, going through the process and then not being told, oh, you can't go there. However, they've already gotten the building, they've been sitting on, you know, so.
But this is
Yeah.
part of the transparency in zoning. It's making sure
Yeah.
that all zoning regulations, because we'd even, I mean, again, I can remember, we talked about zoning overlays and things like
Right.
that. So I got to go back and look at that
Yeah.
definition again to,
Yeah.
I think we were satisfied with it, but zoning is a big issue.
Yeah.
We can't tell a community
just-
how to
yeah.
zone, but we
Yeah,
can
yeah.
make sure that people understand what the zoning rules.
Just remember that you, and this happens to all of us because we're in working committees, but this is the first time that I'm allowed to talk to you guys about it. So you guys have a lot in your head and
Yeah.
you've gone through this for
Yeah.
many months, but this is the first time.
No,
So
but
for me, I'm just kind of, I
No,
know
no,
I'm
you
putting it out
raised
there.
it, no, you
Yeah.
raised a very good point. One about a thing that we actually did discuss, but practically speaking,
Yeah,
we
yeah.
didn't think that we couldn't address that.
Yeah,
And then two, this is just one of those things, I've read this so many different times.
I
that
know.
I'm in.
Likewise, I know.
Okay, so, with that, we, will be coming back 9 o'clock remotely. Sorry, folks, that we're gonna, do you have any?
10 o'clock.
10
10 o'clock, I'm sorry, we can't because we didn't.
10 to 2 then tomorrow?
Hopefully less than that, but yeah.
What happens in the case that we're not done tomorrow?
If we're not done tomorrow, I unfortunately, I gotta get on the road. I have,
Yeah, no, it's fine.
and so,
I'm just
we
thinking,
don't have-
I'm planning ahead a little bit.
yeah,
just
no,
thinking
but we
because-
don't have anything on Monday.
Commissioner Stebbins.
Well, let's contemplate that. Well, no, because we'd have to notice, we'd have to notice. No, we'd have to notice, so we couldn't do it.
I mean, Madam Chair, 3 affirmative votes carry. So even if you had to leave the meeting
Yeah.
early, you could
Yeah.
designate someone else a chair.
Yeah,
and-
no, that's, yeah, no, absolutely. I mean, I would just,
That's all.
it would, yeah.
that's-
But we also, we're gonna be able to get through, I think, this. I don't think we're, and we've taken a lot of time today, so.
We've done 3/4 of the packet, more than that,
Way more than that.
way more than that.
Okay. So, Mr. Director, do you have any comments that you'd like to make? Okay. Are you gonna be making any announcement today? Okay. When will you be making your announcement?
After I have adequate discussions with your colleagues.
Okay, all right, sounds good. Okay. With that, I will entertain a motion to adjourn to tomorrow at 10 o'clock in the morning.
So moved.
All right. Take a call of the roll. Commissioner Camargo.
Yeah, and before I do, I just want to make a few comments. I just want to thank staff for getting us here, commissioners who put this together. Sean, thank you so much. I know we've been sort of back and forth with you on this process. Mercedes, Andrew, thank you for being here. And Rebecca, Lopez, Kyle, you guys really showed out today. I know I'm going to make my vote, but I got to make my comments. This is
I know,
important to me
I know,
because these
I know.
folks are busting their behinds for us to get this through. So I just want to say thank you.
We're not done yet.
I
I'm
know,
going to thank them tomorrow.
I want to thank them today.
Okay,
Aye.
all right. All right, are you good?
Yes,
Everybody
ma'am.
good?
Yes,
All right,
ma'am. It's important to me.
all right. Commissioner Camargo,
Aye.
Commissioner Concepcion,
I also want to make a comment before my vote.
please.
Earlier
please,
today, I
please.
made a comment about Director Potvin and Rebecca Lopez, who were not on the Municipal Equity Working Group, but they did contribute in a substantial way. So I want to thank them
Thank you.
again and just correct the statement I made earlier. Aye.
Thank you. Commissioner Roy?
Thank you, everyone. Director Potvin, Council Lopez, thank you for your valuable contributions.
Aye. Commissioner Stebbins?
Thank you, everybody. Aye.
Thank you. And again, I thank everyone as well, but I heard earlier, we're worried about the storm, so I just want to get people out. Oh, okay. I thought you were one of the people who worried about the storm. So, all right, thank you. All right.
It's important, it's important.
From here, right?